Hey yo, peace fam. Welcome back to Flesh of the Gods. Today, we're watching the final act of this staged courtroom. The civil trial against Cardi B is reaching its dramatic conclusion. Today, we're not just watching testimony, we're watching closing arguments and possibly even a verdict. Emani claims she deserves a bag because Cardi B assaulted her, used racial slurs, spit on her, and scratched her face with her long 3-inch fingernails. And she talking about 24 M's. Well, at least according to Cardi B's testimony, it's a $24 million lawsuit. Cardi B's testimony was a direct counterpoint to the claims of former security guard Emani Ellis. We also heard from the receptionist who testified that Ellis was the one who was aggressive and was never actually touched by Cardi B. Today, it all comes down to this. The plaintiff's legal team will give their final pitch, trying to convince the jury that the assault was real and the damages are deserved. Then, Cardi B's lawyer will have their final say, trying to slam the door shut on a lawsuit they've called a desperate attempt for a cash grab. After that, the jury will be in deliberation, and the verdict could come down at any moment. Will the truth win in the end, or will the system be used to reward a performance? I guess we shall see. Stay vigilant, stay fresh, and stay blessed, family. Now let's get to it.
When Tiara Malcolm came outside, how did she get between the two of you if you were chest to chest?
She literally, she was like, "What are you guys doing? What's going on? What's going on?" And then she was like, "This just hit me. This just hit me. I'm about to f her up." And I'm just like, I was so confused because it's like, no, I didn't. Like, I didn't hit you. And then that's when like Finky came out, and he's like, what's going on? Go to my office. So I just like went to his office and stuff like that. Like, that's it. It's done.
Right, but you testified that Tiara Malcolm at some point was in between the two of you. Right?
Yes.
Yeah. You got a hamburger bun with a hamburger.
Yeah.
She was the hamburger, and the two of you were the buns, correct?
Yeah.
Right. How did the hamburger get inside the bun?
I'm not sure if I gave her space or one of us gave her space. She wasn't like really like in. She was just like, "What are you guys doing? What is this?" And then she just got in the middle because she just was like going crazy. I don't know where she just turned up like.
And you just testified now that Emani Ellis was yelling that you hit her, right?
Yes.
She was saying that. And you didn't hit her.
No.
Did you take a swing at her?
No.
When Miss Tiara Woods was in between the two of you, did you try to take a swing over Miss Tiara Woods?
No.
How tall are you?
So I don't know who Tiara Woods is, but
Tiara Malcolm, I apologize. Tiara Malcolm.
do we have a question?
How tall are you?
What was the question?
How tall are you?
How tall I am?
Yeah.
5'3".
Okay, how about on that date of the incident when you had your shoes on? Were they flat?
My bad, family. I have to hit my mic button. But they still setting up right now, so we gonna run over some of the past things that happened and catch up with some of the stuff that happened last week during the trial. Today they should be in closing arguments, so they probably getting set up for that. They should be starting soon, but of course they always late. But we'll see. Let's get it, family. Appreciate y'all being here. Don't forget to hit that like button, hit that subscribe, tap in, share with a friend. Let's get it.
Were they heels? What was it?
Slightly flats.
So, and do you know how tall Miss Emani Ellis is?
No.
When you were standing face to face, were your eyes like the same level, or did she look taller? Did she look shorter? What is your recollection?
We was face to face, so she's practically like my height, or just much taller, but she was practically my height. But she is like
What? Say it.
Security heavy.
What does security heavy mean? Just tell us. There's no harm. What does that mean?
Like she just looks a little like she could protect the building type big. You know what I'm saying? She just
Right.
looked more developed than me.
And aren't security guards to be more developed than you?
Assisting.
Welcome to Flesh of the God.
Well, isn't this a nice surprise?
Good afternoon. Miss Almanzar. Do you prefer I call you Miss Almanzar, Cardi B, or it doesn't matter?
I mean, y'all been calling me Cardi B.
A girl have beef with me, she gonna have beef with me forever. Hey America, what's poppin'? My name is Cardi B. You might know me as that annoying dancer on social media that be talking hella crazy.
I want to do a little role play.
Okay.
I want you guys to
What's so funny? Young muggle in the making.
about yourself. You're not just Cardi B from the...
Hello there. My name is Cardi B, and I am from the Bronx.
Was it facing you or was it facing Miss Ellis?
The camera was facing me. When I got off the elevator, her phone was here. Then when I was walking and she was behind me, and then she said, "Oh my God, y'all, Cardi B, Cardi B." I looked back and the camera was like right there.
Oh my God, Cardi B, Cardi B, oh my God, oh. Heck nah. What up, Lady L? I see you. Appreciate you joining. Chan, my black is golden in the house. Shay in the house. What up, though? Brown sugar, babe. What up, though? I see y'all. Appreciate y'all being here.
Like practically on her chest type stuff. I'm like, yo, why are you recording me?
Okay. And you've seen, like, you know, police officers where they have a camera on the front of them. Have you ever seen that, where a police officer will have that?
I never seen that, but that was her phone, not a camera.
I understand, but I'm saying, have you ever seen a security officer, a police officer have a special camera on their chest which records what occurs in front of them?
Assisting.
I'm not saying she was recording you. I am asking you this question. If she was recording you, why does it matter?
Because she's a security guard and I'm going to a doctor's office. It definitely mattered.
You were causing a disturbance. Maybe
I
she
wasn't
wanted to
causing a
record you.
disturbance.
Time out. Let's not talk over each other, number one. Wait for him to finish
Sorry.
asking the question before you answer.
Do you own the building of 8920 Wilshire Boulevard?
No, I was walking to a doctor's office.
Do you agree that you were a guest in that building? You were
Yes.
a visitor, correct? Yes or no?
Yes.
Okay. When a security officer tells you to leave, are you supposed to leave?
Objection.
Yes or no?
Sustained, it's asked and answered. We covered this yesterday.
You were
Sustained, it's asked and answered. We covered this yesterday.
you were causing a disturbance in the building.
She started the disturbance.
Did you
I'm
also?
sorry, ma'am, if you hear an objection, please wait.
Oh, sorry.
Okay. What's wrong?
Do you remember yesterday you said that there was a verbal altercation between the two of you? You remember that?
Yes.
Okay. And an altercation is a fight, isn't it? It's a verbal fight. You had a verbal fight with her.
Asked and answered.
Yes or no?
Sustained.
You used the F word during that fight, didn't you?
Yes.
What other words did you use? Tell us in your own words what you said.
I said, get the out of my face. Why are you in my face? Why are you recording me? Ain't you supposed to be security?
Tell it to
Why
her
are
now.
you-
Go ahead. What other words did you use? Tell us in your own words what you said.
I said, get the out of my face. Why are you in my face? Why are you recording me? Ain't you supposed to be security?
Tell it to
Why
her
are
now.
you-
Go ahead.
Huh?
Say it again. Say it.
Objection, Your Honor.
You want me to say it to
I
her
want
face?
you to tell it to her face what you said on that day so she can hear it for
The
herself
objection
again.
is sustained.
Your Honor, do we have civility in the
Yeah.
courthouse?
Why don't we just take the temperature down a little bit? If you have factual questions to ask her, please do so. It's not a time to argue with her.
What were the words that you used when you got off the elevator to this security guard who is no longer a security guard at this time?
Objection. Argumentative and also covered yesterday.
It's been covered several times, so it's asked and answered. It's objection sustained.
What did you tell Emani Ellis yesterday?
Counsel, you need to move on.
What were you holding in your hand at the time when you got off the elevator?
Objection. Well, excuse me, argumentative.
Overruled.
Nothing, correct? You weren't holding anything, were you?
No.
You had both of your hands free to do whatever you wanted to do, correct? Yes or no?
Objection, relevance.
Overruled.
Yes or no?
Yes, yes.
Okay. And if you wanted to scratch or cut her face with your right hand or your left hand, if you wanted to do it, you could have done it, correct? So
But
you're
I
not
didn't.
disabled,
But
right?
I didn't because I had a baby.
Stupid. Hypothetically speaking, of course, you could have. It's not like asking you to fly or nothing like that. What up, what up, what up, Allie? I see you. Appreciate you joining. Kissing Pink in the building. What up, what up? Good morning, family.
How did she know?
Time out. Let's slow down the pace just a little bit before the opportunity to give objections and for the court reporter. What was the objection?
Argumentative, relevance.
Overruled.
And again, I would ask that counsel lower his voice. This isn't.
So, Your Honor, I was told yesterday that my voice was too low by others, so that's why it's a little bit higher today, so that everybody can hear what I could say, as well as the witness.
I think that there's a difference between volume and tone. I think the volume is fine, the tone is a little bit argumentative.
Thank you very much, Your Honor. I apologize for that. I will try to do my best to tone it down. So, again, I will ask you to tell us and admit to this fact that you are not disabled, correct?
I'm not what?
Are you disabled?
At that moment, no.
No. Are you disabled?
Overruled.
Are you disabled? Yes or no?
At that moment, when you're pregnant, I'm very disabled. You want me to tell you the things I can't do?
Fine. What was your disability on February 24th of 2018? What was your disability?
I was pregnant. I couldn't protect myself, even if I wanted to. She's like twice my size.
No problem, no problem. Let me ask you this. How many
Counsel, if you
months
ask a
pregnant
question,
were
you
you?
need to wait for the answer.
Okay, yes.
You done, man?
How many months pregnant were you?
I was around 13 to 12 weeks.
Months? 4 months? 3 months? 3 to 4 months. Fair enough? Did you have a bulging belly?
No, I didn't.
4 months?
Done, man?
How many months pregnant were you?
I was around 13 to 12 weeks.
Months? 4 months? 3 months? 3 to 4 months. Fair enough? Did you have a bulging belly?
No, I didn't.
Did Miss Emani Ellis know that you were pregnant?
Objection, cultural speculation.
Do you know if Emani Ellis knew that you were pregnant when you walked out of that elevator?
No, I didn't know. But she knows that I'm a patient. When you're a patient to go see a medical anything, you shouldn't even try to fight nobody. You don't know what disability they have.
Okay. Now let me ask you this question. When you say you were disabled, were you disabled in your upper extremity, your arms? Were your arms disabled? The reason I'm asking is I want to make it very clear for everybody that your arms can go up and down, and they could go up and down now, and they could go up and down on that day as well. You agree to this?
Objection, argumentative, asked and answered in a different way. And I guess that's fine.
I'll let you can answer this once. Please don't ask it again.
If my arms were disabled? No, my arms weren't disabled. No.
Can you raise your arms up?
Objection, Your Honor.
Can you? You don't have to do it physically. I'm saying, are you able to do it?
Yes.
And on that day, you were able to do it as well, correct?
If I wanted to, yes.
Okay. That's all I'm asking. Aside from your disability of is a little bit less than an inch, okay?
Mm-hmm.
Now, Miss Emani Ellis had a scar to her face of 2 centimeters long, and she received plastic surgery for that. And my question to you is, was it facing you or was it facing Miss Ellis? You weren't focusing on it, correct?
Objection calls for expert testimony relevant.
Did you look at Miss Emani Ellis's left cheek at any time during the incident? Did you specifically look for that because you thought there might be a scar on her face? Or did you not look?
Objection. Compound and relevant.
Assisting.
Did you look at Miss Emani Ellis's face when you were arguing with her at the time of the incident?
I was looking at her face, but I wasn't looking like, she got a pimple on her face? No, I wasn't looking at her details or anything.
So if she had a scar on her face or cut, you wouldn't be able to know because you weren't focusing on it, correct?
Objection calls for expert testimony relevant.
Assisting. Counsel, she's a fact witness. She didn't see a scar. Why don't you move on?
Yes, sir. You testified yesterday that when you go to get your nails done, you tell your nail person to be careful not to make your nails too sharp. Do you remember saying that?
Yes.
Do you tell them that every time you go to get your nails done?
Objection relevant.
Assisting.
Did you tell your nail person that before you had your nails done, just before this incident?
I didn't have to because of the shape. So the shape that I had that week, it wasn't like a shape that is like hardening. It was like a square coffin shape. So it didn't have like no points or like sharp edges and stuff like that. I mean, there's pictures of me of that week everywhere. So
Do you have a picture now with you?
Got him! Got him!
Do your attorneys have it?
yes.
The nails that you have on now, are they sharp and pointy?
I don't consider them that. No.
You consider them pointy?
No.
How is the jury supposed
Can
to
those
understand
nails
what
that you have on now, can they become sharp to the point where they could cut somebody if you were to scratch them?
The right amount of outrageous conduct or only the right amount of intent to cause extreme emotional distress?
First of all, so those two points, one of them are taken directly from the case instruction.
I wish they would
And
correct.
so the point here is that if the jury is going to find that Mr.
Like, you think it's
Almanzar
confusing?
acted in self-defense,
But since I've already
then
given it, I'll just swap
allowing
in
a claim to be
3903 and
by
3903A as already read, because I did already read these.
Oh, so you're going to keep the one that's been read already, is that what the court is saying?
When I did give these jury instructions, I gave them as they're printed out here. It's just without the, I think the proposed instructions had language that I struck out, so this is just a clean read.
The one that I submitted this morning is directly out of KC.
But you combined 3903 and 3903A. And that's not how I gave it. So if it had been given to me that way originally, I would have read it that way, but I didn't, so I don't want to change what I've already read.
Okay.
All right, 3905A. I think I already gave a version of that as well, right? Oh, maybe I didn't.
I'm not sure, Your Honor, you asked that we just include the case instruction rather than a special instruction. So this is just the case instruction.
Okay, so I will give that.
Your Honor, I also submitted a 3905
Is that straight from the casing?
straight from the KC.
Okay,
Are they
they're the same.
they're the same?
Correct. All right, 3934. That was not in the original package?
That was in the original package.
It was?
It was modified only because now that the damages are more limited than what Mr. Rosenthal was proposing earlier, we've just changed the last sentence.
Oh, okay. And I did not read that on Wednesday. Is that correct?
I don't believe you did.
Correct.
Okay, so so I'll give 3934. Special instruction number 8.
Special instruction number 8, there are just two differences from the Casey instruction. The first is that punitive damages cannot be awarded if there was accidental harm. The second is to include that's paragraph 3. Paragraph 4 is to include provocation as part of the jury's consideration of punitive damages. And we've identified a lot of supporting authorities in the notice that we filed with it. And I believe even Wittgen states that it's proper to instruct the jury on provocation when they're considering punitive damages.
Yes, Your Honor. My understanding was the trial would be bifurcated, and we would only get to this point after the jury made its decision as to the first non-punitive damages stage.
Well, this is a modification of the Casey that is given during the first phase. So do you want to be heard on the modification, specifically accidental or heat of passion?
Again, Your Honor, I don't really see a need for this one because there is a specific Casey on punitive damages that can be read.
I understand that. He is suggesting that it be appropriate to amend the Casey to add accidental harm and heat of passion. Do you want to be heard on that?
Yes, Your Honor. So my point is that none of the cases should be changed. And this is an example of one that's really so far off and completely different than what the Casey states. So that's my position.
All right, submitted?
Yes.
All right, I think special instruction number 8 is appropriate, so I'll do that. Special instruction number 9 is going to apply until we get to punitives. All right, let's go through plaintiff's proposed instructions.
No, there's one more I need to add. 3932, life expectancy. I have it here.
Is it printed out?
Yes.
And is the math right?
May not be. I'm willing to reduce it if that's the case, but I believe it's close to the number. Oftentimes, we'll have a stipulation with counsel, so if they want to reduce it to 40 years, I'm fine with that. I just picked a close enough number.
So, what evidence do you have that she will continue to have future? I guess she testified that it still bothers her. Is that?
Yes.
Okay. Any objection to 3932?
Yes, Your Honor. I'm not sure that she testified that it still bothers her, but in any event, first of all, this was never shown to me. We're not sure that the math is correct, and this is just not an appropriate. This is not an appropriate instruction in a case like this, where it's over an alleged scratch and there's a overwhelming amount of evidence that it wasn't caused by the.
Can I respond to that?
Go ahead.
So I'm pretty confident that if it was changed to 40 years, it would fall well below the threshold of the National Violence Statistics Report. So I'm willing to do that. If there's a different number that they propose, I'm fine, but there should be some kind of KC 3932 of life expectancy so that the jury can understand that.
Where's that chart in the cases? Oh, here it is. And she's 32 today?
Yes, she's 32 years old. Yes, she is.
It appears to be correct. This is 50.3, they've got 50. All right, I'll give 3932 over plaintiff or defendant's objection.
Thank you.
All right, plaintiff proposed 3901. I think I already gave 3901. Is that not correct? No, I give 3,900. I did. Oh.
Your Honor,
Yeah. So 3901 is only if liability's been established, not contested.
I apologize, that's an error.
Okay, so that's withdrawn?
Withdrawn.
Okay. 3902 already gave. 3903. I did not give, but I think that was proposed by the defense.
That's correct, Your Honor.
And that's, the defense version was straight from the casing?
Yes.
No,
It's in the binder.
the one that I did, Your Honor, is from the KC, which seems to have a lot more words than theirs.
Yeah, I already did give 3903.
So we're gonna go with their version now?
It's straight from the casing. 3905, I think I already gave.
May I be heard on that, Your Honor?
Go ahead.
So the one that I've submitted today has all of the different types of physical pain, mental suffering, and emotional distress. Their version doesn't really cover everything at all. It just has a small amount. It's missing an entire paragraph, at least a portion of it. So I would request that plaintiff's version be read to the jury.
Right. I just looked. I did not give 3905 on Wednesday. And plaintiff's is straight from the casing.
Yes, Your Honor.
And defendant had a different one.
I think theirs is 3905A, so maybe that's why. But I would like 3905.
Your Honor, I believe the difference is that 3905 and 3905A, we just submitted them as separate instructions, and Plaintiff's counsel has combined them.
Your Honor, I don't think I've combined them, but
Oh, I see. The defense proposed version does not define.
doesn't cover.
Yeah, it's not the full instruction, so I'll give plaintiff's proposed instruction.
Thank you.
All right, 1600. I think I gave 1600, didn't I?
I believe you did.
I thought the court wanted us to work on the 1600s, but I may be mistaken.
Your Honor, it was the 1602 instruction, which was the special instruction 4 we discussed earlier.
I did give 1600 already.
I withdraw the objection as to the 1600s.
Okay. Did we give a version of that?
1602 is the special instruction 4 that we discussed a few minutes ago.
And that, okay.
And
so I'll give the modified version.
Thank you.
1603, did we give that?
1603 was included in ours as well. I believe the court asked that we include it, so
The absence of evidence is not evidence.
And 1604,
I believe was given.
While they taking their sweet time, let me send a shout out to TSC in the building. Appreciate you, family. Much love for the gifted, for the donation, the $2. And TSC said, peace and blessings from the Bahamas. She's in Bahamas. Hi, family. She said hi from the Bahamas. Yeah, y'all show her some love. Shout out to TSC. Appreciate you, family.
That is the only distinction between the two versions that I
forgot to turn the volume back on. You didn't say nothing. You didn't say nothing. Y'all ain't missing nothing. My fault.
It was filed today at 12:19 a.m. with two different verdict forms. I did submit it to the court this morning without the caption of the attorneys, just so it would be somewhat of a neutral form. And I request that one of these be used because the one that they've provided doesn't really follow the usual method. I don't think it even has a signature line. Let me see. No, I withdraw that. But it doesn't really cover it the way that's usually done from what I've seen. Thank you.
All right, so I noticed the plaintiff's version has damages for each cause of action, which is duplicative multiple times over. It also doesn't include self-defense, and it also doesn't include what was the other affirmative defense?
Contributory negligence.
Oh, comparative.
Yeah.
Contrib went away on time with them.
Yeah. Thanks.
All right.
I can modify it.
Your Honor, if I may.
Yes.
What we submitted was to simplify the form as much as possible. I believe it even has fewer questions than the plaintiff's form. And that was after our discussion that the previous form was complicated, which we agreed. We believe this is clear cut. It includes all the issues. It should not be difficult for the jury to understand or to answer.
May I respond here?
Go ahead.
So the worst part of it is it, again, states by preponderance of the evidence. That's not usually in a special verdict form. They put that throughout the questions, kind of limiting, kind of creating a way for the jury to think ahead of time. It just doesn't make sense to have that there. I can modify mine. I have a printer. I can make changes in a couple of minutes. I print out the version that the court wants me to print. And the special verdict that I've submitted, I've seen all kinds of attorneys use it. I've never seen this version. And they would have to change it anyway because of the preponderance of the evidence, and it doesn't really tell the jury how to move along. So, for example, under assault, you have a question, yes or no, and then it says if you answer the question 1 is yes, then answer question 2. If you answered no, then proceed to question 6. Theirs doesn't have any of that. It's very confusing and has that preponderance of the evidence language. So definitely I would ask that that language be taken out, preponderance of the evidence. And if it could follow more along the lines of a special verdict form, that would possibly make it a better form, but still, it would confuse it.
Your Honor, as far as the instructions, it's just clearly not true. The verdict form specifically states what the jury is supposed to do after they answer every question. There are other problems with plaintiff's form that would be beyond just little modifications. As you mentioned, the damages issue is very likely to lead to confusion and possibly duplicative damages awards. So if the court is inclined to ask that one of these be modified, we believe it should be this one. And we would, if the court has an issue with the preponderance of evidence language, we can strike that language. Otherwise, it would be the same.
Can you strike it and print it within
Yes.
the next 5 minutes?
Certainly in the next 10 minutes.
Be heard?
Go ahead.
So again, Your Honor, the way that they've had it is not the way that the Casey instructions read. The Casey instructions do not have these boxes. It's a confusing way. It doesn't allow the jury to really answer the questions. They have to just say yes or no for everything. It doesn't break it down. So, for example, they're not able to answer the 4 parts of the question. For example, assault, it has 4 parts. And their form does not have the ability, the jury cannot answer the 4 different parts. They have to either go with everything or nothing. And that's not how a special verdict form, or any verdict form, is done. So I have a printer with me today. I can make changes. I can email it to the court if the court wants to do something with it. Their form doesn't cover any of these questions for any of them. Either it's all or nothing, and that's not how a special verdict form reads. So I would ask that the court. Well,
I'm just inclined to do a general verdict at this point in time.
I'm willing to accept that, if that's what the court wishes to do, but theirs is really off base, and it does not cover all the 4 parts.
Your Honor, there's multiple causes of action. Affirmative defenses that apply to some causes of action but not others. We believe it's important, at least for our appeal rights, among other things, that we have a special verdict form in this case. I'd be happy to work on it.
Well, I mean, actually, I think the defendant's proposed verdict form is the equivalent of a general verdict.
Well, may I be heard, please?
Go ahead.
So again, I'm looking at my form here, and first of all, the question is, are we doing the punitive damages question? At least I can narrow it down to, does the court want number 19 or not?
Well, I'm not inclined to do the plaintiff's version at this point in time.
No, I understand, but I just wanted to know if you wanted to have punitive damages, if that question, because the question is the same.
Your Honor, under the motion to bifurcate, the jury decides entitlement to punitive damages.
Exactly. So here's my question on punitive damages in the defense's proposed version. You've got punitive damages attached to negligence. Was that your intention?
Along with the instruction that it cannot be caused, that punitive damages are not awardable if the conduct was by mistake.
I'm sorry, you're saying you can get punitive damages for negligence?
No, not if it's by mistake. Not if it's what? No. We don't believe you can.
Okay, so but you do have a punitive damages question linked to question number 9, which is damages for negligence and comparative.
We can strike out the end of that of 12. question 12.
Here's what I want to do. I think the defense version of the verdict form is, for all intents and purposes, a general verdict on each cause of action. I think it's straightforward. I don't think it's confusing. And so the only remaining issue that I have with it is that you've got damages for each section, whereas there's a jury verdict that says that they only decide damages once. So how do we deal with that?
So we did it. We did the form this way just to avoid having to ask questions like, did you answer question this? Did you answer question that? However, if you look at question 7, for example, it says if you already answered question 4, which is the same, skip this question. So the intent is to have only one of those be answered. And if you fill the form out, that's how it would work.
May I respond, Your Honor? Each cause of action can have its own separate damages. And that's why in their form it is the way that they have it, and that's why I did the same thing. So I would request that the jury be allowed to break it down on damages and decide what type of damages are for assault and battery. Those are kind of coupled together. It shouldn't be, but they are. And then intentional infliction of emotional distress.
And that arguably kind of makes sense to me. Let's say that they find that the assault was limited to the scratch and nothing more. That the scratch itself did not cause past or future, maybe isn't going to cause future emotional distress, but they find that the intentional infliction of emotional distress was more longer lasting.
For example, Your Honor, have you heard?
Go ahead.
For example, they may find that there was an assault and battery and no intentional infliction of emotional distress. By removing the damages section, they would never be able to award any damages. So that's why I request that it at least be left there so that they could give damages to the parts that they wish to give. And counsel on both sides can argue duplication, don't give it twice, break it down.
Your Honor, that would be incredibly complicated, difficult to separate. It wouldn't work. I understand your position, but there needs to be some way of ensuring that there's not duplicative damages awarded.
Your Honor, they have multiple attorneys on their end. They created this form. If the court is going to go along with their form, then they should have to live with the form that they created.
The form that we've created does not have that risk of duplicative damages. I'm sorry. The other thing is that I think we've already established with the jury instructions that there are not damages that are awardable under some causes of action but not others.
May I add one more thing, Your Honor?
Go ahead.
Yeah. I'm sure the court has seen it in many cases where it is broken down. There's the damages award specifically for one cause of action, like in this case, assault and battery, and another one for intentional infliction of emotional distress. In closing argument, counsel obviously can argue how this form should be filled out, and as confusing it is to me, I'll have to just live with it. To take away the damages section in assault and battery would mean that it's too confusing. It should be separate so that the jury can decide whether there should be any damages for assault and battery and any damages for any other cause of action.
Your Honor, we could, in theory, have one question for the damages and just not duplicate them. And that the only difference there would be we would have questions like, did you answer yes to the question 3? Did you answer yes? Like what we did with the punitive damages. That would be one of the differences.
How about we modify question 7? What are Miss Ellis's damages? If you answer question 4, only include additional damages for this cause of action.
Can we include if any, Your Honor?
If any.
I'm confused. So again, it is very confusing because assault and battery is a separate cause of action and has its own damages component. By leaving the form as is, the jury can then decide if they're going to give any damages for assault and battery.
They can. It's under question 4.
Right, in 4. And then they can do it again for 7. They can do it again for 9. They might not do it in any of them. So that way they're able to break it down and decide what, if any, damages they're going to be awarded. Each cause of action has its own damages award.
But you can't double count.
I'm sorry, Aaron?
You can't double count, though.
Double count? What does that mean, then?
Meaning include the same emotional distress that if they find that she has a certain amount of emotional distress, are you asking them to allocate it between the different causes of action, or just...
No. I'm just straight asking assault and battery. This is what it is. If you find that an assault and battery, it should really be separate. Now, let's say we take it as together. We say, was there an assault and battery? And then what are the damages for assault and battery? It's really harmful to have it assault and battery combined because the swing that was taken was the assault and the cut to the face was the battery. So we're then limited to one damages in number 4. We're limited to one set of damages for both assault and battery. So then in my closing I have to explain that. Same thing, intentional infliction of emotional distress. Separate cause of action, it has its own damages. Negligence has its own damages.
Your Honor, I believe that, first of all, the addition that you proposed would address that. Not including something or just including more damages questions would make everything more complicated. Another proposal, Your Honor, however, is we could do separate verdict forms, one for and have damages only after liability. It would make things less complicated.
Go ahead.
So yeah, separate verdict form complicates it even further. This is a form that defense has prepared. It was well thought out, and it doesn't even break down the 4 different parts of the question. If we're going to live with this, I ask that at least we have those damages for each section. I'm not going to ask for the same thing 3 times. It's going to be broke. If I'm going to do it, I would break it down. This is worth this, the other is worth the other. It's not the same, Your Honor. So I ask that the form we submit it as is, and just if the court is going to go along with their form, then at least I would ask that. Thank you.
All right. I'm going to ask that you modify question number 7 to, if you answered question 4, only include additional damages under this cause of action, if any.
All right, that makes sense. Thank you. And what happens with the other one, Your Honor, number 9? Same thing?
Same thing. Can we do that?
Yes, Your Honor. Thank you.
All right.
And Your Honor, will we be giving number 13?
Yes.
Your Honor, just to confirm, question 12, we're going to omit the last 3 words or question 9.
Correct.
Thank you.
All right. Is there a request for judicial notice regarding the date of the NBA game?
Yes, there is. I did file that yesterday, and I served it a copy on defense counsel.
And I'm sorry, what was the testimony of the date that the photograph was taken?
Miss Almanzar stated that that the photo was taken on the date of the NBA All-Star game, which was the date of the accident, the date of the incident, February 24, 2018, about 6:30 p.m. She testified that that's when the photograph was taken, and her nails look like that on that date. There's no question that the All-Star game was on February 18th of 2018, so it's just a clarification so that the jury is clear of when the game is. This is common knowledge. There's no question about it. I've given different exhibits confirming that the All-Star game was on February 18th of 2018, and that's why I found this.
All right. And for the defense?
Yes, Your Honor. What Mr. Rosen is saying is absolutely false. I'd like to read what my client testified to. Cardi, I'm going to put this in front of you. Cardi, can you please look at this photograph and tell me, do you recognize this? Answer, yes. Question, what's this photograph? Answer, that is me out here in LA at the All-Star Weekend in Diego. Question, does this picture reflect your recollection about what your hair color was that week? Answer, yes. What color was it? Answer, I'll say like...
More slowly, please.
Sure. Answer, I'll say like an ashy, dirty blonde. Question, can you see your nails in that photo? Answer, yes. Question, were you wearing acrylic nails or some other type? Answer, acrylic. Question, I think you testified yesterday that acrylic nails can last you up to 2 weeks. Is that right? Answer, yes. Question, are those the nails you had the entire time you were in LA? Answer, yes. And I can continue reading, Your Honor, but nowhere does my client say that this was taken on February 24, 2018. She doesn't reference a date. And Mr. Rosen represented this to you twice last Wednesday, that the court was advised and everybody was advised that it was on February 24th of 2018. He later said she testified that she got this picture taken on the same day. She testified under oath that at 6 p.m., he just said 6:30, on February 24th, 2018, that this picture was taken. That's absolutely false, Your Honor. I'd be happy to provide a copy of the transcript to the court.
Okay.
May I respond?
And one other thing, Your Honor, may I?
Go ahead.
My understanding under California law is that you can't take judicial notice of the truth of the contents of a website. And there is case law on point I can refer the court to.
Well, I'm not necessarily worried about that. I'm just worried about whether... I don't think that there was any representations of the date it was taken. She did just reference it generally, but the substance of the testimony was that she had those nails for the entire time that she was here. So whether it was taken on one day or a different day, I don't think that's material.
May I respond?
Go ahead.
The purpose of this is really not to make anybody right or wrong. The purpose of judicial notice is just to clarify the All-Star game took place. The purpose of judicial notice is just to clarify the All-Star game took place.
Pleading it as
Absolutely false, Your Honor. I'd be happy to provide a copy of the transcript to the court.
Okay.
May I respond?
And one other thing, Your Honor, may I?
Go ahead.
My understanding under California law is that you can't take judicial notice of the truth of the contents of a website. And there is case law on point I can refer the court to.
Well, I'm not...
And the second half of it is when the photograph was taken. There's overwhelming evidence attached.
Necessarily worried about it.
Different news outlets. There's
again, is it material? The date she said she had those nails for the entire week.
It's material, Your Honor, because the defendant testified that that's what she was wearing later in the day, exact same day. She had those nails. You have on the same date of the All-Star game and the same date of the incident. What was the error there is that the All-Star game was on February 18th of 2018, and the court said that we didn't have credible evidence at that time about it, so that's why the judicial notice was prepared so that the court can see for itself that the All-Star game was on February 18th of 2018.
Okay, I'm going to deny the request for judicial notice. All right. Are we otherwise ready?
There's one more thing, Your Honor.
Go ahead.
The court asked that I prepare a statement regarding the death of John Sherrick.
Okay. Do you have that?
Yes, I do. I did give it to the court. It would say plaintiff testified that she treated with John Scher, MD, in relation to this case in 2018. It is undisputed that Dr. Scher died on March 5th, 2021.
After a lot of back and forth, what we agreed to, what I agreed to, was that the court can instruct the jury that it is undisputed that Dr. Scher died, period. This March 5th, 2021 date, it's not in evidence. Plaintiff didn't testify. She said she understood he died sometime in 2021. She also testified, and we launched the transcripts. I can cite to where in the transcript she says it. Page 148, lines 12 through 149, line 15. She says that she went to see a Dr. Scher, and he told her not to have any treatment. So this assertion that plaintiff testified that she treated with John Scher is not supported by the evidence. The only portion of this that is actually what I agreed to was
that I'm just worried about whether I don't think that there was any representation.
My bad, family. It's just skipping. I was trying to see if the other one's skipping like.
It is undisputed that Dr. Scher died. Period.
Okay. You heard. So, this is what I would propose reading. Plaintiff testified that she treated with John Scher, MD. Does not dispute that Dr. Scher has passed away.
Your Honor, she did not testify she treated with Dr. Scher. She sought medical treatment. This is page 148, line 12 through 14. Around that time, unclear when that is, did you also seek medical treatment from Dr. John Scher? I did. And then at line 22, and when you saw him, did he advise you that you needed to wait at least 1 year? He did. So, okay. That goes on page 149.
So I will read, plaintiff sought treatment with John Scher. It does not dispute that he's passed away.
Well, plaintiff testified. Plaintiff testified she saw it.
Very good.
Thank you, Your Honor.
What will we read, Your Honor?
Plaintiff testified that she sought treatment with John Scher, MD. It does not dispute that he has passed away.
Thank you, Your Honor.
All right. Now are you ready?
Well, there's a couple things. In my closing argument, I need the verdict form, so I can't start without.
We're working on
that in hand. The other thing I wanted to say, Your Honor, is Your Honor did allow me to argue and clarify the NBA All-Star game when it was, the photograph. I want to be very clear that I intend to argue that in my closing.
It's not in evidence, though. I think what you said was they didn't provide the date. And you're fine, you can argue that they didn't properly authenticate the photograph in terms of the date.
Your Honor, the court said that I could argue this in my closing.
You could argue it. You could argue that they didn't establish what the date was.
And also that the All-Star game was on February 18, 2018, the week before. But the week before the incident, I don't see the harm in that. They can object to that. They can say their version, but that's part of my closing, Your Honor. And this photograph, by the way, this photograph was sprung at the last minute. It was never produced in discovery.
Go ahead.
Just briefly, a couple of questions. First, if you remember, counsel violated a motion in limine order.
And if anybody getting a lot of ads, refresh your browser. I changed the timing, so if you still have the original timing, it might be frequently, but I changed it to less. So if you're getting a lot of ads, just refresh your browser.
I would, and now he's talking about. If the court doesn't want to tell him, then he has to follow the rules. He can't argue out things that aren't in evidence. He can't violate the motions in limine.
I think it's readily apparent that you can't argue facts that aren't in evidence. I think plaintiff's counsel knows that. I think he knows that he would be violating the rules of professional responsibility by intentionally arguing facts that are outside the evidence that was presented in court. If you want to present that and you want to object, then that's how we'll proceed.
Thank you, Your Honor.
Are you the same? Are you done?
Then two procedural questions. Does the second monitor work and can it be facing the jury so they can clearly see it?
I don't think so. But we're in the middle of a transition, and I don't know.
Okay. And
we can see it's not.
Your Honor's preference, we have demonstratives and we have things we're going to show, intend to show. Do we need permission to publish admitted exhibits?
No.
And do we need permission to publish demonstratives? They have been provided to plaintiff's counsel.
No. And it's argument.
Yeah, okay. I just want to make sure. Thank you, Your Honor.
All right. Anything else from plaintiff's counsel?
Yes, Your Honor. I feel that what counsel has just stated is really below the belt and disrespectful to my side. I would never argue things that are outside of the evidence.
I think you just said you were going to.
No, I didn't say I was going to. The court told me that I can argue the issue of the photograph, that it wasn't taken on the day.
Correct. Your position on Wednesday was that they didn't establish the right date, and you can make that argument.
That's exactly what I wanted to do.
Okay.
Thank you very much, Your Honor.
All right. Are we ready to move to the jury?
I must have the verdict form before I start.
All right.
They're being printed right now.
Okay. All right. Let's wait a minute.
Well, look like they about done with that, so next should be the jury instructions. Appreciate y'all being here. Hit that like, hit that subscribe, tap in, share with a friend.
Well, isn't this a nice surprise?
Did you see any skin or any blood underneath your fingernail after the incident? Any of your fingernails?
There was no physical incident for me to even see nothing like that.
That's not what I'm asking. I'm saying if you saw anything.
All right, welcome back.
No.
We're still on the record
Okay.
in the Ellis matter. We now have a defendant with us as well as the members of our jury and our alternate. Based on the fact that you're all here, I'm assuming no one hit the lotto over the weekend. Folks, we thank you for your patience. We did have a few procedural issues that we needed to address prior to bringing you in. We are now ready to proceed with the last batch of jury instructions. I'll try to give context to these to the extent that it's necessary. I will put them into the package where they belong, but I do need to give these to you. And we're going to relieve the court reporter of her obligations to report these by stipulation of the parties. Okay, here we go. Words alone, however threatening, do not amount to an assault. Aggressive and threatening actions do not constitute an assault unless they were intended to cause immediate, harmful, or offensive contact. If you decide that Ms. Almanzar assaulted or battered Ms. Ellis, you should fine for Ms. Almanzar if you decide that Ms. Almanzar was acting in self-defense. To succeed, Ms. Almanzar must prove both of the following by a preponderance of evidence: that Ms. Almanzar reasonably believed that Ms. Ellis was going to harm her, and that Ms. Almanzar used only the amount of force that was reasonably necessary to protect herself. Ms. Almanzar claims that Ms. Ellis's own negligence caused or contributed to Ms. Ellis's claimed harm. To succeed on this claim, Ms. Almanzar must prove both of the following: that Ms. Ellis was negligent, and that Ms. Ellis's negligence was a substantial factor in causing Ms. Ellis's harm. If Ms. Almanzar proves the above, Ms. Ellis's damages are reduced by your determination of the percentage of Ms. Ellis's responsibility. I will calculate the actual reduction. Ms. Ellis may only establish her claim for negligence if she proves that Ms. Almanzar engaged in negligent conduct that caused Ms. Ellis to suffer physical injuries. If Ms. Ellis can prove that Ms. Almanzar caused her to suffer only emotional injuries, and this is under the negligence cause of action, Ms. Ellis cannot establish her claim for negligence. Emotional distress in suffering, anguish, fright, horror, nervousness, grief, anxiety, worry, shock, humiliation, or shame. Ms. Ellis claims that Ms. Almanzar assaulted her. To establish this claim, Ms. Ellis must prove all of the following: that Ms. Almanzar acted with the intent to cause harmful or offensive contact, that Ms. Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner, that Ms. Ellis did not consent to the conduct, that Ms. Ellis was harmed, and that Ms. Almanzar's conduct was a substantial factor in causing Ms. Ellis's harm. A touching is offensive if it offends a reasonable sense of personal dignity. Words alone do not amount to an assault. Outrageous conduct is so extreme that it goes beyond all possible bounds of decency. Conduct is outrageous if a reasonable person would regard the conduct as intolerable in a civilized society. Outrageous conduct does not include insults, threats, indignities, annoyances, hurt feelings, petty oppressions, bad manners, or other trivialities that a reasonable person is expected to endure. Outrageous conduct also does not extend to profanity, obscenity, or abusive language without circumstances of aggravation. In deciding whether defendant's conduct was outrageous, you may consider, among other factors, the following: whether defendant abused a position of authority or a relationship that gave her real or apparent power to affect plaintiff's interests, whether defendant knew that plaintiff was particularly vulnerable to emotional distress, and whether Ms. Almanzar knew that her conduct would likely result in harm due to mental distress. Under Factor A, which is the position of authority, examples of positions of authority or relationships of power include an employer, a landlord to his or her tenant, a hospital to its patients, an attorney to his or her client, or a religious institution to its members. Ms. Almanzar acted with reckless disregard in causing Ms. Ellis's emotional distress if Ms. Almanzar knew that emotional distress would probably result from her conduct, or Ms. Almanzar gave little or no thought to the probable effects of her conduct. If you decide that Emani Ellis suffered damages that will continue for the rest of her life, you must determine how long she will probably live. According to the National Vital Statistics Report, a 32-year-old female is expected to live another person is likely to live, but is not conclusive. Probably live. According to the National Vital Statistics Report, a 32-year-old female is expected to live another person is likely to live, but is not conclusive. In damages from Ms. Almanzar under more than one legal theory. However, each item of damage be asked to decide whether Ms. Almanzar is liable to Ms. Ellis under the following legal theories: battery, assault, intentional infliction of emotional distress, and negligence. Ms. Ellis's claimed damages are recoverable only once under all of the above legal theories. And the verdict form breaks that down for you. The following are specific items of non-economic damages claimed by Emani Ellis: physical pain, mental suffering, and emotional distress. No fixed standard exists for deciding the amount of these non-economic damages. You must use your judgment to decide a reasonable amount based on the evidence and your common sense. To recover for future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, humiliation, emotional distress, Emani Ellis must prove that they are reasonably certain to suffer that harm. For future physical pain, actually, I think, okay, no, we're fine. For future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, humiliation, and emotional distress, determine the amount in current dollars paid at the time of the judgment that will compensate Emani Ellis for that future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, and humiliation, and emotional distress. If you decide that Ms. Almanzar's conduct caused Ms. Ellis's harm, you must decide whether that conduct justifies an award of punitive damages against Ms. Almanzar. The amount of punitive damages, if any, will be decided later. You may award punitive damages against the defendant only if plaintiff proves by clear and convincing evidence that Ms. Almanzar engaged in that conduct with malice, oppression, or fraud. If you define that the defendant accidentally harmed plaintiff, punitive damages are not appropriate and should not be awarded. In deciding whether or not to award punitive damages against the defendant, you may consider whether the defendant's acts were the consequence of a sudden heat of passion that was provoked by plaintiff. Malice means that defendant acted with the intent to cause injury, or that a defendant's conduct was despicable and was done with a willful and knowing disregard of the rights or safety of another. A defendant acts with knowing disregard when a defendant is aware of the probable dangerous consequences of her conduct and deliberately fails to avoid those consequences. Oppression means that a defendant's conduct was despicable and subjected the plaintiff to cruel and unjust hardship in knowing disregard of the plaintiff's rights. Despicable conduct is conduct that is so vile, base, or contemptible that it would be looked down on and despised by reasonable people. Fraud means that the defendant intentionally misrepresented or concealed a material fact and did so intending to harm the plaintiff. During the trial, plaintiff testified that she sought treatment from John Scher, MD. It is not in dispute that Dr. Scher has passed away. All right, ladies and gentlemen, that concludes the additional jury instruction, and we're back on the record with the court reporter.
I know you better get out of my face.
That concludes the additional jury instructions
out of my face. Out of my face.
We are adding to those instructions that I previously read. At this point in time, it is the time for the attorneys to give you their closing arguments. Please keep in mind my instructions regarding the facts in this case. You are the ones who are to determine the facts, and to the extent that the attorneys argue facts that you do not believe were proven during the trial, please rely on your own finding of what the facts are. And similarly, to the extent that the attorneys argue law that is contrary to the law that I've just given you, please rely on the law that I gave you. And with that, is plaintiff prepared to give your closing argument?
Yes, Your Honor. I would just ask for a quick sidebar for a moment, please.
Here they go with the sidebars. Hold on. While they doing the sidebars, I got something I want to see. Oh, it ain't right there. Well, we got something else.
Thank you for coming down.
Thank you. Subject to recall.
Did you subpoena her?
No.
Then I don't think it's subject to recall. All right. All right, we had a brief conversation at sidebar, and now is plaintiff prepared to proceed with your closing argument as soon as you get there?
Yes, Your Honor. Thank you very much.
And just for any members of the gallery, if you are not a member of the press and you don't have a sheriff's badge as well, you're not allowed to use any electronic devices or phones. Thank you for that.
Thank you all for coming back today. So at this point, both sides will be giving our closing argument, basically a summation of everything you've heard, just so you can jot down things, take notes if you feel comfortable. So you all heard all of the evidence in this case, and the distinction between a civil case and a criminal case are different. And what that means is, in a civil case, our proof, what has to be in the box, is greater than 50%. Touch more than 50%, maybe a featherweight more than 50%. 51%. It's not 100%. The standard is a little bit more than 50%. In this case, you've heard lots and lots of testimony. We've had the plaintiff who's testified. We've had the plaintiff's mother who's testified. We've had the plaintiff's grandmother who's testified. Those three witnesses explained their recollection about the scar. There was testimony that the scar, or the cut, came from this incident. That's a very, very important fact. There's really nothing to contradict that. If anything, our expert witness, Dr. Mulliken, you remember he came to court. He's a very well-respected doctor that specializes in plastic surgery. And his testimony was that, in his opinion, as an expert, that when the way that this scar, the way that this cut happened was from fingernails.
and that there were 3 different scrapes, 3 different scratches, and that the middle one was the deepest one, and that's really the one that he worked on. Now, the issue in this case, well, before I go to that, is the photograph that you.
I'm glad he said that, because that's just what I was about to say. The issue is, in this case, is the photograph does not show that, so clearly he's lying.
Saw, okay, which is in evidence. There's a photograph of the scar, which is a 2-centimeter scar. The photograph, because of the skin color, it does not show well in photos. The cut that was on the face does not show up as well. So you may have to really look at it deeper than just had it been someone else. The other thing that I wanted to highlight is I really just don't understand. The defendant came here, used all of this foul language. This is a court of law. You cannot speak this way in the court. I have never seen this before. And for her to use all of those words, F word, B word, all these different words, it's a disrespect to us. It's a disrespect to the judge. It's disrespect to this courthouse. You cannot come to court and say these kind of words. It's just disrespectful. And just because Miss also known as Cardi B is a celebrity, doesn't mean that she could just say and do whatever she wants and attack people. Okay? If you recall, just to give you a little bit of background about Miss Ellis. When she was 19 years old, she moved out of her house. She went to college. She's a college graduate. She has a bachelor's degree. She went on to become a security guard for 4 years. From 2014 to 2018, she did whatever she needed to do to become a licensed security guard. And she did that job. And when this incident happened in 2018, that was cut off. She lost her future in security work, in something further, whether it's FBI, police, attorney, whatever she wanted to do. This incident cut it off. No more.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop.
The trauma that she sustained. And I get it. There were doctors who gave their opinions. For example, the defense brought Dr. Rosenberg. Nice guy, gentleman. He complimented me. Maybe he's doing that because he's a psychiatrist and he knows what to say to twist everything. But the point is, he got $40,000 to come here and basically tell us that the plaintiff didn't suffer any emotional injury. That's not the facts. The facts are, Emani Ellis was working as security guard. There was a change. Okay, it's very, very traumatic to be assaulted and battered. I can only imagine the embarrassment, the emotions, the pain that Miss Emani Ellis suffered. Now, in this case, there was overwhelming testimony that Miss Ellis was working as a security guard at the time of the incident. There's no question. She was in full uniform. She had a badge on. Even the defendant admitted, yes, I understood that this person was a security guard. And there has to be some level of respect. These are not doormen or doorwomen. The defendant, when she came to the building, instead of listening to the plaintiff, to listening to her commands, you got to do this, you got to do that, please leave the building, different commands were given to her, which none were followed. They were all ignored. Instead, the defendant thought that, well, Miss Ellis was on her phone. She was telling people that I'm here. These were the thoughts that were going through her head at the time, and she's testified to those. However, that's not the case. Miss Ellis testified that she's never had a fight before. She's never done anything to harm anybody. She's never had any fight with anybody. And her mother and her grandmother also testified. She's a model citizen. She's a hardworking person, and she simply, her whole goal of doing this, to be here and sit here and go through this, is so she could move on with her life. Sometimes people have to be heard. Be heard. So by you all being here and hearing everything that's gone on, you have given her a sense of closure where she can move on and go on to the next step and the next phase. She's only 32 years old, and she has plans. She has plans to do other things in her life. So we're very thankful that you gave us that opportunity. Each and every one of you, we're very thankful. The other thing I wanted to mention is the phone. It would be impossible for someone to be videotaping someone and be on a phone call at the same time. I tried it myself. And the error message that you would get if you tried it is, recording video is not available while on a...
He must have forgot that she said she had two phones in her hand. She openly on the stand said she had two phones in her hand.
So it couldn't be. The two of them couldn't be done at the same time. Miss Ellis told Cardi B multiple times, I am not recording you. I am not telling anybody that you are here. I'm simply doing my job. And instead of maybe agreeing or investigating further, Miss Almanzar, Cardi B, got angry and started yelling and cursing and spitting on Miss Ellis and calling her different words, using the N-word to disrespect her, calling her the B-word, calling her fat, anything to try to trigger her and make her upset and embarrass her. Sometimes and cursing and spitting on Miss Ellis and calling her different words, using the N-word to disrespect her, calling her the B-word, calling her fat, anything to try to trigger her and make her upset and embarrass her. Sometimes words are more painful than the physical. And to add insult to injury, she then cut her face and caused a scar on her face. And what happened then? Miss Ellis had to go see different doctors. The court did read about Dr. Scher a sentence that basically that it's undisputed Dr. Scher died. And Miss Ellis basically testified that initially, a couple months after the incident, she saw Dr. McKenzie, a psychologist, through her workers' compensation. She was given that. She got 7 visits with that doctor. During that time, she also saw Dr. Scher, who was another plastic surgeon. Unfortunately, we don't have him here. We don't have his records because he passed away. So that's why that was read to you in open court, so that it's some sense of fairness. Why there's no records from Dr. Scher.
Objection, Your Honor.
The truth is that you are a liar.
Then we learned throughout the case that when Cardi B came to the building, she caused a disturbance. She caused a disturbance. She was yelling and screaming at the top of her lungs, going crazy, yelling and screaming, to the point where 2 other witnesses, Miss Malcolm, which was the secretary of the doctor, and Dr. David Finke, it was so loud that those 2 people came out after about 40 to 50 seconds. Now, the issue with that is those 2 witnesses didn't...
Anything that I may have said they exacerbated it.
See the 4 things that happened before that, which happened in the 40 to 50 seconds before. So yes, they're witnesses, but they're not witnesses to that first part, that first segment, which would include taking a swing at Miss Ellis, spitting on Miss Ellis, calling her the N-word, and ultimately cutting her face. None of that was seen by those 2 witnesses. So yeah, they're witnesses, but they're witnesses to the aftermath. They're witnesses to what happened afterwards. They're not eyewitnesses. They don't know what really happened. And when they arrived, Miss Ellis was so upset. Can you imagine all those 4 things happening, being disrespected, embarrassed, who knows what else happened? All of that was done to her, and she still was able to contain herself to a certain degree. But yeah, sure, I mean, naturally, she was angry, she was emotional. So when these 2 witnesses come out of their offices, they can only see an angry person. They didn't see what led up to that, and they had assumed that it's her fault, maybe, or that she did something wrong. But again, those 2 witnesses didn't really see much. They saw something after the fact. And then you have Miss Malcolm, who decided on her own, this was her choice, to squeeze herself in between the 2 people. Well, that's a risk that she took. And if she somehow got a cut to her face or a scratch or something, well, we don't know who did that. We really don't know. She didn't even know. Miss Malcolm testified that she did not know who scratched her face. She has no idea. What does that mean? It could be from either one. It could be from the commotion that's going on. These things happen so fast, we have no real idea as to what really happened. Unfortunately, there was no video camera there. There was no other witnesses that actually saw it. So it really comes down to one thing. Do you believe Miss Ellis? Why not? You should. She's a hard-working security guard. She was doing her job with no prior anything.
That same but you just lied. Stop it. Stop it.
At some point during the trial, the defendant showed you Exhibit 232. If you all remember this photograph, Exhibit 232, this is a photograph. Now, the issue with this photograph is there's really no way to know the date that this photograph was taken. There's no way to know. We don't know when it was taken.
Objection. Overruled.
There is no proof of when this photograph was taken. It could have been taken at any time, before or after the incident.
Overruled.
It could have been, and in this case, the defendant testified that this photograph was taken on the date of the incident.
Objection, Your Honor. Overruled.
That was her testimony. But where's the proof? Do you really believe that a celebrity can't prove when this photograph was taken? She testified that this photograph was taken at the All-Star, NBA All-Star game. There's no proof of that anywhere? That's just false. There is proof of when this photograph was taken. It just wasn't given to us. It wasn't provided to us. So we can't rely on this photograph because there's no date on this photograph.
Monkey shit.
Go ahead. You got some time, Allie. You look like they taking a little sidebar because this dude up here wilding. Like, wasn't the jury here the whole time? You don't think they gonna recognize that you sitting here lying to their ass?
Miss Ellis did is she made an incident report. 2 days after the incident, Ms. Ellis wrote an email to her boss and followed what she was supposed to do to explain all of the details of what happened to her. And she did follow company policy and did what they asked her to do. She called her supervisor, made an incident report, and did everything possible to document all of the different things that happened to her on that date of February 24th, 2018. The other important issue is Cardi B testified that she came to the building, at least downstairs of the building. She had a security guard with her, Mr. Newton. Mr. Newton, that's her security guard. He didn't testify in this case. Why not? Where is he? Disappeared? Miss Ellis testified that when she saw this security guard downstairs in the lobby, and she met with him there, Mr. Newton apologized for what happened. Mr. Newton should have testified in this case and could have testified in this case, but he didn't. And there is a jury instruction, KC Jury Instruction 203, which deals with a party having power to produce better evidence. The jury instruction states, you may consider the ability of each party to provide evidence. If a party provided weaker evidence when it could have provided stronger evidence, you may distrust the weaker evidence. That's what the law is. So, where is Mr. Newton? I don't know. He was on the witness list. He should have came here and testified. Another important fact is, if a witness is not credible on one point, you can disregard their entire testimony. When you go back into the jury room, you will have all of these different jury instructions. And each jury instruction will be there for you where you can read and understand what the law is and how it applies to this case. And as I told you before, testimony is evidence, and you can rely on testimony alone to come up with your verdict. KC 107 states, do not make any decision simply because there were more witnesses on one side than on the other side. If you believe it to be true, the testimony of a single witness is enough to prove a fact. So in this case, you've heard from different witnesses. Just because one side may have more witnesses or less, that's not how it works. One witness is sufficient to prove a fact. You initially heard that Ms. Ellis saw a Dr. Nicole McKenzie. Dr. McKenzie testified. She's a psychologist. She treated the patient in her office, between her and other providers in her office, a total of 7 visits for a period of 8 months. Ms. Ellis did seek psychological care and received it. She also, as I said, went to Dr. Scher. Dr. Scher advised her that he could not do the plastic surgery for a couple reasons. One is you have to wait at least a year. You have to wait at least 1 year, 1 to 2 years, to determine if the scar will become a keloid. I'm sorry, if the cut will become a keloid, if it will become a scar. Sometimes it may go away on its own. In this case, it did not go away. After that time period, if we all remember that in April of 2020, the pandemic occurred. We had this pandemic outbreak where everything was closed. You can't just go and have elective surgery. So the case was delayed. The medical treatment was delayed. That's why Ms. Ellis waited. Another factor is affordability. She had to find a doctor. We had to help her find a doctor that was willing to work on a lean basis. Dr. Mulliken testified that he would agree to that he treated her on a lien basis. What that means is she still owes the money. However, in a court case, what happens is the doctor will agree to treat the patient and delay payment. They delay getting paid. That's what Dr. Mulliken did. Dr. Mulliken testified that he fully examined Miss Ellis. He then decided, with his expertise as a board-certified plastic surgeon, that it would be beneficial for Miss Ellis to have plastic surgery and have this done in a surgery center. 2 different surgeries were done over a period of 3 to 4 months so that Miss Ellis could, there were 2 issues. She had hypersensitivity, a little bit of hypersensitivity, and also as a woman, she doesn't want to have a scar to her face. And all the time, every day, waking up in the morning, looking in the mirror, remembering the event, it reminded her. It does remind. It does remind.
No.
No.
No, he's sleeping.
Now, the defendant had the ability to hire their own plastic surgeon and have their own expert witness.
I'm sorry. Overruled.
And in this case, the defendant decided not to hire one. So what does that mean? What that means is you really got to take what Dr. Mulliken says with a lot of importance, a lot of truth. There is no other doctor from the defense side. They could have spent money and hired somebody and had them testify here and tell us, yeah, Dr. Mulliken's work is no good, or she could have done something different, but we don't have that here. You have one doctor on the plaintiff's side basically explaining all of his expert opinions. And he's a board-certified plastic surgeon for 30 years. He's affiliated with UCLA.
Monkey shit.
And even testified that he, in his career currently, does teach medical students at UCLA to help them in their careers of becoming plastic surgeons themselves. Now, when you go back into the jury room, you'll see Dr. Mulliken's records and bills that are part of this case. They've been admitted into evidence, and you will see his medical report, and you will see his medical bills. Those are admitted into evidence. You'll have that in the jury room, so you can see it for yourselves. And if you remember, even Dr. Rosenberg had testified that he has seen Dr. Mulliken in other cases. He's been an expert in other cases working alongside Dr. Mulliken. And this is a very well-respected doctor. He went to Yale Medical School. Even Dr. Rosenberg testified that he had impressive credentials. He acknowledged that fact. And the other thing that I wanted to discuss would be the fingernails. The Cardi B testified that most of the time she would have long fingernails.
But you just lied. Stop it. Stop it.
Of 3 inches. That's her style. That's what she did. And in this case, not only did she have these long, sharp fingernails, she also had rhinestones. If you remember Dr. Finke, he was a fingernail, that was his thing. and he basically said he remembers the rhinestones, that they were protruding. They were raised.
He's gonna lie? She said they was flat. Dang, he's just lying every word. That's crazy. Tell me, Lewis, what's
When
good?
Cardi B testified, she acknowledged that she refused to listen to Miss Ellis, who was the security guard on duty at the time. There was also testimony by Cardi B that the two of them were chest to chest, touching. This was a touching that Miss Ellis didn't want. Miss Ellis didn't want to be connected to Cardi B physically, but Cardi B made that happen, and that's an unlawful touching. That alone, aside from the rest, that alone, Cardi B admitted to that fact. She said, that is what I did. I was chest to chest with Miss Ellis. Cardi B even testified that she was yelling and screaming so much that she acknowledged that it was possible that her spit went on to Miss Ellis. That was in the testimony. When Miss Ellis told Cardi B to leave the building, she should have left the building. Miss Ellis was hired by the owner of the building to keep the building secure and safe for tenants and other patients and visitors. Cardi B refused to listen to the security guard who was working there.
Where? I'm almost done.
At some point, Cardi B caused such a disturbance that what she was doing was a trespassing. You cannot be on the property when the owner or an extension of the owner tells you you have to leave. You have to leave. Miss Ellis's mother, Leanne Schmidt, testified. She testified that Miss Ellis obtained the scar to her left cheek as a result of this incident.
Objection, Your Honor.
Miss Ellis's mother testified that she recalled seeing the scar after this incident. Miss Ellis's mother testified that she saw changes in her daughter after this incident. Same with Miss Ellis's grandmother, Diane Schmidt. She also testified that she recalled seeing the scar after this incident, and that she noticed a marked difference in Miss Ellis after the incident. That's her granddaughter. The defense put on a Dr. Rosenberg, who was a hired gun, received $40,000 for this case and makes millions of dollars in this type of work. He criticized the Kaiser Hospital for not writing down that Miss Ellis had emotional injuries when when Miss Ellis went to Kaiser Permanente for vaginal discharge in 2022. Dr. Rosenberg testified that there was an inconsistency when Miss Ellis went to Kaiser and didn't tell them about her emotional injuries. Why I'm bringing this up is very simple. When someone goes to an orthopedic surgeon, they don't talk about dental injuries. When someone goes to a gynecologist, they don't talk about emotional injuries. What really happens is when someone goes to a psychologist or psychiatrist, they tell them about their emotional injuries. When someone goes to a dentist, they tell them about their broken teeth. When someone goes to an orthopedic surgeon, they tell them about their neck pain, their back pain, their left foot pain, left ankle pain. This idea that every time you go to a doctor, no matter what specialty, you have to cover all these things is not real. It's not real life. Some of the doctors will even say, don't tell me, I don't want to know. I'm not writing it down. Yes, sir. We've all gone to doctors, and we all know when we go to a specialist, we'll focus on why we're there. Miss Ellis went to Kaiser Permanente Hospital for vaginal discharge in 2022 and different things throughout her time there. She didn't go there for emotional injuries. She didn't go to the psychiatric care there. She didn't get any psychological care there. None of that. So for Dr. Rosenberg to sit there and tell us there's inconsistencies because in Kaiser she didn't tell him about the emotional injuries, it just doesn't make sense. I want to talk a little bit more about Miss Malcolm. So I just want to remind you that when Miss Malcolm came out, 40 to 50 seconds had already transpired. She came to the aftermath. I know I've already said that, but I really want to hammer this home, that she is not a witness to what happened before. It's like a car accident. There's two cars, they have an accident. If a third car comes down the road a minute later and hits them, it's completely different. It has nothing to do with it. So that was inserted into this case, in a sense, to muddy the waters, to kind of cloud what really happened. What really happened here in this case is Miss Ellis was working as a security guard. She had to be there. She was working there as a security guard. And Cardi B came along and thought she's above the law. She could do and say whatever she wants and attack Miss Ellis emotionally, physically, and do whatever she wants in a building which is inappropriate. We all know that when we go to a building, you got to be respectful, especially to security guards that are working there. These are not just doormen or doorwomen opening the door for you. You have to follow along with what they say. Next, we heard from Dr. Finke. Want to talk about inconsistencies? There was an inconsistency between Malcolm and Finke. Malcolm said, I don't know how I got this scratch on my forehead. I don't know. Dr. Finke comes out and says that Malcolm told him that Ellis had scratched her face. That's not true. That was never said. So this, if you remember, this is a 7.5-year-old incident, and that's a few thousand days ago. It takes a lot of time has passed, and an incident can be perceived differently.
The sign is real simple, B. It says wrap it up. Wrap that shit up, B.
By different people. So Miss Malcolm could have perceived it one way, and Dr. Finke could have perceived it one way. But again, same problem with him is when he came, everything had already been done. The whole incident already happened. The injury was already complete. And really this comes down to believing Miss Ellis. He gave you no reason not to. She's been truthful through me and through herself and through her witnesses to give you whatever is there, to provide for you all that she could with the things that she has available to her, so that you could give her the peace of mind, the closure, and yes, she is asking to be compensated for the loss that she sustained. She lost something, and by you compensating her with money damages, you're then evening the playing field. You're giving her what she lost back. So she's not trying to gain something that she's not entitled to. Unfortunately, she was abused, she was harmed, she was assaulted and battered by Cardi B. And Cardi B needs to pay for that and needs to be accountable. We need to hold her accountable. We should not just let her walk away and say, oh, everything you did was okay, and yeah, do it again.
Asistencia de Xavi, més cap a dreta per a Messi, 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 immens Messi, encara 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 Messi.
Now, in addition to seeing the two plastic surgeons and Dr. McKinsey,
The right front, the right left, excuse me, the right left side. Front.
Miss Ellis also received another 12 visits of, she testified that she saw a psychologist, Dr. Avila, and other
Objection, Your Honor.
people in
It's
his office.
Violation of the court's order.
Move on.
The other thing that Cardi B failed to do or could have done is she could have filed a cross complaint.
Objection, Your Honor.
I was wondering that if she filed a cross claim or filed a claim against her to counter sue. I guess she didn't.
All right. And then I want to go over a little bit about the medical bills. So you don't have to get it exact. It doesn't have to be an exact number. But there was testimony in this case that Miss Ellis had $17,500 in medical bills from Dr. Mulliken, the plastic surgeon, and another $18,000 in psychological care through her work comp and other things.
Objection, Your Honor.
There was also testimony from Dr. Mulliken that he believed Miss Ellis could benefit from one more surgical procedure, another one, to make it better. The cost of that was $15,000.
Objection, Your Honor.
That's why he came and testified. He was trying to get that $15K for that new plastic surgery.
$15,000 that would be paid for that would, in Dr. Mulliken's expert opinion, it would make the scar better, meaning it would reduce, basically what I'm saying is there's still some scar on her face. And if you want to look at it, you're more than welcome. You can have her walk around, you can look at it for yourself. There is still some scar on her face. It's still there, and it still bothers her. So that's why I'm asking that not only you give her the $17,500 in her past medical bills for the scar, that you give her another $15,000 for the future scar revision treatment. She didn't deserve this. She didn't deserve to be scratched and cut and spit on and all these things. All of the things that happened to Miss Ellis are they're wrong. And we want to make this wrong right. And how can we do that? Through each one of you. You have the power to make this wrong right and close the books for Miss Ellis so she can move on with her life as much as she possibly could. And yes, the only way to do that right now for today's purposes is to reimburse her for the losses that she sustained. Those are the medical bills, the past, and the future. The other thing that is an important way of compensating Miss Ellis is for her pain and suffering. In every case where there's medical bills and there's medical damages, component of that is pain and suffering. There is really no way, there's no exact math to that. So for instance, if you said, I want to give her the $17,500, I want to give her the $15,000, and I want to give her another $250,000 for pain and suffering, you are allowed to do that. It is a number that you can come up with. During the 7.5 years that she's been suffering, you may say, I would like to give her $100 a day. For 1 year, that's $36,000. And for 7 years, that comes up to $270,000. We're not looking for millions of dollars like the defendant said. That's not what we're looking for. We're really looking for a simple amount of money that can make her whole, give her something that's fair so she can get some form of compensation, some form of closure, and move on with her life. That is all we're asking you to do.
No one in Chot Diggy in the building. What's good, family? I see y'all. Appreciate you joining.
So, when you go into the jury room, you'll be given a verdict form. And the verdict form will basically state, it covers all of the different areas of this case. The first section A is the assault and battery. They are in a sense separate because the assault is the swing and the battery is the scratch and the cut to her face. However, it's very clear. Did plaintiff Emani Ellis prove all of the following elements of battery? And then it goes down, it breaks it down. Defendant Belcalis Marlenis Almanzar touched Miss Ellis with the intent to harm or offend Miss Ellis. Miss Ellis did not consent to being touched. Miss Ellis was harmed or offended by Miss Almanzar's conduct. A reasonable person in Miss Ellis's situation would have been offended by the touching. I would say that yes, all four of those have been done here. So when you get to that question, there is going to be on the right side, it's not broken down into 4 parts. It's all as a whole. So if you want to give money damages to Miss Ellis, you would check yes. Okay, and then you go to the next question. Did Miss Ellis prove all of the following elements of assault? And again, it breaks down for you the 5 different parts. Miss Ellis acted with the intent to cause harmful or offensive contact with Miss Ellis. Miss Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner. Miss Ellis did not consent to Miss Almanzar's conduct. Miss Ellis was harmed, and Miss Almanzar's conduct was a substantial factor in causing Miss Ellis's harm. Again, if you want to give her money damages, you would check yes. That would be page 2, both of those. Then you have question number 3. Did Miss Almanzar prove all of the following elements of self-defense? So the defense is trying to argue that all the things that Miss Almanzar did were in self-defense. There is no testimony of self-defense here. In fact, Miss Almanzar herself, her position was, I didn't touch anybody and nobody touched me. So self-defense, no. You would say no. Then you can go, then question number 4 speaks about the damages that she suffered. Past medical expenses. That's where you would put in an amount of money through the testimony that you heard and through all of the exhibits. You would put an amount of money that you believe Miss Ellis incurred in this incident. So you will have in the jury room exhibit number 4. You'll have exhibit number 4. It's been marked at the bottom right corner. You will have exhibit 4-1 through exhibit 4-6, and then it will skip over and you will go to the bills, which will be 4-13, 4-14, and 4-15. If you combine all of these bills, you will get $16,500. So past medical expenses would be $16,500. That would be what you would write there if you want to give her the cost of all the plastic surgery she had to go through up until now. The future economic loss is the future plastic surgery. Dr. Mulliken stated that Miss Ellis would benefit from a future plastic surgery of $15,000.
We're going to skate to one song only. Lady Hump.
In that box.
What you gonna do with all
Pain
that
and suffering.
junk? All that junk inside my
Again.
trunk? I'm gonna get you drunk off my lady hump, my lovely lady hump.
I'm not skating to anything with references to lady humps. I don't even know what that means.
No one knows what it means, but it's provocative.
No, it's not. It's
Gets
gross.
the people going.
It's
Pain and
That's not.
suffering and future pain and suffering. The court read a time frame for you of how many more years Miss Ellis will live, and the jury instruction life expectancy 3932 basically states that Miss Ellis
will live for another 50 years. This is an estimate. It's not 100% certain, but it's the best estimate that we have based on all kind of statistics. She has 50 more years to live. So if you feel that she's going to suffer from this point forward, then you can award her money damages for the future. And if you feel that she sustained pain and suffering in the past, then you can award her money for the 7.5-year time period. And again, you'll all have the jury instructions in the back when you go into the jury room. And the jury instruction on pain and suffering covers a whole bunch of different things.
Hell no, to the no, no, no.
So I would take a look at that one because it covers all of the different things. Embarrassment, pain and suffering, disfigurement, all of those. So if you look at 3905, it talks about physical pain, mental suffering, and or emotional distress. And it basically says that there's no fixed standard for deciding the amount of these damages. This is a number that you will come up with. It won't be based on chance or a flip of a coin, but it will be a number that you come up with. If you decide you want to give her $500,000, you can do that. If you want to give her more, you can do that.
No, 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 no.
So for past non-economic loss,
no, I refuse.
you should put a number there. Because if you don't, the award will be thrown out. You got to have at least $1 there. You got to award some kind of pain and suffering. It's required. Now the amount would be up to you. A lot of times, some people say, well, 3 times medical bills, 10 times medical bills. This is an assault and battery. It's just not a simple car accident where it's just, some bumps and bruises. This is a serious, serious injury. Very serious, and Miss Ellis has been suffering for the last 7.5 years. What kind of weight do we put to that? What kind of number do we attach to that? I don't know what number you're going to attach to that, but for purposes of now, for example, you could write $250,000 for the past pain and suffering. This was a violent attack. She was violated. She has a scar to her face now. She's gone through all kinds of medical treatment that she didn't have to go to. So much life was lost from her, time-wise. You can't get it back. All this time that she's lost and feeling embarrassed and all of that. What is the value of life? It's significant. We all went through the pandemic. We all went through the pandemic and we realized that after the pandemic, the value of life is much greater because we realized what life is really about. Future non-economic loss. Again, that's going to be for the 50 years going forward. You could pick what number you feel. Maybe you feel she's recovered. Maybe you feel she deserves another 10 years. Maybe the whole 50 years. I don't know what it is. But you as individual judges will work together as a team to come up with a number for the future non-economic loss. Then it goes into intentional infliction of emotional distress. Did Miss Ellis prove all the following elements of intentional infliction of emotional distress? Number 1, Miss Almanzar engaged in extreme and outrageous conduct beyond mere insults, threats, indignities, annoyances, hurt feelings, or other trivialities that a reasonable person is expected to endure. Miss Almanzar intended to cause Miss Ellis emotional distress. Miss Ellis suffered severe emotional distress, and Miss Almanzar's extreme and outrageous conduct was a substantial factor in causing Miss Ellis to suffer severe emotional distress. If you believe that Miss Ellis sustains emotional distress, then you would, on number 5, you would say yes. Then number 6, again, it says, did Miss Almanzar prove all of the following elements of the privileged conduct defense? So again, it's similar to a self-defense of this, and it goes through a whole laundry list of different ways and finding excuses why the conduct was okay. So you would put no there if you believe that the conduct caused intentional infliction of emotional distress. Then number 7 has its own damages component. However, we've agreed and conceded to the fact that we don't want you to award damages for the same thing twice. It's not what our goal is. The goal is, if you feel there should be separate damages, aside from the assault and battery, for the emotional distress, then this is where you can give that amount of money. It'll be a separate and apart damage area for you to award more damages. Same breakdown. You can give past medical expenses, obviously, past and future medical expenses. In this, if you're awarded in the first box, then you would say, 0 and 0, because we're not asked double dipping here. That's not our goal. However, pain and suffering. If you want to give separate pain and suffering for the emotional distress, separate pain and suffering for the emotional distress from the past and the future, this is where you could do it. You could say, okay, well, we're going to give $50,000 additional for the past, $50,000 additional for the future, and then we're going to move on to the last part, which is negligence and contributory negligence. And again, this is all from the form that you're all going to see when you go into the jury room. And I'll close with this. Did Miss Ellis prove all of the following elements of negligence? Miss Almanzar was negligent. Miss Almanzar's negligence caused Miss Ellis to suffer physical harm rather than only emotional distress, and Miss Almanzar's negligence was a substantial factor in causing Miss Ellis's harm. So what that means is, for example, was Miss Almanzar, was Cardi B negligent in thinking that the plaintiff was disseminating her privacy to others, photographing her, videotaping her? If you believe that Miss Almanzar, Cardi B, was mistaken, then that would be negligence. She was negligent. She negligently thought that all these things were happening. And then again, it asks for the damages. Same thing. 0 and 0 for the past and future medical expenses if you have given it in the first phase. That's a good idea. So there's different areas. Maybe you'll say, well, I don't really believe there was this, but I believe there was that. So anywhere on the form, we would ask that you award Miss Ellis her medical bills of $16,500 for the past and $15,000 for the future, and in different boxes and different areas of this form to award her the pain and suffering that you feel is fair for all the things she went through, the assault, the battery, the emotional distress, all that she should be compensated for. And then there's a box, did Miss Almanzar prove all of the following elements of contributory negligence? Miss Ellis was negligent. Miss Ellis' negligence was a substantial factor in causing her own harm. Well, Cardi B testified that Miss Ellis didn't touch her, didn't do anything. There was no physical contact. That was the testimony of Cardi B. So how can she say that there was contributory negligence? What did the security do wrong? So the answer would be no. And then it goes to number 11. What percentage of responsibility for Miss Ellis's harm do you assign to Miss Almanzar? Say 100%.
And Miss Ellis,
Yo, the sign is
0.
real simple, B. It says wrap it
And the
up.
final page deals with punitive damages. Did you answer question 4 or 7? And you look back and if you did, damages.
No.
No, he's sleeping.
Yo, the sign is real simple, B. It says wrap it up. Wrap that shit up, B.
I don't think that's a...
And you put yes. And then it says, did Miss Ellis prove by clear and convincing proof that Miss Almanzar engaged in conduct with malice, oppression, or fraud? And then you would look at the case as a whole and kind of come up with your opinion. Did all of these things combined, did all of this thing that Miss Ellis went through? And remember, it's or, so it's either malice, oppression, or fraud. So if you agree that there was, then you would say yes here. So at this point, I'm going to turn it over to my counterpart. They will obviously contradict everything I will say, I've told you, and then I will have a chance to come back and rebuttal and clean up anything that was said. At this point, I'm basically Miss Ellis's mouthpiece, and I work with her as best I could to convey all of the things that she wants you to know. I worked with her personally to tell you all what she went through, and I did the best that I could with what I have. And we really, no matter what happens, whatever is supposed to happen will happen, because that's what's supposed to happen. And we want to thank you each individually for being here. Each of you as individual judges, we're thanking you very much. Thank you so much for hearing the story as to what Miss Emani Ellis went through, and I'm asking you to award Miss Ellis an amount of money that you think is fair that will make her whole for the losses that she suffered in this case. Thank you very much.
All right, thank you, counsel. You okay? You okay?
¿Qué puñetas?
Okay. All right.
¿Qué puñetas? ¿Qué puñetas?
I think a break would be appropriate at this point.
Does anyone want a break? We got started late. Okay, why don't we take a short break? Why don't we resume back at 11:25? In the meantime, please do not discuss the case with anyone, including other jurors. Don't form any opinions or do any research. We'll see you at 10:25. Or I'm sorry, 11:25.
Well, isn't this a nice surprise?
The absence of evidence is not the evidence of absence.
What?
Hey, yo, big shout out to Allie with the 5 gifted memberships. Y'all show her some love in the chat, drop her some coins, show TSC some love, Chan My Black is Golden some love. That was horrible. That was horrible. I would sue him for ineffective assistance of counsel because he spent all that time up there and didn't say
The
nothing.
modifier we.
Hold on.
It's probably, I wasn't going to get into it. It's generally not proper to include yourself in terms of what we all went through, but that's why I was overruling the objections. One note, and is this grandmother here?
Yes.
Ma'am, can I have you step forward? Can I have you step forward? And ma'am, you were previously sworn, and you understand you're still under oath? Sure. Did you have any conversations with alternate number 1 on Wednesday?
Alternate number 1?
The woman on the corner? The woman who's on the jury?
No.
You don't recall any interaction with her?
She sat next to me and she was waiting on a break, but we didn't speak.
You didn't speak with her? Okay. So you didn't talk to her about the trial at all?
Absolutely not.
Okay, all right. You were just seeing, we thought that there may have been some discussion between the two of you. You don't recall that? Okay, all right, thank you. All right. Something else?
Yes, Your Honor. Although you cautioned counsel that he can't argue things that are not in the evidence, he repeatedly did. He even started talking about Dr. Avila's treatment, even though he was excluded, over and over and over again. And all the jury sees is me objecting and Your Honor sustaining it. I would request that you admonish the jury to disregard all of the statements that you sustained objections to. I would also ask that you assign misconduct to counsel and that he be reprimanded because this has just been ongoing.
Okay, we can discuss.
I want to respond.
Well, let me do this. I will give further instruction to the jury about that the argument of counsel is not evidence and that they should disregard any comments that were not supported by the evidence. I will give that instruction. We can discuss whether or not we want to set an OSC after the trial for any alleged conduct. Okay.
Thank you.
Your Honor, may I please say one thing?
Yeah.
Please.
Go ahead.
I just want to note that you advised Mr. Rosen that if he were to argue to the jury that Cardi said that photograph was taken on February 24th, that would be a knowing violation of the professional rules, and that's exactly what he did.
Okay. Well, why don't we? I don't want to do it now.
Well, I have to say something about it.
You don't. I said we'll discuss whether or not we want to set an OSC, and we can address it then. Okay.
Thank you, Your Honor.
All right.
They so full of shit. I thought lawyers were supposed to have candor. When they supposed to be always honest when they in front of the court, but then they just let them get up here and lie with no repercussions. Fuck out of here.
The absence of evidence.
Just get up here and lie.
Evidence, the absence.
What? The truth is you are a liar.
That's crazy though. Shout out to our stream sponsors. Had to wrap that part up, and now we're gonna get to some other clips. We still got some clips from some of the past, some funny moments. Appreciate y'all being here. Hit that like, hit that subscribe, tap in, share with a friend, you dig? Let's see. Let's do this one.
When Miss Emani Ellis called you several months later and asked you to help her, what is the reason that you chose not to do so?
Well, main reason, I didn't feel like she was in the right. I felt like based off of her position, working at the office, everything was handled unprofessionally, and going back and forth. No, she didn't work at our office, but clearly Cardi B was a patient going, she had a purpose at that building where she worked at. So I didn't feel, I don't know what I would help her with. I don't think if I told my truth it would help her. So.
Were you aware that Miss Ellis was a security guard at your building?
Yes.
Do you understand that the security guard is supposed to go from floor to floor to make sure everything is safe? Are you aware of that?
I don't know the rules.
I'm sorry, what was your objection?
Irrelevant.
Assisting.
Had you ever seen Miss Ellis on other days aside from the date of the incident? And I will represent to you the date of the incident for purposes of all my questions will be February 24th of 2018.
Did you sustain any, well, straight. Let me take you a little bit back to the incident. So, when you were at the building and Cardi B exited the elevator on February 24th, 2018, what were the words that she used that were so hurtful?
She used a lot of words, and again, excuse my language, but she was like, fuck you, you fat ass bitch, that's why I'm gonna beat your ass. I'm gonna get you fired. Nigga this, nigga that, bitch ass nigga. That's why you do security. Ah, that's why you do security. Ah, she was sticking her tongue out. She was flailing her arms up and down. She was jumping up and down. Body shaming me. I mean, racial slurs, just a lot.
And did she spit on you?
She did.
Did her spit actually land on your body?
It did.
Why did you exit the elevator to speak with her after she said what she said?
I wanted to clarify the misunderstanding.
Did you also want her to leave because she was causing a disturbance?
At that time, she was causing a disturbance. She was yelling and screaming, and I did want her to leave.
And
objection leading.
As a security guard, were you working there as an extension of the owner to be able to make that kind of call, whether somebody should be told to leave because they're causing a disturbance?
Objection leading. My foundation calls for legal publicity.
Could you repeat the question, please?
I'm going to ask you a different question. Did the landlord hire you as a security guard to protect its building?
Yes.
Overall. And did you do that?
Yes.
For how long?
For about 4 years.
During those 4 years, did you ever have a problem with anybody else?
Never.
Not one time?
Not as far as I can remember, no. Not a perfect employee, but a good employee.
What up, Trakisha? So the not prosecution, but the plaintiff, which is old girl Emani, the counsel for the plaintiff just finished his closing statements. And then next up is gonna be Cardi B, the defense closing statements. Right now they on a short recess. And yeah, he did horrible, if you want to know. Yes, he did a horrible job closing. just to go ahead and put that out there. Appreciate you being here. Hit that like, hit that subscribe. Let's keep it going.
Minaj, right? How you saying that I got ragged by Riley when there is so many footages of that night, every single angle, and where am I getting ragged at? Why would I be here sitting in line like, oh yeah, I did this, I did that, knowing that the next day there's gonna be so much footages of that same night? And second of all, how you say that I was the wild animal, that I attacked you, that you was mortified, that you was humiliated, playing the victim, but now you're the gangster. You need to pick a side. Do you want to be the victim or do you want to be the gangster? You lie so much you can't even keep up with your fucking lies. First you're saying that you...
Do you know what the word ghetto means?
Objection, Your Honor.
Did Miss Emani Ellis call you ghetto?
I don't remember.
If someone called you ghetto, would that make you angry?
Objection, relevance.
Me?
Yeah.
If somebody calls me ghetto? It depends on how you're using it, but I don't really feel offended if you call me ghetto.
Did Emani Ellis tell you that you're stupid?
Your Honor, relevance.
So I don't remember that being no part of the testimony. I don't remember her saying that. I don't remember nobody else saying that. Was this just his opportunity to call her ghetto and stupid? He was like, I'ma just say it, see if I could get her mad. And that was no part of the testimony. Where did that even come from?
I really don't remember. She did. She was cursing at me though.
What were the words that she used?
You're gonna get the out of my building. You're gonna get the out of my building. I can do whatever the I want. Then it's like when I was telling her, it's like, why you was recording me? She said, it's my phone. It's my phone. You're in my building. That's what she was telling me. And she was like, yeah. She also was saying like, cause I don't give a who you are. I don't give a who you are.
Okay. And you remember her telling you that?
I remember that.
Those exact words?
Yes.
And did that make you angry?
Yes, absolutely.
Okay. When you get angry, you black out and maybe not realize what happens next?
Mm-hmm.
Do you know if you blacked out on the date of the incident? At any time? All right. And when you were yelling back and forth, and you were speaking and yelling and screaming. You were, correct?
See?
You were yelling and screaming at each other,
Yes.
correct? And you're doing that. Did your spit come out of your mouth and go onto Emani Ellis?
I don't think so. No.
But it's possible, right? Because when you're speaking, sometimes you use many, many words, the spit comes out, correct?
Objection?
You agree with this?
I'm sorry, what's the objection?
Well, relevant, sure.
Overruled.
You can answer.
I'm not sure. I don't think so. I don't think it'd be happening. I don't know.
You know, why don't we do this way? I'm not going to agree with for
I
this.
ignored him. I didn't talk to him.
Okay, all right, we're going to bring in the jury.
It's complete falsehood.
It's Mr. Anderson, too.
Wait a minute, what just happened?
And made some remarks to me that were rude.
You know, why don't we do this later? I'm not going to agree with for
I
this.
ignored him. I didn't talk to him.
Okay, all right, we're going to bring in the jury.
It's complete falsehood.
It's Mr. Anderson, too.
And before our counsel and the parties are present, as are the members of our jury and our alternate. And before we get started with the defense closing argument, you heard a number of objections during plaintiff's closing. Some were procedural or evidentiary in nature, but some of them were based on facts that weren't introduced during the trial. And so that's why I was sustaining those objections. To the extent that plaintiff's counsel mentioned any facts that weren't presented in evidence during the trial, please disregard any and all of those facts that he represented that weren't actually accepted into evidence during the trial. Okay? All right, with that, defense can give their closing.
Why tell him disregard his lies instead of telling him don't lie? That's stupid.
Thank you. Good morning, everyone. I'd like to start by thanking all of you for taking the time to participate as jurors. This is how our system works, and it wouldn't work without jurors. And I'd like to thank you on behalf of both Cardi, my colleagues, and myself. I'd like to just mention quickly that counsel argued that Cardi swore and used profanities in the courtroom and that was disrespectful. Actually, all she was doing was repeating under oath what was said. In fact, Ms. Ellis, plaintiff, used profanities to describe what she heard. Counsel used profanities, and I have to admit I used profanities, but just to tell you what was supposedly said. Cardi has never gratuitously sworn at any point in this courtroom, and the suggestion that you should be prejudiced against her because of that is just unfounded and offensive. Last Monday, it seems like it's a lot longer ago, but last Monday in the opening statements, I told you what I expected the evidence would be, and I told you that you can treat my statements and counsel's statements as promises of what they were going to show, and that I would ask you at some point today to decide who kept their promises and who didn't. I also told you that I would have a second chance to talk to you directly after all the evidence is in. The evidence is in, witnesses have testified, the exhibits have been admitted, and if you remember, the judge told you the first day that the way trials work is that bits and pieces of evidence come in. This is my opportunity to tell you how we think those bits and pieces come together and how they establish that Cardi, you should decide in Cardi's favor. First, there's a couple of things I'd ask that you keep in mind throughout the rest of the trial. If you remember, Judge Fusselman told you last Monday morning that the reason we have juries is because they have diverse backgrounds and they have common sense. He reiterated how important common sense was when he said We just need you to exercise common sense and evaluate, is this witness being consistent? Is this witness saying things, something that doesn't seem true? And does this piece of evidence fit in with all the other pieces that have been presented in this case? I respectfully suggest to you that using your common sense, there's only one possible outcome in this case, and that is a decision in favor of Cardi. Now, you'll be instructed that plaintiff bears the burden of proof of establishing her claim. She must convince you that the evidence shows that by 50% or more, her claims are valid. Now, there's another way of putting it is, and you'll see this in the jury instructions that you get from the judge, if plaintiff fails to prove that her version of what happened is more likely than not what did in fact happen, you must decide the case in Cardi's favor. The concept of a preponderance of the evidence can be demonstrated by this slide. That's 50-50. That's where the plaintiff has put on as much evidence of as the defendant of a fact, and you'll see that that's where people talk about the 51%. But it is crucial to keep in mind that plaintiff doesn't start at 50%, she starts at 0. She has to raise that needle from 0 to 50% and more. She has to go beyond 50%, or you have to find for Cardi. Third, there is no dispute that there was yelling and some curse words in the hallway at the medical building around 1:30 p.m. on February 24th, 2018. But the judge will provide you with the jury instructions, in fact he already has, that arguing, yelling, even using profanity is not something you can sue over. That's just part of normal life, and that is what we're supposed to bear. In fact, that would be crazy that someone could sue if they caused someone else to use profanity. The question really is whether Cardi ever struck plaintiff, and who caused this confrontation? Who caused the incident? And the answer is that the evidence in this case overwhelmingly proves that Cardi did not strike plaintiff, and Cardi did not cause this encounter. As a result, plaintiff has failed to establish, by the evidence you heard last week, that by a preponderance of the evidence, more likely than not, that Cardi was the cause. The way, I'm going to try and do this in a very organized fashion, and the way I'm going to do it is going to be demonstrated by this chart. And so we have on the left-hand side plaintiff's evidence, and then on the right-hand side defendant's evidence. Now, plaintiff started with her own testimony. Last Monday, she testified under oath. Importantly, though, in plaintiff's evidence, she never called as a witness either Tiara Malcolm or Dr. Finke, both of whom were present.
Objection, Your Honor.
Both of whom were present at this very time of the incident. Now, plaintiff's evidence, plaintiff's testimony, and we should keep in mind that just because plaintiff says something doesn't make it true, okay? She has her version, but the fact that she alone says it does not actually make it true. And later this morning, may stretch into afternoon, I'll tell you, or I'll identify the many inconsistencies in plaintiff's story over the course of this litigation, actually going back to February 26, 2018, when she did her incident report. In the meantime, plaintiff claims that she was assaulted and scratched or cut on February 24, 2018. But plaintiff did not see a doctor. She didn't go to an emergency room. She didn't call the police or make a police report.
Objection, Your Honor. Misstatement.
And she actually testified she did not know if the scratch that has supposedly ruined her life was even bleeding. She also testified last week that she didn't even put a Band-Aid on this scratch. What did she do? She claims that Cardi mauled her, basically, cut her face, and this woman went home, and what did she do? She took a nap. that was her own testimony. She took a nap. The fact that on February 24, 2018, plaintiff just went home and took a nap is corroborated by plaintiff's own T-Bell cell phone records for that day. As you'll see, and this was an admitted exhibit, you'll be able to see it, it's exhibit 200. She gets calls and she makes calls from 11:20 a.m. all the way to 3:35 p.m. and then nothing until 9:08. That's when she took her nap. That's what she did. She didn't call a doctor. She didn't go to the hospital. She didn't put a Band-Aid on her face. She took a nap. Now, importantly, when plaintiff testified as her own first witness in her case, she admitted that in 2021 she hit her head in a car accident. She's put on no proof that that wasn't the source of the scar, which is a pretty obvious reason that she would have a scar if she had one. And importantly, 2021, a car accident in 2021, is after plaintiff told Dr. McKenna in April 2018 that Cardi almost touched her with a fingernail. Not touched her with a fingernail, and I'll talk more about that later, but almost touched her. So after the plaintiff tells Dr. McKenna, her workers' comp physician or psychologist, that Cardi almost touched her, plaintiff was then in a car accident, hit her head, and that's when she went to Dr. Mulliken. She went to plastic surgery 4 years later after being in a car accident.
Objection, that misstates the testimony.
Plaintiff also testified, by the way, that she was in another accident in 2023 and filed another lawsuit over that one. Plaintiff has argued, and he said again today, that plaintiff's counsel has argued and said again today that plaintiff has some special status as a security guard. But she testified she became a security guard by having her fingerprints taken and sent to California. That's it. That doesn't make her a policeman. Also importantly, when testifying last Monday, plaintiff admitted that she knew on February 24, 2018, that Cardi was in the medical building because Cardi was going to a medical appointment. Plaintiff's own testimony establishes that at 1:30 p.m. on that Saturday, plaintiff could have been at that security guard booth that counsel showed you a photograph of. She could have been on her rounds, going through the whole building. She could have been in parking, checking, because that's what security guards do. But plaintiff, who has testified she was a fan, just happened to be outside Dr. Finke's office when Cardi B was showing up to see an obstetrician. From those facts alone, you can infer that she was actually laying in wait. She wanted to photograph and videotape Cardi. She would then be able to post it on YouTube, maybe start a new career, be a follower, I don't know. But from the facts you've seen in this and heard in this case, she very well could have done that on purpose. But even if we assume that plaintiff just happened to run into Cardi B in a 5-story building that afternoon, plaintiff testified that she knew Cardi thought that plaintiff was using plaintiff's phone to tell someone that Cardi was there and to videotape her. What would a reasonable person do at that point? By her own testimony, plaintiff had the chance to be professional and avoid all of this by putting her phone away. That's all she had to do. But the evidence is she kept that phone in her hand all the way through as she advanced on Cardi B and forced her into a corner in the hallway where Tiara Malcolm found her. Plaintiff also testified that after she was fired as a security guard, she got a new job that paid more money. That's why you don't hear any claim for lost wages or anything like that. She was better off.
Unfortunately, you're not claiming lost wages.
That summarizes what plaintiff testified to, and I'll talk later about the inconsistencies in it. But let's talk about her second and third witnesses, plaintiff's mother and grandmother. Both very charming. But her mother and her grandmother weren't in the hallway that afternoon. Her mother and her grandmother were not witnesses. And they testified that because plaintiff is the mother's daughter or the grandmother's grandchild, that they believe her. They don't need evidence. They just hear what she says. And that's understandable, of course. We all have relatives, and we hope our parents believe us, and our grandparents. But remember what Judge Fusselman said at the very beginning, common sense. Okay? We all know that parents are not with their children every minute of the day. We all know that children don't always tell their parents everything, and they especially do not tell their parents that they're embarrassed or guilty about what got them fired. That's what plaintiff left out when she talked to her mother and her grandmother. Is anyone surprised that plaintiff did not tell her mother and grandmother that plaintiff cursed and yelled at a pregnant Cardi, half her size, that plaintiff cornered Cardi in a medical building hallway, and that plaintiff knew she was probably going to get fired? Is that the kind of thing you'd say? Guess what, Mom? Guess what I did today? So it's completely understandable, using common sense, that the mother and grandmother would not know actually what happened. In fact, plaintiff didn't tell them that she had apologized in her incident report to Allied and the building for her own behavior. She left that out. Because I asked both the mother and the grandmother, did your daughter or granddaughter, tell you that? And they said no. So we know that plaintiff left that part out. Plaintiff's mother and grandmother both said that plaintiff is a peacemaker. Okay? Well, that sure doesn't square with the testimony of Tierra, Malcolm, Dr. Finke, or Cardi, and I'll discuss that later. And maybe what we take from that is she's a peacemaker when she gets her own way. We know what she's like. We've heard testimony what she's like when she doesn't get her own way. But there's another word for that other than peacemaker. It's a bully. Plaintiff's mother and grandmother both said they saw a scar on plaintiff's cheek. But on February 26, 2018, 2 days after the incident, plaintiff emailed her incident report to her supervisor, Jasmine, stating that Cardi scratched plaintiff's nose. So how is it that the mother and grandmother are saying that, well, when this happened or around that time, our daughter said that Cardi had scratched her cheek. But in plaintiff's own incident report, she said she told her supervisor Cardi scratched her nose. A nose is not a cheek is not a nose, and there is something wrong about what's going on because, again, apply common sense. Plaintiff's mother testified that she saw a scar, but she didn't testify when she saw it. Counsel asked her, did you notice after the incident that Emani Ellis had a scar to her face? Answer, I did. When did she notice that? 2018, 2019, 2020? We don't know. And in response to one of your questions, because the judge was kind enough to allow jurors to ask questions, which doesn't happen all the time. You were lucky in that regard. One of your questions, the judge read, and in response, plaintiff's grandmother said she spoke with plaintiff right after the incident. Right after the incident, she spoke with plaintiff. But plaintiff testified last Monday. Question, you didn't call your grandmother though, did you? Answer, no. Okay? So again, common sense tells you something is very wrong here. Now, plaintiff's mother and grandmother testified that plaintiff became depressed. If so, there could have been many different reasons for it. And for example, it could have been because she got fired, and as we'll see in a few minutes, she felt guilty. That's what plaintiff told Dr. McKenna in April. On April 26, 2018, plaintiff told Dr. McKenna that she feels guilty. Ultimately, the testimony of plaintiff's mother and grandmother just doesn't move the needle for plaintiff. They weren't there, and they're relying on what plaintiff told them. Now, plaintiff's third group of witnesses is Dr. Mulliken. Okay, that's what she offered to support her claim. Of course, Dr. Mulliken also wasn't there on February 24th, 2018. He didn't witness what happened. Dr. Mulliken testified that plaintiff came to him in November 2022, or more than 4 years after the alleged incident. Dr. Mulliken is a plastic surgeon, not a psychiatrist. So counsel pointed out that Dr. Mulliken testified that plaintiff told him she has post-traumatic stress, anxiety, depression, and headache. But Dr. Mulliken said, that's what she told me. I did not make a diagnosis to that effect. That's just what she told me. Now, Dr. Mulliken, and I hope he's not insulted, but his testimony was confusing and inconsistent. He testified that in November of 2022, plaintiff had a scar, had 2 to 3 scars, had 3 scars, and even plaintiff doesn't claim that she has more than 1 scar. But Dr. Mulliken thought there were as many as possibly 3. Somehow the no scar from the beginning turned into 2 scars and then 3 scars. Also, though, Dr. Mulliken's own photograph, Exhibit 228, which he testified was taken with a digital camera before any treatment, sure doesn't appear to show the scar. That is you'll have the actual, a copy of the actual photo. It's admitted as exhibit. You can look at it and you can decide. Counsel actually challenged you, look at the photograph, and we invite you to. If you see a scar, that's news to us. And this is before she was treated. Importantly, Dr. Mulliken testified at his deposition. You've all heard about depositions. They're under oath. It's just like a trial, except there's no judge. And that the claim scar was about an inch long and most likely made by a right-handed person who scraped or clawed downward with 3 fingers. Okay? That's what he testified to. That's what was in his deposition, and that's what he testified to here. But plaintiff herself claimed in her deposition that Cardi jabbed her with a straightened index finger, like this. That's not a scrape. Your Honor, I don't think I need to ask.
She got poked.
Permission, but we'd like to show the. Okay, then we'll show. This was played for the. This was played for the jury before. Okay. It's Cardi's testimony. Excuse me, plaintiff's testimony as to how she was supposedly cut by Cardi.
Was it a poke or a scratch? Did she poke you?
When you say it like this, she put her finger.
Pointing, yes, so like this, pointing her finger in my face, yes.
That is directly and irreconcilably in conflict with Dr. Mulliken's testimony that it was a right-handed person who scraped with an index finger and 2 other fingers downward. Those are completely different things. They don't correlate. The testimony is clear that plaintiff and her plastic surgeon have completely different explanations for the same claimed scar. And once again, common sense. Something's wrong here. Something is very, very wrong. Now, maybe the scar that Dr. Mulliken says he saw and his explanation, maybe it was a car accident. I don't know. But it is irreconcilable with plaintiff's own testimony that she was jabbed with a straightened finger. And to add to that, Cardi is not right-handed. I want to say that again. It's very important. Dr. Mulliken says that in his professional opinion, and counsel talked about how well-respected he is, that it was a right-handed person who scraped 3 fingers downward across plaintiff's face. But Cardi is left-handed. She is not a right-handed person and could not have done that. Plaintiff's counsel tried to get Dr. Mulliken to testify that a left-handed person might have made the claim scar. But that's not his opinion. He admitted that it would be hard, in fact testified it would be hard for a left-handed person to reach across and strike a person on the opposite them on the left side of the face. Now here's another important thing. Dr. Mulliken testified that he can't say when plaintiff got the claimed scar. He testified there's no way of knowing the age of the scar. That's important because plaintiff admits that she hit her head in a car accident in 2021, almost 2 years before the November 2022 appointment with Dr. Mulliken. And Dr. Mulliken also testified that he can't say whether the claimed scar was caused by an intervening accident or some other cause.
Objection, that misstates the testimony, Dr.
Ladies and gentlemen, you heard the evidence. Please rely on your recollection of the evidence and rely on your own recollection to the extent that it differs from counsel's representation.
And Your Honor, we also have a cite to the reporter's transcript. There are other odd things about Dr. Mulliken's testimony. For example, he calls a 3-minute long session of outpatient microneedling a small part of plaintiff's cheek, which serves, well, as reconstructive surgery and plastic surgery. A 3-minute microneedling session in his mind is reconstructive surgery and plastic surgery. Now let's talk about why he would say that. He has a broad version of surgery that enables him to charge an additional $11,000 for an operating room. He testified surgery is anything that includes a doctor, a nurse, a scrub technician, and an operating room. No matter what you're doing, even if it's microneedling, even if it's pulling a splinter out, you go into that room and he charges $11,000. Dr. Mulliken testified he is the sole owner of the surgery center with that operating room. So he has a strong financial incentive to use and charge for that operating room, whether he's doing real reconstructive surgery or microneedling. Now, perhaps because his photograph doesn't seem to show the claimed 1-inch scar, Dr. Mulliken also provided confusing testimony about hidden scars under the skin. I don't know if you remember that. It had my head spinning. But he never testified. There's no testimony from Cardi, from Dr. Mulliken, or anyone else that plaintiff has a hidden scar. In fact, it's supposed to be this, really big embarrassment that she has this, terrible scar on her face that, you can decide whether you've seen it. You've walked by her. If you see a scar, well, no one else. A lot of us don't, I should say. Dr. Mulliken also testified that he charged $17,500 on a lien basis, which means he gets paid only if plaintiff wins or if plaintiff pays him. But plaintiff testified under counsel's own examination on Monday that she couldn't afford a $15,000 or $20,000 plastic surgery bill. So we know she's not going to pay Dr. Mulliken. Dr. Mulliken knows that he is going to get paid, if at all, his $17,500, only if his testimony helps plaintiff recover money in this case. That is a big incentive, and because of that risk, he testified he added a 20% premium to his bill. That's plaintiff's side of the scale, which keeps disappearing. And it pales in comparison to Cardi's side. So, of course, Cardi's evidence starts with Cardi's testimony, which will appear shortly. Thank you. Cardi is one of the 3 eyewitnesses who directly contradict plaintiff's story about what happened that day. Cardi testified that in February 2018 she was pregnant. You may remember in this trial that plaintiff's counsel asked Cardi, why does that matter? You're pregnant. No one knows, but why does that matter? Well, it did matter, and Cardi testified, and you should consider, and I hope you remember Cardi's response. She felt her privacy was completely being violated, and that her medical issues are not anyone's business. Quote, especially something that is so sacred as your pregnancy. It's yours. No one knew she was pregnant. Her parents didn't know. And she shows up for an appointment, and this woman is photographing, filming her, and then getting belligerent. Now, I mentioned that Cardi testified her parents didn't know she was pregnant at the time, and it's common sense that no daughter would want their parent to find out that she's pregnant by social media. This was a secret. There were special arrangements made so that she could see an obstetrician while in LA on a Saturday. Now, Cardi testified that she came to Los Angeles for the NBA All-Stars weekend, and concerned, she made an appointment with the obstetrician for Saturday afternoon. I'll get to the photograph in a minute. Cardi testified that she got off the elevator to go to the doctor's office at about 1:30 on the 5th floor of that building, and plaintiff started filming and photographing her. Cardi objected, and plaintiff apologized at first, saying, "Oh, my bad," which is effectively an admission that she was doing what Cardi thought she was doing. Cardi testified that plaintiff wouldn't stop and just kept following her with her camera, with her phone out. Cardi testified that she was very concerned and nervous and confused by plaintiff's conduct. That is understandable. Cardi testified that she was concerned about her unborn child. Cardi referred to plaintiff as security heavy. She's a large woman. She's almost twice the size of Cardi. Cardi's pregnant, early in her pregnancy, and this person comes up to her in black boots and starts yelling at her. Cardi was concerned about her, and scared, frankly, about what she might do to her unborn baby. Cardi also testified she was confused. Why is this going on? Why is a security guard doing this? Why is she filming me? Why is she following me? Cardi also told plaintiff specifically that plaintiff was invading her privacy. But when Cardi told plaintiff to leave her alone, plaintiff went berserk. She yelled, it was plaintiff's phone. Plaintiff said, "That's my phone. This is my building. You can't tell me what to do." That's what Cardi testified, and it's consistent with what Tierra Malcolm and Dr. Finke testified. But plaintiff advanced on Cardi, screaming and yelling and forcing Cardi backwards down to the hall to a corner, coming chest to chest with Cardi, yelling at Cardi about how, this is her building. She can do whatever she wants. Now, hearing the yelling, the doctor's receptionist, Tierra Malcolm, and then the doctor intervened and tried to get plaintiffs to stop and leave. We'll talk about that in a few minutes. In the meantime, Cardi testified that she and plaintiff yelled and used curse words, but neither struck the other. Cardi did not strike plaintiff. Plaintiff tried but did not strike Cardi. Cardi testified.
I don't want to interrupt. We're coming up on a break. If there's a logical place to stop, please.
I can stop there if you want to.
All right. Why don't we stop there, folks? We're going to resume back at 1:30. In the meantime, please not discuss the case with anyone, including other jurors. Don't form any opinions or do any research. We'll see you at 1:30.
Talk about you don't want to interrupt. What you think that was? That was a big ass interruption. It's all good. We got some more. We could go back and check in what's been going on so far. Let me see what's up with the chat real quick. Shout out to everybody in the chat. Late Night Bacon with Mookie. Leah, what up, Miss Leah? I see you. Appreciate you joining. Barty said, be careful. Be careful with me. Do you know what you're doing? That's a song, but I don't remember how it go. I know that's a song lyric, though. But I don't think I said it right. Shout out to our stream sponsors of the day.
The absence of evidence is not the evidence of absence.
What?
Time for a comfort break. Y'all go ahead, get your snacks, get your zooms, get your whams, you know what I'm talking about? Roll up. Not that I can, I don't even know why I'm smoking. I ain't even got nothing right now. I need to go get something. But anyway, let's get back to it. We still got some more clips. Appreciate y'all being here. Let's see what we got. I want to hear this one again.
Did you sustain any, well, straight. Let me take you a little bit back to you. So,
That ass bitch, that's why I'm gonna beat your ass. Words,
what were the words that she used that were so hurtful?
She used a lot of words, and again, excuse my language, but she was like, fuck you, you fat ass bitch. That's why I'm gonna beat your ass. I'm gonna get you fired. Nigga this, nigga that, bitch ass nigga. That's why you do security. Ah, that's why you do security. Ah, she was sticking her tongue out. She was flailing her arms up and down. She was jumping up and down. Body shaming me. I mean, racial slurs, just a lot.
And did she spend?
Now here's another thing. You think a security is gonna let you scratch them in the face without her body slamming your ass or putting you up against the wall or anything? Like, once you hit her, then you have whatever you gotta do to get her out the building, allegedly. So you think she gonna really just let you just slap her? Like, look at her. Do she look like she gonna let somebody just poke her in the face or claw scratch her and then just act like nothing happened? Just yell? Yeah, right.
Spit on you?
She did.
Did her spit actually land on your body?
Racial slurs, just a lot.
And did she spit on you?
She did.
Did her spit actually land on your body?
It did.
Why did you exit the elevator to speak with her after she said what she said?
I wanted to clarify the misunderstanding.
Did you also want her to leave because she was causing a disturbance?
At that time, she was causing a disturbance. She was yelling and screaming, and I did want her to leave.
And as a security guard, were you working there as an extension of the owner to be able to make that kind of call, whether somebody should be told to leave because they're causing a disturbance?
Objection, Leading Life Foundation calls for legal publicity.
Could you repeat the question, please?
I'm going to ask you a different question.
The answer is no. You are not a part of that office. That's why they fired your ass. Because if you was literally a part of that office and they didn't fire you, they probably would have got sued for violating HIPAA laws. It's a dumb ass.
Did the landlord hire you as a security guard to protect its building?
Yes.
Black's Foundation.
Operable.
And did you do that?
Yes.
For how long?
For about 4 years.
During those 4 years, did you ever have a problem with anybody else?
Never.
Not one time?
Not as far as I can remember, no. Not a perfect employee, but a good employee.
And at the time when you saw Dr. Finke, you knew his name at that time, correct?
I didn't know his name. And for a while, when I was getting asked by lawyers like his name and like the receptionist's name, I didn't know it because I saw him one time. So I kind of like just forgot about him.
But when your attorney asked you for the name for purposes of trial, then you did remember the name.
I didn't remember the name. I told him there was 2 witnesses. The receptionist and the doctor. I told him it was a doctor. My doctor came out at the time, the guy that checked me, and the receptionist. She knows. She was there. He was there.
Who knows?
The plaintiff. She knows.
How do you know she knows?
Because that's who separated. That's who separated and got in between us while we was verbally arguing.
Who got in between you?
The female receptionist, she came out first and she started like telling her like, "You're security, what are you doing?" And then that's when the doctor came out. He was like, "Go to my office." And that's when I just walked away, and that was the last of it.
Okay. And 12.1 question. 12.1 subparagraph D. State the name, address.
It's a question. First, it mischaracterizes the testimony. It's compound. It's irrelevant to the merits of the case.
In written discovery, were you asked to provide the name of your security guard?
Your Honor.
Yeah, but why don't we? I don't know what you're trying to impeach her on because she hasn't testified to anything yet. You're saying it's impeachment, but you're not impeaching anything.
Did you respond to special interrogatory set 1 through your attorney? Your Honor.
All right, the court's going to sustain its own 352 objection. Why don't you move on?
You don't deserve nothing but an orange
Do you
coat.
consider Karan Newton to be a witness in this case?
No,
Sustained. Counsel, I need you to move on.
Man, that lawyer is dumb. I mean, like, ineffective. Let's say, yeah, he's very ineffective. The hell is he even talk about?
Do you know what the word ghetto means?
Objection, Your Honor.
Sustained.
Did Miss Emani Ellis call you ghetto?
I don't remember.
Over.
I'm not aware of that. He didn't tell me he talked to her.
Are you aware that your security guard, Karan Newton, on the day of the incident, apologized to Miss Ellis on your behalf?
Objection.
Sustained.
Did your security guard tell you that he apologized to Miss Ellis on your behalf at any time?
Objection. Asked and answered. Argumentative. Black foundation.
Sustained.
Have you ever been assaulted and battered in your life?
Objection, Your Honor.
Sustained.
Have you ever been abused in your life?
Counsel, if you're out of questions, you can pass the question.
Did you know that by your actions, you took away the feeling of safety for Emani Ellis?
All right. Counsel?
Yes, Your Honor.
Are you done?
I have a few more questions.
Have them be fact-based.
Yes, Your Honor. And do you agree that this incident, which we're talking about, why we're all here today, is occurred 7.5 years ago? Are you aware of that?
Yes.
Okay, and that's 2,741 days ago, based on my math.
Sustained.
How do you remember all of these details that you gave us from 2,741 days ago?
Objection. As to the days.
Over.
You can answer.
I mean, I remember like the basics. I don't remember like the whole. I remember the basics. Like it was, but it's not really much to remember. It was a in and out thing.
Have you ever used your nails to scratch yourself? Like if you get a bug bite? Have you ever done that before?
Objection, Your Honor. Relevant.
Sustained.
Did you have any jewelry on you at the time of the incident, whether it was on your hands or your neck?
Objection. As to the answer.
Sustained.
When you were in the hallway, did you block Miss Ellis from leaving? Even if it was for 1 second?
No.
Did she block you from leaving?
Yes. She blocked me from moving. She was right in my face.
He tried to slide in that leaving, and she caught it though. That's why she said she blocked me from moving, because she caught it. But he's trying to say leaving, because he keep on trying to make it like she was supposed to be leaving the doctor office.
She was right in my face.
Okay. And when you were standing there, were you were you facing Dr. Finke's office or a different side? Do you understand the question?
Objection. Negative.
I withdraw the question. When this whole thing happened, did you start to move around in a circle, or were you standing physically the same spot the whole time?
Objection. As to the answer.
She was moving around in a circle, talk about put him up, put him up, put him up, with her Pink Panther paws up. Hell no. Did you walk around in a circle? What? Shut up. She said my back was against the wall, dummy.
Sustained.
Put him up, put him up.
Would you consider yourself a peaceful person?
Sustained.
Yes.
And he was in the lobby area waiting for you?
That's the answer.
Sustained.
Okay. And when you left the building, you went to the parking lot, or was the car waiting for you outside?
That's your relevance.
Sustained.
From Tiara Malcolm and Dr. Finke and Emani Ellis, who were in that hallway. Were there any other people there?
No.
Did any other doctors come up to that floor?
No.
You're sure?
Absolutely.
How are you sure?
Objection.
Sustained.
Or doctor or someone else come up from the stairwell, which was close to the elevator area.
Objection. That's the answer.
Sustained.
Ask you one thing about when you were chest. I forgot to ask you one thing about when you were chest to chest. Did you ever touch Emani Ellis's face or nose with your finger?
No.
You never touched her nose like this?
No.
Thank you, Your Honor.
Cardi, do you remember, did you get your nails done before you came to LA or after?
It's most likely before LA.
Okay. But they were the same nails the whole time you were here?
Mm-hmm.
Okay.
Yes.
I have no more questions for this witness, Your Honor.
All right. Read it.
Focus on the left hand or right hand. Your Honor, I would want to zoom in the photograph just to show the nails better than what we can see.
Can we do that?
If you wanted to scratch someone with those nails and cause them to have a cut to their face, you could do it with those nails, can't you?
Sustained.
The nails that we see in this photograph, are they sharp in your opinion?
Objection, Your Honor.
Photo. Well, it's referring to the photograph now.
No, they are not sharp at all. Those are not sharp nails.
Okay. Now, you heard a witness, Tiara Malcolm, a few moments ago in the last 15, 20 minutes. She testified that she also had a cut to her face. Do you remember hearing that in court?
Yes.
So how did she get the cut on her face? If you know. How do you, if you know?
It wouldn't be for me.
Is it possible that when you were reaching over, you cut her face?
Objection.
Sustained.
And the rhinestones that you see there, you consider those to be flat?
Yes.
I'm just joking with you, brown sugar babe. Go ahead, check it out. It's only about 3-4 minute song. It's a video, and I'm mad. I watched the whole video thinking Lucci was gonna show up. He not even in the video, but he on the song though. So if y'all want to check that out, it is available. We're gonna keep it rolling.
Shit brazy, bro. Cause it's like, you know, cause you know I know something. You know I don't want to give him the benefit of the doubt that he.
Yes.
Okay. And at 1:40, you made an 8-minute phone call?
Yes.
Okay. And whose phone number is that?
Which time are you referring to?
310-403-3656.
I'm sorry, can you say that again?
Yes, absolutely. I apologize. 310-403-3656.
I don't know who the number belongs to, but it's probably a family member of mine.
Is that Nicholas Jackson's phone number?
Probably yes.
I didn't tell anyone that I saw her.
Could you please answer the question, though? I can repeat it if you like.
Okay.
Isn't it true that as a security guard who had been trained, as you said, and worked for 4 years, you knew it would have been improper for you to tell people that Cardi B was a patient at a medical facility?
Objection, asked and answered.
Overruled.
It would be improper, but I did not tell anyone I saw her.
Move to strike everything after improper.
So maybe I just want you to answer the question, okay? Don't, if you can answer the question with the yes.
Talk about she never been in a fight. Yeah, right. She probably got a heavyweight championship belt out there where she from. They all know her. They don't fuck with her. Talk about she don't fight. Looking like little... Nah, let me stop.
No question. Essentially, it's no.
Yes, Your Honor.
When you saw her today, did you notice that her fingernails were very short?
Yes.
Does she usually wear them that short?
Objection. Leading.
It's also lacks foundation, sustained.
Have you seen, well, strike that. For how long, were you a fan of Cardi B before this incident?
I was.
What kind of fan were you?
I enjoyed her music. I was interested in going to a concert. I didn't have any problem with her.
Did you ever go to see her in concert?
I had tickets to go to see her, but I never went after this incident with her.
Did you ever go to see her in concert?
I had tickets to go to see her, but I never went after this incident.
When were you supposed to go see her in concert?
I'm not sure of the date. It was sometime in 2018.
With your lying ass. So you was about to go see her that year, but instead you decided to record her in the doctor's office and cancel your trip. The hell out of here with that bullshit.
The truth is that you are a liar.
And you're very close with your grandmother, Diane Schmidt, is that correct?
Correct.
How old is your grandmother?
She's 79.
Does she have information about this incident? Objection. Speculation, lacks foundation. Did you show your grandmother the scar on your left cheek after February 24th of 2018? Overruled.
Could you repeat the question, please?
Did you show the cut on your left cheek after February 24th of 2018 to your grandmother, Diane Schmidt?
Yes.
When did you first start?
I first started rapping in 2016, but I became a superstar for rapping in 2017.
Okay.
So, just being blessed then. So.
All right. And why was it, aside from what you've told us?
She was blessed in. Ain't she from a gang? You know what blessed in mean, don't you?
That you feel being a freshman, being pregnant, the two didn't match. Was there any other reason aside from that you wanted to keep your pregnancy a secret? Earlier, you testified that when you went to the doctor's office on the date of the incident, you wanted to keep your pregnancy a secret, correct?
Yes.
And the reason you wanted to keep it a secret was because you were a rapper, correct? Why did you want to keep your pregnancy a secret?
My career. I didn't tell my parents yet. I was just very overwhelmed.
And when you thought that your secret was being violated, it made you angry, correct?
Objection. Argumentative. Mischaracterizing. Testimony. Lacks foundation.
Overruled. You can answer.
Yes, I feel like my privacy was completely being violated. I wouldn't want to be anything that had to do with my medical records or anything. Even if I do cosmetic surgery, I don't want people to be in anything that has to do with medical in your business. It's just, especially something that is so sacred as your pregnancy is yours.
And you would do anything to protect that privacy, correct?
Objection, Your Honor.
Sustained.
And aside from your assumption that you were being recorded by Miss Emani Ellis, was there any other assumptions that you had at the time of the incident?
Objection, argumentative. This characterizes the testimony.
Sustained.
You had a belief, a state of mind, that Emani Ellis was recording you at the time of the incident, correct?
Objection, outside the scope of redirect. And
Sustained.
To protect that privacy, correct?
objection, Your Honor.
Sustained.
Dang, my bad. I'm talking on mute. But dang, bro, just give it up. Let it go. Why you over here acting like you own one when you really not? I guess they have to do that though. They have to lie because the case was shit. Like Doug Weinstein say, the case was shit. Big facts.
I want you to think of it like a hamburger bun. You're the hamburger, and the two of them are the buns. How did you get in between them? Did you physically push them apart? Did they magically back up from one another? How did you get in between them? How?
Just like you said, it was 7 years ago. So I'm walking upset because of what I'm seeing, and that's just how I am when I see. I mean, it's not like I see it all the time, but seeing what was going on, I just immediately. That's just what I did. I didn't really think about. I didn't really have a plan. That's just what I did to try to calm it down.
Okay. And Miss Ellis, who's sitting to my left, you heard her cursing at Cardi B on the date of the incident?
Yes.
You actually heard profanity.
I actually heard profanity.
Many different ones.
Yes.
How do you know it wasn't Cardi B that was using the profanity?
They have two different voices.
Okay. Was Cardi B using any profanities on the date of the incident?
Yeah, she was upset.
Did she use profanities?
Profanity, yes.
F word,
curse words.
bitch, F you, all that, correct?
Yes.
And you don't really know what happened before you got there, correct? You have no way of knowing.
I wasn't there before I got there.
So if there was any physical contact, whether it was spitting, scratching, or no. And you don't really know what happened before you got there, correct? You have no way of knowing.
I wasn't there before I got there.
These nuts. Got him. Got him.
So if there was any physical contact, whether it was spitting, scratching, or cutting someone's face, you wouldn't know that because you weren't there during that time period before you got there, correct? Do you understand my question? Let me withdraw it. In the, let's just call it the 40 to 50 seconds while there was a confrontation, I'll give you that estimated time. During the 40 to 50 minutes of seconds when they had their confrontation, you would have no way of knowing what happened during that duration of time because you weren't there. Is that fair?
Yeah, I wasn't there. I only heard.
No, anything could have happened, right?
Objection, speculation.
Correct?
Yeah, I wasn't there.
Emani Ellis could have hit Cardi B.
Counsel, she wasn't there.
Okay,
So.
I withdraw it. When you saw Cardi B that day, you spent time with her, right? In your medical office, correct?
Not a lot of time, but I spent the time from taking her to her exam room, making sure she was okay, and once the last patient was checked in, I was out of there.
Okay. And how long did you spend with her?
Not that long, maybe a minute, if that.
When the patient went.
You mean when we went into the, just to make sure you're safe?
No.
when we went into the office, how long did I spend with her? Yeah, maybe
15 minutes, half an hour?
no. I was still ready to go. Maybe a minute.
Did you notice that she was wearing, well, strike. Do you notice that she had fingernails? Did you look at her fingernails?
I don't remember that.
Did you notice that Cardi B had long fingernails on the date of the incident?
I don't recall none of that. All I recall is going back to crib.
Evidence and argument.
Did you see the size of Cardi B's fingernails on the date of the incident?
I don't remember her having or seeing her nails.
And have you ever seen her before? Does she wear long fingernails?
I don't know what she wears.
On the date of the incident, would you agree that because you did not look at her fingernails, you have no idea as to how long the fingernails were on the date of the incident?
Objection.
True?
Calls for speculation, lacks foundation.
Assisting.
When you said that you saw arms flying,
Hey, is it just me, or she kind of looked like the plaintiff? I just now seeing them side by side. That looked like her sister almost, huh?
you also testified a moment ago that you weren't sure whose arms were flying, correct?
Mischaracterized testimony.
Overruled.
I believe I stated I was facing Miss Ellis. So Cardi B was behind me.
Right.
So I could only see the arms that were flying in front of me. I can't recall. She was behind me, so
Right.
I think I would have felt something behind me.
Okay. So if Cardi B had taken a swing, you would not be able to see that.
Most likely I would. Oh, sorry.
See, I'm not talking about feeling. Would you agree that because Cardi B was behind you, if she took a swing without touching your body, you would not be able to see that? True?
Mischaracterizes the testimony and is calls for speculation.
Overruled.
I didn't see her hands flying on the side of me.
I understand that. But
Yeah.
again, I would like to know the answer to this question.
What was your question? I'm sorry, I forgot.
Of course. So the question is, because you were facing Emani Ellis,
Hypothetically speaking, of course.
you have no idea what Cardi B was doing at that moment, right?
Objection.
So if Cardi B was...
She was pretty much like the back of this chair. That's how close she was to me.
I understand.
So I didn't feel anything or see any hands come from behind me.
Understood. But if Cardi B took a swing, because you were not facing her and you were focusing on Emani Ellis, and you don't have eyes in the
No, I
back of
didn't
your
see
head,
her hands.
you would not be able to know what she was doing.
Right.
So if she took a swing, you wouldn't be able to know. Fair?
Okay, yeah. Let's see.
As far as the...
It was just bleeding a little bit.
It was bleeding.
The absence
Yeah.
of evidence is not the evidence of absence.
What?
Basically, he just said the absence of evidence is not the evidence of absence. Shout out to our stream sponsors, Ali, TSC, Chad My Black is Gold. Appreciate you, family.
Yes.
Okay. How did that cut get there? I withdraw the question. Did that scratch or cut or anything get there at the time of this incident?
Yes, it definitely wasn't there before I went outside.
Okay. All right. So now we're going to get into this. There's only three options, and you could add more if you want, but I'm going to give you three. The cut came from you, the cut came from Ellis, or the cut came from Cardi B. Or make up your own. Where did the cut come from? And if you don't know, you can say, I don't know. Do you know?
It definitely didn't come from me.
Okay, so that's out. You got two more.
And
Ellis and Cardi B. Or
Cardi
your own.
was behind me, so the only assumption that I had was it was from Miss Ellis because she was facing me.
Okay. But did you ever see Miss Ellis take her fingers or her hand or any other object and cause damage to your head? Did you ever see that?
I seen hands trying to reach over me, so like I said, the adrenaline and everything was going so fast, but being that she was in front of me and hands were going like this, that's the only realistic assumption I can have, is that that's why I got cut.
But you're assuming, correct?
Objection.
I think you're asking her to assume, counsel.
Are you assuming?
Your Honor, objection.
Yeah, why don't we move on?
We're asking you to assist her in some way to be her witness, correct? That was the purpose of the call?
Objection. Calls for speculation. Purpose.
Did Miss Ellis's attorney contact you?
I don't remember that.
Did Miss Ellis ever come inside your office at any time between the date of the incident and today?
Objection relevant.
Sustained.
Do you know if Miss Ellis spoke with Dr. Finke at any point?
Objection relevant.
Sustained.
Just a hot mess. Flesh of the Gods, good to see you. Good to see you.
As far as your background, do you have any professional degrees?
I got my AA at West LA College. I'm a real estate agent.
On the date of the incident, because Cardi B was your patient, you felt that it was necessary to go outside to bring her inside to help her get inside for the medical appointment, correct?
Objection relevant. Ask an answer.
Sustained.
I have no further questions. Thank you.
All right, you're right.
No, Your Honor. Thank you.
All right, any questions from the jury? All right, I think these questions are appropriate. Ma'am, when you did you actually close your office to maintain privacy for Cardi B?
Yes.
And when you do that, was it your custom and practice to also notify the building security?
You think the security wouldn't know that it was closed for a celebrity, or they don't know when a celebrity is coming because y'all close the office at a certain way at a certain time and make them the last client?
I honestly don't know if that was done or not.
Did you normally do that, or were you?
That wasn't my task, no.
Okay. Do you recall the N-word coming out of Cardi B's mouth?
No.
Can you describe Cardi B's emotional state during and after the incident?
Upset, emotional, worried about the reason why she was there. I don't know if I'm sure. But.
You don't know the details?
No, I don't know if
in terms of the medical issues? I mean,
yeah.
Testimonies that she was there for a pregnancy checkup.
Yeah, so just concerned about that and being upset about her privacy.
Did you notice whether Miss Ellis had a phone or a camera during the incident?
She had a phone in her hand.
She did have a phone in her hand?
Yes.
All right. Thank you for coming down.
Thank you.
Subject to recall.
Did you subpoena her?
No.
Then I don't think it's subject to recall. All right.
No further questions, Your Honor. Thank you.
All right. Any redirects?
No, Your Honor.
All right. Any questions from the jury? I'm not seeing any hands. All right. You can step down then. All right. I think we're not going to have another witness before lunch, or I'm sorry, does plaintiff have another witness for after lunch?
We do not, Your Honor.
All right. Does plaintiff rest?
No, Your Honor.
Well, are you going to have a witness after lunch?
Cardi B said I pose on that ass. Hey, hold on. I've recorded a clip of her looking pregnant. Do I got that clip? Hold on. Where is that at? Oh, it's not over there. Is it over here? Is this it? Nope. Okay, well, I'm gonna have to look for that and see if I can find it. I don't know what I did with it. I had the clip of her walking out the courtroom. I know I saved it, but I don't know where it's at because it was a couple days ago. But so real quick, while we waiting on them, I ain't gonna play too much of this, but did y'all see the new release of the body cam footage of Fannie Willis' daughter when she got arrested? First, they was only showing one body cam, but they just released the body cam of her daughter. I'll put
Hi, man. How you doing? I'm Officer Hale with the Tyrone Police Department. The reason I stopped you, I figure you probably know, I saw you on your cell phone back there at the red light. Was there a reason you were on your cell phone while you were driving?
Yeah, my mom was checking on me because I'm pregnant.
Gotcha.
So,
okay.
That's it.
Can I get your driver's license, please?
Yeah, I'm looking for it. That's fine.
Just hang tight for me. Okay, I'll be right back, all right?
Or driving with suspended revoked. The suspense date is 05/13.
Your license is showing suspended. Were you aware of that?
No, because I just paid my stuff off and got my license back in May.
Gotcha. Well, it's showing it's been suspended since the 13th of May.
That's when I got it back, though. Like.
Gotcha. Well, that's what it's showing in the system, and we just had that confirmed through our dispatch. So right now you don't have a.
Nowhere, because I just took care of some stuff in May.
Gotcha.
Yeah.
Who's this in the car with you?
It's my sister.
That's your sister? Does she have a valid driver's license?
I'm not even sure if it was suspended, but I know I didn't have a valid driver's license in Georgia because I got a state ID in Texas, and I apparently can't have one in both.
Put your hands behind your back for me.
You arresting me?
Yeah, you're on arrest right now for driving under suspended license.
Can I tell my sister?
Yeah, I am going to let you talk to her, and with your permission and stuff, going to let her, if that's fine with you, take your vehicle and stuff and get that removed from the vehicle as long as she has a valid license, okay?
Yeah. He said you can take it off. Okay. Because he said my license. And call Mom and Casey.
2 fingers right there, that's good.
One, I need your phone password. Where is she going at the moment?
She'll be, one sec. Sorry, I'm not trying to get your hair caught up in here. Put 2 in there. Double up.
You're 145 Johnson Avenue.
Okay, let me see.
Who's taking possession of the vehicle?
I'll check in 1 moment. So if not, it'll sit here and we'll have somebody pull up. I'll stay with it until then.
Gotcha.
Hey.
All right, so let me sort of explain what's going on.
Okay.
You're being arrested right now for driving unsuspended. I know you think you took care of it back in May. I'm not sure for what sort of happened with that. All we can really tell right now is that your license is suspended. It has. Now, as far as the process and everything, like right now, it's basically like a traffic citation as far as the arrest. You're going to know your bail amount and everything by the time you get there. You're not going to have to wait to go before a judge or anything like that. So you most likely, depending on how long it takes her at the jail, depending on the time and how busy they are at the moment, you could probably be out in just a handful of hours here. Just don't quote me on that, but that's typically how it goes. It just sort of depends on how busy they are. Okay. Do you have any sort of questions or comments or concerns or anything like that? Just like I can answer for you right now. All right, turn around. I'm gonna do a brief pat down. You don't have any weapons or any contraband or anything like that on you at all. Anything that's gonna poke me, stick me, or hurt me in any way. Walk me over here.
I'm gonna just go ahead and go so they can get me processed. So call Mom and stuff.
Careful now.
Sorry.
you out.
Oh my goodness.
My bad. I probably should have put a trigger warning or something before I posted that. Y'all seen the Woody pic, man? That shit look crazy. Trigger warning.
I'm gonna reach over and seatbelt you just for safety here. I'm sorry. Let me pull your hair here, but it.
Yeah, I didn't just took that picture. On the 13th, and they issued it on the 14th. That makes no sense.
That's what it's showing in the system
like
as.
you see that doesn't make sense. Like I'm not getting upset with you, but like that's stupid. That's a processing issue.
I'm not saying that doesn't happen. If it does, that's going to be something you're having to work out when you go to court for your for this. All it's telling me right now is your license suspended. I had that confirmed through our dispatch.
No, that's fine.
You can see it right there. That's all we have to go by.
That's fine.
Alrighty. I'm gonna close the door. Just watch out. I don't want to hit your knee here. Okay.
Are you talking to Casey?
Yeah, he's on the way.
Let me see. Let me talk to him.
Mom's calling again.
Oh, Casey's coming to get it.
Mom.
My boyfriend's coming to get my car.
Gotcha. What's his name? Just so I can put that down.
Larson Carson. CARLO.
CARSON?
Yeah.
Awesome. And you said your phone's in the car?
She has it right now.
Oh, that's the one that my corporal's on? That's the one my corporal's using right now?
Yeah.
Okay.
Calling me again. Maybe I should just send him where you're going since you're... Yeah, I'm going to send him where you're headed.
Look, Mama looking like us. The windshield's a little dark. Oh. Oh.
Hey, how are you?
Doing well. How are y'all?
Excellent.
Wasn't that some shit when this video first got released? After all this, she talking about, nah, we don't talk to each other no more. We're just friends. Oh, we're friends. We don't talk to each other no more. And then they pull up in the same car in their pajamas.
Mom, Dad, what's the...
Just a friend, yeah.
Okay.
Connie, nice to meet you.
So, hey,
Nice to meet you. What?
So, apparently,
Nice to meet you.
apparently her license is suspended.
News to me, okay.
For something. Doesn't tell us what for or why or where, or that's something she's going to have to call DMV to find out. She's gone over to Fayette County Jail, which is right in the Fayette.
I think Trump suspended that shit. Trump was like, well, we got you.
Bell Square. It's 145 Johnson Avenue. Yeah. Normally, I would say a couple hours is the process. It just depends on how busy they are and like that, okay? The driving on the suspended's basically a traffic citation. She's got to have her fingerprints done and picture taken, then she can make her bond. You can pay it cash, use a bondsman, be 10%, whatever. They've got a list of people over there, too, that you can choose from and use whatever. Where was she stuck? So the vehicle's registered to her. Okay. I don't know if it was on a flock hit or if the officer observed some kind of traffic infraction. It wasn't me. I didn't make a traffic stop. He's already gone and got her going. Okay. So whatever the case may be, when you run the tag, it obviously gives us the vehicle information and the registered owner, and it's already in the system that she has the invalid license. Yeah. So upon that, we just verify that it is that person driving, or stop the car first at that point. How you doing, man? Take your time. Straight that way.
Alright, Miss Wills. Here's going to be the citation today for driving on suspended license. I'm just going to give you a warning on the cell phone. I'm not going to. You've been cooperative and everything with me, so I'm not. Just make sure we're driving. We're staying off of that and not. And if we need to make a stop, make a call or text or something, make sure we're pulling off and doing that instead of doing it while we're operating the motor vehicle. Okay. You do me a favor and sign for me here, right next to the X, for the citation for driving while suspended. Back to where we were here. Also, I think I might know what sort of happened with your suspension license. I think...
Hold on. Pay attention to this part.
Bruh.
Listen to why he tell her her license is suspended. Just listen to it. Hold on. Look how she looking. and it got suspended the day she went to get it renewed. The day she got it renewed, it got suspended. But listen to the reason though. Watch.
Like you said, it was suspended at one time, and then you went through the process of getting it fixed. But when you had gotten it pulled over or suspended for driving on suspended license, that also created another license suspension. Had gotten it, I think, like you said, it was suspended at one time, and then you went through the process of getting it fixed. But when you had gotten it pulled over or suspended for driving on suspended license, that also created another license suspension for driving on suspended license. So that's, I think, what sort of...
Wait.
Monkey shit.
He said it was suspended and you went and got it fixed, but during the process of getting it fixed, it got suspended again because it got suspended because it wasn't fixed, but it was fixed, but it wasn't. I think I know why now. It's starting to make sense. You just got to think about it. It all starts to make sense once you think about it.
That would be the right front, the right left side. Front.
Cause that to happen. I know what sort of happened with your suspension license. I think, like you said, it was suspended at one time, and then you went through the process of getting it fixed. But when you had gotten it pulled over or suspended for driving on suspended license, that also created another license suspension for driving on suspended license. So that's, I think, what sort of caused that to happen. The bond amount's not super high or anything like that. You don't got, I believe it's going to be $800, which it's not that bad, and plus you don't got to wait to go for a judge or anything like that. It is going to be a must appear on the citation, so your court date for that's going to be October 24th.
Pay the whole thing, the bond?
Yeah, you got to pay the whole bond amount for that to be released, but that's going to be something you have to work out with the jail staff. It is going to be must appear for the citation for October 24th. That court date's going to be on there. If you have any other questions or anything like that, you can call the number on the back of the citation, and they can sort of answer you any questions or concerns or anything you have, okay? Gotcha. Do you have any questions or comments or concerns or anything for me right now? All right. I understand it's inconvenient and everything, and it's not so, but it's not the end of the world, okay?
In the end, Kanaya Willis was arrested for driving while license suspended and was issued a warning for unlawful cell phone use while driving. She was later released, and her vehicle was recovered by her mother, Fannie Willis. Did the officers handle it right, even after realizing who she was?
Shut the fuck up. Did the officer get it right, even after realizing who she was? Shout out to them for dropping that video, though.
Welcome to Flesh of the Godz.
Well, isn't this a nice surprise?
When did you first start?
I first started rapping in... I'm not aware of that.
Any other people there?
No.
Did any other doctors come up to that floor?
No.
You're sure?
Absolutely.
How are you sure?
Objection. Sustained.
Or doctor or someone else come up from the stairwell, which was close to the elevator area.
Objection. That's the answer.
Sustained.
Morning, Cardi!
to that scoop, and we're going to get all the money we need to send that girl to university.
Everyone talks about, everyone's about Jesse Smollett, Cardi. Does the president have to denounce these kind of things?
Hold on. You absolutely right, Miss D56. How can I play Little Miss Willis without playing Everybody Can Get It? Ah, then it's frozen. We'll just leave her there for a minute. Let's get up to the next one. But yeah, Little Miss Willis, I thought Fanny said everybody can get it.
Everybody can Lady Justice is blind. Everybody can get it.
What y'all think? Is that pregnant tummy? Or she just still got a little beer on her breath from drinking 40s and shit? Everybody could get it except Lil Fanny. That's a fact. What y'all think right there? It look like she pregnant? She didn't waste no time, huh? Got right back to it. She said, you can do it if you put your mind to it.
Minaj, right? How you saying that I got ragged by Riley when there is so many footages of that night, every single angle, and where am I getting ragged at? Why would I be here sitting in line like, oh yeah, I did this, I did that, knowing that the next day there's gonna be so much footages of that same night? And second of all, how you say that I was the wild animal, that I attacked you, that you was mortified, that you was humiliated, playing the victim, but now you're the gangster. You need to pick a side. Do you want to be the victim or do you want to be the gangster? You lie so much you can't even keep up with your fucking lies.
From cameras, her bodyguards surrounding this.
We're aware of no evidence.
From cameras, her bodyguards surrounding her with big black umbrellas as they rushed her into the 109th precinct. Charges of third-degree assault and reckless endangerment.
Cardi B, can you tell us what happened?
But behind that smile, only
Day 2 of her civil assault trial. The hip-hop artist is accused of physically and verbally abusing a security guard in 2018. The plaintiff in the case, Emani Ellis, claims that Cardi B attacked her outside of a Beverly Hills medical office at a doctor's appointment. ABC News' Melissa Don is joining me now for more on this. So,
with her 2020 private. Well, that's what happened, is that it was not. There was a security guard there that took out phones, and that's when an alleged incident occurred. Well, 2 years later, in 2020, Emani Ellis, that was the security guard that was working there, filed a civil lawsuit against Cardi B, and that's when we first learned about this incident in, of course, all of these civil court documents. Well, fast forward 5 years later, this is now when we're seeing this civil court play out. Today is day 2. Yesterday, of course, day 1 is when we first heard from that former security guard, Kana.
And it sounds like we also heard from Emani Ellis yesterday, who took
hey, it's Cardi B. She says in that moment, because of her reaction, that's when Cardi B came over to her. There was a verbal altercation and then a physical altercation. That's where she's alleging essentially that Cardi B scratched her cheek with one of her fingernails, trying to snatch one of those cell phones out of her. And essentially, in that moment, that is when Emani Ellis says that it was very violent for her. But Cardi B is basically saying, look, there was a verbal situation that happened, but nothing physical happened. Now,
did you sustain any on February 24th, 2018? What were the words that she used that were so hurtful?
She used a lot of words, and again, excuse my language, but she was like, fuck you, you fat ass bitch, that's why I'm gonna beat your ass, I'm gonna get you fired, nigga this, nigga that, bitch ass nigga, that's why you do security, that's why you do security, she was sticking her tongue out, she was flailing her arms up and down, she was jumping up and down, body shaming me, I mean, racial slurs, just a lot.
And did she spit on you?
She did.
Did her spit actually land on your body?
It did.
Why did you exit the elevator to speak with her after she said what she said?
I wanted to clarify the misunderstanding.
Did you also want her to leave because she was causing a disturbance?
At that time, she was causing a disturbance. She was yelling and screaming, and I did want her to leave.
This is EL, but it's higher?
No, 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 no.
This is EL, but it's higher?
No, 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 no.
So that type of shit, I don't do around my nigga.
Nations, this is gonna be your first televised performance since you gave birth, right? Yeah. How are you feeling?
I feel so nervous. My stomach been hurting. I've been farting all day because I'm just
Why are you farting?
so nervous. You know, I haven't performed ever since. You know, I haven't performed ever since my baby. Why
are you farting?
So nervous. You know, I haven't performed ever since my baby. Ever since.
Right? Yeah. How are you feeling?
I feel so nervous. My stomach been hurting. I've been farting all day because I'm just
Why are you farting?
so nervous. You know, I haven't performed ever since my baby. Ever since I. And as the Emperor of New York, I'm going to address something that's been going on in our hoods, in our cities, that nobody's addressing, and I will address. Where the fuck are these raccoons coming from? Bro, I lived in high...
She said, you name it, we got it all. But hold on, did she say rats? She said hams, rams, dogs, hogs, chicken, rats. Hell no.
16 years and shit. And you know what? I went to visit the other day, and there was a motherfucking raccoon. And I was scared. Like, y'all know, I'm used to the rats. I'm used to the rats and shit. Like, we already used to that shit. But these raccoons, they dangerous. They carry rabies, and they attack dogs. The government is placing rabies in our New York City communities. Yeah, that's right. That's right. We gotta get rid of these motherfucking raccoons.
Okay. Do you hate that I'm successful and a minority? Guess what? My parents are immigrants. Guess what? My parents are immigrants and they ain't going nowhere, motherfucker. Are you so upset that I got money and I'm not white? Yeah, yeah.
I will always ask him, what about that Cardi B, though?
Nope.
She's a star.
Wait, yeah, my management's here. Have you heard that Angie Martinez wanted to interview me? We ain't heard nothing.
Damn self.
But we moving on up to the east side. And I finally get a piece of that pie.
Cause. Hey, y'all, come look at this.
To take pictures with it? Because you don't smell your own farts. You need to smell yourself, bitch. How crazy you think. And then you take. And I know y'all smell your own farts too. So I don't give a shit, bitch. You need to smell your own farts so you can know the potential of the farts that you take. Imagine if you think that your farts don't stink and then you fart around a nigga and shit, and then you don't even realize that your farts smell wild crazy because you don't smell your own farts. You need to smell yourself, bitch. The fuck? Okay then. Well, let's step it up a notch then. You guys want to know some real shit that I have learned? Like, I've been hanging around with a lot of people that's wealthy, that is rich, that is famous. And one thing I learned about these people is that, like, no matter how much money you have, no matter how big you are, how famous you are, like, they will still end up stealing your charger and your lighter. I talk about the curved dick. Like, you know, niggas' dicks that be curving like this, like a cashew or like a banana or some shit. Like, those type of dicks is actually a shape, right? And a lot of niggas have that type of shape. And like, you know, sometimes they those type of dicks hit the spot in the pussy, but it's really hard to get fucked in the ass with those type of dicks because it just don't go straight to your asshole. And those type of cocks, the bended curved cocks.
You said to Donald, yo, Donald.
You are. Hold on, trigger warning. Where did trigger warning go?
Orange motherfucker. Do you hate my skin? Do you hate that I'm successful and a minority? Guess what? My parents.
Well, everybody's singing Bodak, y'all.
Yeah, I see. I'm so proud of myself.
y'all. So it has come into a conclusion that the best way, am I lying? The best way to fuck is with the TV on. You wanna know why? Because let me tell you something. If all the lights is turned on, right, and I'm fucking, and I see a pimple on the nigga face, it distracts me from coming. Because now I wanna pop the pimple, and I can't focus. I can't focus at all. Now when it's too dark and all the lights is off now I'm scared. Cause I'm scared of the dark. And you know you start seeing monsters when it's too dark and shit. Bitch, I'm scared. I wanna get out of here. I wanna see my husband. I wanna see my man. And you know why I can't see my man? Cause I'm fucking stuck in New York working. Y'all bitches think I don't want no dick? Acting different when your nigga come around, you need to cut that bitch off. I will tell you to beat her ass right there and then, but government is taking 40% of my taxes. And Uncle Sam, I want to know what you're doing with my fucking tax money, because you know what I'm saying? Like when you donate to a kid from a foreign country, they give you updates of what they doing with your donation. I want to know what you're doing with my fucking tax money, because I'm from New York and the streets is always dirty. We was voted the dirtiest city in America. What is y'all doing? There's still rats on the damn trains. I know y'all not spending it in no damn prison, because y'all be giving niggas like 2 underwears, 1 jumpsuit for like 5 months. So what is y'all niggas doing with my fucking money? What is y'all doing with my fucking money? I want to know. I want receipts. I want everything. I want to know what y'all niggas doing with my fucking money. What is y'all niggas doing with my fucking money? Uncle Sam, I want to know what the fuck you doing with my motherfucking money. Because I wake up in the mirror sometimes and I be like, God damn, I look fucked up. It's okay though, because I got good pussy. Where a nigga going? Nowhere. He ain't going nowhere. Not with this good ass pussy. Not with this good ass fucking mouth. Wet ass mouth. Deep ass throat. Deep motherfucking throat. If I'm drunk, I might put the whole dick and the balls in my mouth. What's up?
She's a star.
Wait, my management's here. Have you heard that Angie Martinez wanted to interview me? We ain't heard nothing.
Her damn self.
But we moving on up to the east side, and I finally get a piece of that pie.
Cause. Hey, y'all, come look at this.
To take pictures with it. Yo, there's a robbery. Give me your penis. Oh my goodness. There's a yo, there's a robbery. Give me your penis. Oh my goodness. I want to fart so bad. I'm about to air it out. Put the window down.
Open the window.
I farted.
Open the left side
I
window.
farted.
Hurry up,
I farted.
open that window.
I farted.
Open the...
Oh, it stank.
No,
You smell it, Ashley? Nah, it's not. It's gonna hit you, though. It's gonna hit you.
Oh, fucking God. Are you fucking kidding me?
You smell it?
So...
Drive! I like that fart. It had like a sweet aroma, stinky smell. I don't give a fuck, bitch. I know you motherfuckers farts, and I know y'all smell your own farts, too. So I don't give a shit, bitch. You need to smell your own farts so you can know the potential of the farts that.
Who are you?
I'm pregnant. Mariah Carey.
Who are you?
I'm pregnant. Mariah Carey.
Mariah Carey.
Yeah. No. Do you know?
And you are Cardi?
Bacteria vaginosis. No. Madonna. Know how to.
Oh, please show me.
No.
Nothing I want to tell the people out there at all.
I want to tell the people out there, suck my dick. And I know you think because I'm a woman I don't have a dick, but I have a pink dildo in my dick. It smells weird. You know what I'm saying? And I come out.
Yeah.
Yeah. Well, especially if that's comfortable for you to do, it'll be easy to...
Yeah, I was just trying to show the world how I got pregnant in the first place.
I see.
Oh, wait. Hear this. Ah, fuck, I don't understand why they not loud. They not loud, but they stink, though. They stink. You know what I'm saying?
Can you imagine if you die and it's like, oh my God, how they die? By choking on a dick.
But I have another gift for you from
You know why nobody told you about those things? Nobody told me that they were gonna stitch my vagina.
Nobody told you that?
No, like people just be like, oh, you know, when you give birth, it's gonna hurt, but nobody tells you that, like, your vagina.
Yeah. That's where they like she can do things for herself.
No, but she's just like, she's very feisty. Like, you know what? My husband used to tell me, like, stop screaming and stop catching that attitude when you're pregnant because you're going to pass that to the baby. And it's like, I did.
Yeah. Tell the people out there at all.
I want to tell the people out there that thank you for supporting me. And if you don't, suck my dick. And I know you think because I'm a woman I don't have a dick, but I have a pink dildo.
It's fluffy.
Mm-hmm.
Or is it?
Wait, that is fluffy, or is it? Uh-huh. What is in your box?
Not a penis.
And then like the couture stuff and the expensive name brand stuff, you put it on her, and then it's like right away she throws up, she drools, or she might crap on it, and she just end up being in a Target outfit, you know, like in a Target onesie. My best pictures and videos.
This is gonna be your first televised performance since you gave birth, right?
Yeah.
How are you feeling?
I feel so nervous. My stomach been hurting. I've been farting all day because I'm just
farting?
so nervous. You know, I haven't performed ever since my baby, ever since I got pregnant and everything. Like I can't. Yes. No, I'm not.
With Dora the Explorer. Ew. I don't know what it is.
I can wait. You can think of a name for it, and I can tell you if I think you have to know what it is.
Pussy balls. Are they pussy balls or not?
This is gonna be your first televised performance since you gave birth, right?
Yeah.
How are you feeling?
I feel
So it'll be easy to...
Yeah, I was just trying to show the world how I got pregnant in the first place.
I see.
This because she's gonna take me out that situation. Who is your celebrity crush? I don't really like none. I like girls. I don't know. I don't fantasize with none of them. Spanking or hair pulling. Nah, I don't like none. Like when people spank my butt, it hurt, and I definitely don't like getting my hair pulled because I pay for a lot of my hair.
Bartier Cardi. Bartier Cardi.
Yeah, you know I named it Bartier Cardi. You know what I'm saying? Because I don't want Cartier to sue me. Featuring 21 Savage. Okay. Ew. Y'all go get that.
No, we're gonna get it. Bartier Cardi. I can't tell you how much we love you.
Underwear or commando? Commando, duh. My vagina gotta breathe. Have you ever hurt yourself during sex? No, guys hurt me. Where's I did.
With everything going on in your career, did you ever think of not having the baby? Or was it planned? I mean, it might have been planned.
No, it wasn't planned. It wasn't planned. It was just one night. It was a good night.
I know exactly when it happened.
You remember exactly when you got your club shot up?
Yeah, because that one night,
Cardi B joining me! Oh my God, I've been dying to talk to you. How are you?
I'm feeling good. I'm feeling nervous, overwhelmed, everything.
You feel it all right now.
I feel it all, butterfly in my stomach and vagina.
Okay. I love you. Why do I love you? Well, I know I love you so much. The same reason everyone loves you.
You fiending anything right now, food-wise? Is there something like you have to have? Like my wife was into ice cream and strawberries.
Cravings.
Is there any craving that you need? Like I need this now.
Chicken Caesar salad.
Chicken Caesar salad.
That's not bad.
It's not that bad. The last time it was hot cakes from McDonald's, so that's better.
Yeah,
I don't know. I don't really be eating like that. You know. I've seen some clips.
How would you describe the aesthetic appeal of Thierry Mugler to somebody who wouldn't know the difference between Tom?
So it would be like Jay-Z, Rihanna, because I just feel like they're like super moguls, and I feel like my tongue is drunk. I feel like my tongue is drunk. Like it's like. But look at it.
Chicken, turkey, rats, dogs, hogs. Where they at, family? They running late, huh? They running late. I'm running out of clips.
So, you know, we just did something more romantic in LA. Well, we went to the strip club. I got a little drunk. I got so drunk, I sucked the soul out his dick. Let me tell you, bitch. Huh. You know what I'm saying? Like, I saw the soul out his dick. Like, his dick is black. I sucked it pink. You know, he got me some diamonds. And some beautiful flowers, you know what I'm saying? Like, and, you know, I saw the effort that he was trying to do, taking me to Cabo and everything.
A girl had beef with me, she gonna have beef with me
Forever.
When Tiara Malcolm came outside, how did she get between the two of you if you were chest to chest?
She literally, she was like, what are you guys doing? What's going on? What's going on? And then she was like, this just hit me. This just hit me. I'm about to f her up. And I'm just like, I was so confused because it's like, no, I didn't. Like, I didn't hit you. And then that's when like Finky came out, and he's like, what's going on? Go to my
Stanky Panky Dr. Finky came out and said, go to my office. Get on that bed and open them legs.
office. So I just like went to his office and stuff like that. Like, that's it. It's done.
Right, but you testified that Tiara Malcolm at some point was in between the two of you.
Yes.
Yeah. You got a hamburger bun with a hamburger.
Yeah.
She was the hamburger, and the two of you were the buns, correct?
Yeah.
Right. How did the hamburger get inside the bun?
I'm not sure if I gave her space or one of us gave her space. She wasn't like really like in. She was just like, what are you guys doing? What is this? And then she just got in the middle because she just was like going crazy. I don't know where she just turned up like.
And you just testified now that Emani Ellis was yelling that you hit her, right?
Yes.
She was saying that. And you didn't hit her?
No.
Did you take a swing at her?
No.
When Miss Tiara Woods was in between the two of you, did you try to take a swing over Miss Tiara Woods?
No.
How tall are you?
So I don't know who Tiara Woods is, but...
Tiara Malcolm, I apologize. Tiara Malcolm. How tall are you? How tall are you?
How tall I am?
Yeah.
5'3".
Okay, how about on that date of the incident when you had your shoes on? Were they flats? Were they heels? What was it?
Slightly flats.
So, and do you know how tall Miss Emani Ellis is?
Oh yeah, I forgot. They be 30 minutes behind. They got a 30-minute delay, so it probably won't start till about 2 o'clock. Well, 2 o'clock California time, PST.
No.
When you were standing face to face, were your eyes like the same level, or did she look taller? Did she look shorter? What is your recollection?
We was face to face, so she's practically like my height, or just much taller, but she was practically like my height. But she is like
what? Say it.
Security was practically like my height, but she is like
what? Say it.
Security heavy.
What does security heavy mean? Just tell us. There's no harm. What does that mean?
Like she just looks a little like she could protect the building type big. You know what I'm saying? She just looked more developed than me.
Okay. And aren't security guards to be more developed than you? Just tell us. There's no harm. What does that mean?
Like she just looks a little like she could protect the building type big. You know what I'm saying? She just looked more developed than me.
Okay. And aren't security guards to be more developed than you?
Assistant.
Good afternoon, Ms. Almanzar.
Hey yo, peace fam. Welcome back to Flesh of the Gods. Today, we're watching the final act of this staged courtroom. The civil trial against Cardi B is reaching its dramatic conclusion. Today, we're not just watching testimony, we're watching closing arguments and possibly even a verdict. Emani claims she deserves a bag because Cardi B assaulted her, used racial slurs, spit on her, and scratched her face with her long 3-inch fingernails. And she talking about 24 M's. Well, at least according to Cardi B's testimony, it's a $24 million lawsuit. Cardi B's testimony was a direct counterpoint to the claims of former security guard Emani Ellis. We also heard from the receptionist who testified that Ellis was the one who was aggressive and was never actually touched by Cardi B. Today, it all comes down to this. The plaintiff's legal team will give their final pitch, trying to convince the jury that the assault was real and the damages are deserved. Then, Cardi B's lawyer will have their final say, trying to slam the door shut on a lawsuit they've called a desperate attempt for a cash grab. After that, the jury will be in deliberation, and the verdict could come down at any moment. Will the truth win in the end, or will the system be used to reward a performance? I guess we shall see. Stay vigilant, stay fresh, and stay blessed, family. Now let's get to it.
The absence of evidence is not the evidence of absence.
What?
And while we waiting for this last little 5 minutes or 10 minutes or so to wrap up, I still got some more clips for y'all. But before we get to that, shout out, what the heck? Before we get to that, why my mouth ain't moving? What happened to my mouth? All right. Anyway, shout out to the stream sponsors, Ali, TSC, Chan Black is Golden. Appreciate y'all, family. Much love, much love. Y'all showed them some love, dropped them some coins, dropped some what ups for Ali, dropped some heart hand emojis for TSC, and dropped some witch emojis for Chan Black is Golden. Appreciate y'all, family. Keep it rolling.
Do you prefer I call you Miss Almanzar, Cardi B, or it doesn't matter?
I mean, y'all been calling me Cardi B.
Hey yo, peace fam. Welcome back to Flesh of the Gods. Today, we're watching the final act of this staged.
If this is your signature.
The hell?
On page 47. Is that your signature?
It could be, because if it's like by electronic, that's how I sign. Like,
that's how she signed it like that. You see the sign? What up, Maura O'Shea? I see you. Appreciate you joining, family. Is it O'Shea or O'Shea?
It could be, because if it's like by electronic, that's how I sign. Like,
And the question that I showed you, 12.1, just say, you want to read it or you want me to read it to you?
you can read it.
State the name, address, and telephone number of each individual who witnessed the incident. This is A, subparagraph A. Or the events occurring immediately before or after the incident.
Mm-hmm.
That's what the question is.
Yes.
Okay. As you sit here today, would you, is it your testimony that Dr. Finke is a witness to the incident?
Absolutely.
He is a witness?
Yes. She knows. She was there.
Is Dr. Finke outside speaking with you?
Outside where?
On February 24, 2018.
Outside like.
In the hallway?
Yes.
He came out of his office?
Yes.
And your response in 12.1, this is what you responded with your attorney's assistance. I won't hold you 100% at fault for it. But question,
Your Honor?
I withdraw. I apologize. The response is, what's discovery?
Yes.
What are form interrogatories?
Oh, honey, I don't know what that means.
What is special interrogatory?
I do not know.
What are requests for admissions? You don't know, right? Is that fair? You don't know?
No.
You do know?
No.
Okay. And when your attorney responded to the written discovery on your behalf, did he or she show you the discovery responses? Did they email you a copy of it?
I mean, I will have to see what you're asking me.
I will show it to you. May I approach, Your Honor? You show her the discovery only? Sure. Thank you, Your Honor. Could you identify it, please? Yes. I will show it to you. For identification purposes, it is form interrogatories, set 1, dated September 30th of 2022. That's what it is? Okay. Just come and show you this document. You can take a look at these pages. Did your attorney show you those documents at any time in your life?
I'm not quite sure. I don't think so, no. Whoa.
And I'm going to show you, with the court's permission, your responses, which were drafted and served on
Well, I might have shot myself in the foot with some of them clips. I'm getting some warnings already. I guess we'll see where that goes. Man, they don't, no mercy over here for your boy Flesh. No mercy.
Good afternoon. Was it facing you or was it facing Miss Ellis?
The camera was facing me. When I got off the elevator, her phone was here. Then when I was walking and she was behind me, and then she said, "Oh my God, y'all, Cardi B, Cardi B." I looked back and the camera was like right there, like practically on her chest type stuff. I'm like, "Yo, why are you recording me?"
Okay. And you've seen, like, you know, police officers where they have a camera on their on the front of them? Have you ever seen that, where a police officer will have that?
I never seen that, but that was her phone, not a camera.
I understand, but I'm saying, have you ever seen a security officer, a police officer, have a special camera on their chest which records what occurs in front of them? I'm not saying she was recording you. I am asking you this question. If she was recording you, why does it matter?
Because she's a security guard and I'm going to a doctor's office. It definitely mattered.
You were causing a disturbance. Maybe she wanted to record you.
Disturbance.
Time out. Let's not talk over each other, number one. Wait for him to finish asking the question before you answer.
Do you own the building of 8920 Wilshire Boulevard?
Make me. It's my time. Make it's me. My time. I'm talking. Make me. It's my time. Make
no, I was walking to a doctor's office.
Do you agree that you were a guest in that building? You were a visitor, correct? Yes or no?
Yes.
Okay. When a security officer tells you to leave, are you supposed to leave?
Objection.
Yes or no?
Sustained if asked and answered. We covered this yesterday.
You were
sustained if asked and answered. We covered this yesterday.
You were causing a disturbance in the building.
She started the disturbance.
Did you also...
Ma'am, if you hear an objection, please wait.
Oh, sorry.
Okay.
That should happen.
What's wrong?
Do you remember yesterday you said that there was a verbal altercation between the two of you? Do you remember that?
Yes.
Okay. And an altercation is a fight, isn't it? It's a verbal fight. You had a verbal fight with her.
Asked and answered.
Yes or no?
Yes.
Sustained.
You used the F word during that fight, didn't you?
Yes.
What other words did you use? Tell us in your own words what you said.
I said, get the f out of my face. Why are you in my face? Why are you recording me? Ain't you supposed to be security?
Tell it to her now. Go ahead.
Huh?
Say it again. Say it.
Objection, Your Honor.
You want me to say it to her
I want
face?
you to tell it to her face what you said on that day so she can hear it for herself
The objection
again.
is sustained.
And, Your Honor, do we have civility in the courthouse?
Why don't we just take the temperature down a little bit? If you have actual questions to ask her, please do so. It's not the time to argue with her.
What were the words that you used when you got off the elevator to this security guard who is no longer a security guard at this time?
Objection said argumentative and also covered yesterday.
It's been covered several times, so it's asked and answered. It's objection sustained.
What did you tell Emani Ellis yesterday?
Counsel, you need to move on.
What were you holding in your hand at the time when you got off the elevator?
Objection. Oh, excuse me, argument.
Overruled.
Nothing, correct? You weren't holding anything, were you?
No.
You had both of your hands free to do whatever you wanted to do, correct? Yes or no?
Objection, no. It's
overruled.
Yes or no?
Yes.
Okay. And if you wanted to scratch or cut her face with your right hand or your left hand, if you wanted to do it, you could have done it, correct?
But
You're
I
not
didn't.
disabled.
But
right?
I didn't because I had a baby inside me.
How did she know?
Time out. Let's slow down the pace just a little bit before the opportunity to give objections and for the court reporter. What was the objection?
argumentative, relevance.
Overruled.
And again, I would ask that counsel lower his voice. This isn't.
So, Your Honor, I was told yesterday that my voice was too low by others, so that's why it's a little bit higher today, so that everybody can hear what I could say, as well as the witness.
I think that there's a difference between volume and tone. I think the volume is fine, the tone is a little bit argumentative.
Thank you very much, Your Honor. I apologize for that. I will try to do my best to tone it down. So, again, I will ask you to tell us and admit to this fact that you are not disabled, correct?
I'm not what?
Are you disabled?
At that moment, no.
No. Are you disabled? Are you disabled? Yes or no?
At that moment, when you're pregnant, I'm very disabled. You want me to tell you the things I can't do?
Fine. What was your disability on February 24th of 2018? What was your disability?
I was pregnant. I couldn't protect myself, even if I wanted to. She's like twice my size.
No problem, no problem. Let me ask you this. How many
Counsel,
months pregnant were
you?
you?
Need to wait for the answer.
Okay, yes.
You done, man?
How many months pregnant were you?
I was around 13 to 12 weeks.
Months? 4 months? 3 months? 3 to 4 months. Fair enough? Did you have a bulge?
12 weeks.
Okay.
You done, man?
How many months pregnant were you?
I was around 13 to 12 weeks.
Months? 4 months? 3 months? 3 to 4 months. Fair enough? Did you have a bulging belly?
No, I didn't.
Did Miss Emani Ellis know that you were pregnant?
Objection, cultural speculation.
Do you know if Emani Ellis knew that you were pregnant when you walked out of that elevator?
No, I didn't know. But she knows that I'm a patient. When you're a patient to go see a medical anything, you shouldn't even try to fight nobody. You don't know what disability they have.
Okay. Now let me ask you this question. When you say you were disabled, were you disabled in your upper extremity, your arms? Were your arms disabled? The reason I'm asking is I want to make it very clear for everybody that your arms can go up and down, and they could go up and down now, and they could go up and down on that day as well. You agree to this?
Objection, argumentative, asked and answered in a different way, and I guess that's fine.
I'll let you can answer this once. Please don't ask it again.
If my arms were disabled? No, my arms weren't disabled. No.
Can you raise your arms up?
Objection, Your Honor.
Can you? You don't have to do it physically. I'm saying, are you able to do it?
Yes.
And on that day, you were able to do it as well, correct?
If I wanted to, yes.
Okay. That's all I'm asking. Aside from your disability of is a little bit less than an inch, okay?
Mm-hmm.
Now, Miss Emani Ellis had a scar to her face of 2 centimeters long, and she received plastic surgery for that. And my question to you is, did you at any time see a scar on Miss Emani Ellis's face, or a cut, or a scrape, at any time during the time of the incident?
No. And she couldn't get a scratch from me because I didn't touch her.
I understand that's what you're saying. I get it. Did you look at Miss Emani Ellis's left cheek at any time during the incident? Did you specifically look for that because you thought there might be a scar on her face? Or did you not look?
Objection. Compound and relevant.
Did you look at Miss Emani Ellis's face when you were arguing with her at the time of the incident?
I was looking at her face, but I wasn't looking like...
Resume the defense closing argument?
Thank you, Your Honor. Good afternoon. We're back. So picking up where I left off, Cardi testified in this courtroom that the whole encounter was maybe 45 seconds, less than a minute. Counsel has urged, and I'll get back to this as well, that she didn't see what happened before, but if you add her and compare her estimates with those of Tierra and Dr. Finke, who said that it lasted about 45 seconds, it's clear that they came out right at the beginning. Now, Cardi also testified in front of you and under oath that she never spit on plaintiff. She never struck or cut plaintiff. She never touched plaintiff's face. She never used the N-word. She never threatened to get plaintiff fired. Cardi also testified that she is in fact left-handed, and we've talked already about how that undercuts Dr. Lanikan's theory that a right-handed person caused the claimed scar. Cardi testified that she didn't have any 3-inch nails at the time of this incident in February of 2018. She also testified that she was in Los Angeles, she lives back east, and she was in Los Angeles for the NBA All-Stars weekend in 2018. And we put into evidence a photograph of Cardi to prove that her fingernails were an inch or less. It's a photograph that she testified was taken at the NBA All-Star weekend. And you heard counsel earlier say that Cardi testified that photograph was taken on the same day of the alleged incident, on February 24. That's absolutely untrue. She did not testify to that. If you are unclear, the record can be read back to you, but I expect that you were here and heard Cardi testify that she was here for a week or so and kept the same fingernails this entire time, and that includes February 24th. The assertion by counsel that she testified to something she did not in fact testify to is something that Your Honor that the judge had already indicated is something you should disregard. Now, she testified that the nails she was wearing while she was in Los Angeles were coffin square and not pointy. That was a new one on me. Apparently coffin square means the shape and a square and it can't cut anything. She also confirmed and testified that the rhinestone images were flat. They were not pointy and they had no sharp edges. Apparently you can get little rhinestones either as little decals on fingerprints or as rhinestones themselves. I'm not like Dr. Finke, a fingernail expert, so I won't talk about that. But the point is, rhinestones can appear on a fingernail, a decorated fingernail, either as three-dimensional or as flat, which of course flat can't cut anything. And she testified, as did Dr. Finke, well, excuse me, I misspoke. She testified that they were flat. Dr. Finke, counsel had said, testified that they were sharp. He actually testified he didn't know whether they were sharp or flat. It is very important, actually, also that while plaintiff's testimony about what happened is uncorroborated, she called no witnesses who were actually there. Cardi actually did have 2 witnesses. And we'll get back to that. I do want to mention something that plaintiff's counsel raised, which is there's testimony from Cardi that as plaintiff advanced towards her swearing and pushing her back, that their chests touched. And counsel told you that that's an assault right there, that his client wins. Well, there's a couple of problems with that. Just touching chests like that is not an assault, and if it is an assault, it's an assault by plaintiff on Cardi. Cardi was being pushed back. That's the testimony from all both of the witnesses and Cardi herself. But I should mention, just in case you want to know, there is an instruction in the jury instructions that deals with the defense of self-defense. Counsel said that that is inapplicable here because Cardi denies that she touched anyone or had to act in self-defense, or that she cut plaintiff. The point he's overlooking is that is up to you. You've heard the evidence. We think it's overwhelming that Cardi did not touch plaintiff at any point in time and did not touch this magic appearing, disappearing scar. But we have to be careful as lawyers. So we've included a self-defense, a defense of self-defense instruction, which means that if you were to find that Cardi did touch plaintiff, or that somehow a chest-to-chest caused by plaintiff is an assault by Cardi, which we dispute strongly, there is an instruction that the judge has given you that self-defense applies if a person reasonably believes that another person was going to harm her or him, and the person uses only the amount of force reasonably necessary for protection. I think there can be no doubt that Cardi was faced with someone bigger than her who was trying to hurt her. We know that from both Cardi's testimony, Tierra's testimony, Tierra Malcolm, and I believe also Dr. Finke. But let's talk about Ms. Malcolm. Tierra Malcolm, we called her as a witness, so we'll add her there. And she is one of the 4 people who are in the hallway, and she testified as an eyewitness, and she has no axe to grind. She's not a friend of plaintiff. She's not a friend of Cardi. She doesn't work for Cardi. They never met before. And so, again, she's an independent third-party witness. She testified that she was Dr. Finke's receptionist and expecting Cardi for a secret appointment. As a receptionist, she was near the front door. That's why she got out first before Dr. Finke, whose office was in the back. She testified it was a Saturday and all the other offices in the building were closed. And they closed early because, quote, they didn't want anyone there when Cardi arrived. When Ms. Malcolm, she testified that when she heard yelling, she immediately ran out. She's near the door. There's nothing she really could have missed once the yelling started. Defendant's counsel has argued that, again, that she wasn't there in the beginning, but we know from her testimony that she was near the door, immediately ran out when she heard yelling. Now we have a visual rendering based on plaintiff's own photograph of the hallway outside the doctor's office and based on the testimony and Cardi of Ms. Malcolm. This shows how far, you see the elevator bank and you see the doors that are depicted in the photograph that the plaintiff showed you, plaintiff's counsel showed you. And where did they end up? They ended up in that corner. That's how far this demonstrates, based on the testimony and evidence in this case, how far plaintiff forced Cardi B backwards and into the corner that Tiara Malcolm saw her when Tiara opened the door into the hallway. Ms. Malcolm specifically testified that when she opened the door, she saw that plaintiff had Cardi against the corner. Ms. Malcolm testified that she said, "What are you doing? You're at work. Go back to your post." And that the plaintiff just refused. She was going after Cardi. She was yelling, screaming. Ms. Malcolm testified that she got between them, with Cardi behind her and with Ms. Malcolm facing plaintiff. There's the evidence.
Let me give it a second, so let it grab up. Let's get to it.
Evidence is that at that point, Ms. Malcolm testified that plaintiff was swinging at Cardi, who was behind Ms. Malcolm. That's what she testified to. Now, Ms. Malcolm didn't realize at first that she was hit. She went after Dr. Finke came out and tried to deal with the plaintiff. Ms. Malcolm took Cardi into the office, and someone else at the office, this is what she testified, what Ms. Malcolm testified to, someone else at the office said, "What happened to your head?" That's when she found out. And all the...
Still a little dragging. I don't know. Let me do this real quick, and we're going to keep it going. Don't leave, family. We're going to keep it going. Oh, there we go. We back.
brouhaha. She did not realize, with Cardi behind her and plaintiff in front of her swinging away, Miss Malcolm did not realize that she had been hit. Now, counsel told you in his opening statement that Ms. Malcolm didn't know she was hit. She knew she was hit. She went back to the office and she saw the scratch on her own head. Counsel has argued
Your
that...
Honor, I would object to him referring to counsel. We can talk about the facts on counsel.
Plaintiff's counsel has argued to you that Ms. Malcolm didn't know who hit her. Okay, and he dwelled on that a lot in his cross-examination of Ms. Malcolm. And with all the things flying, with all of plaintiff's hands flying in the air, what Ms. Malcolm explained is her back was to Cardi. Ms. Malcolm specifically testified she did not see Cardi's hands go in front of her, go by Ms. Malcolm's head. But she did see plaintiff flailing away trying to get to Cardi. That's why she concludes that it was plaintiff who hit her. And it only makes sense. Cardi was behind Ms. Malcolm, and Ms. Malcolm was hit in the forehead, face to face with plaintiff. Again, I apologize for the language, but it's important that you hear this. Ms. Malcolm also heard plaintiff, who was almost double the size of Cardi, expressly threaten in no uncertain terms to harm Cardi. Quote, "I will F your shit up." That's what Tiara Malcolm testified to. She heard plaintiff threaten Cardi. That's an express threat. If anyone was being assaulted by threats of immediate offensive contact, it was Cardi who was being assaulted by plaintiff. Ms. Malcolm testified that while Cardi was behind her and Ms. Malcolm was face to face with plaintiff, Ms. Malcolm did not see any scratches or cuts on plaintiff's face, any blood on plaintiff's face, any injury at all on plaintiff's face, or any spit or spittle on plaintiff's face. Ms. Malcolm also testified that Dr. Finke came out of the office into the hallway and tried to get plaintiff to stop and leave. Ms. Malcolm then got Cardi into the doctor's office. She testified that throughout this, plaintiff had her phone in her hand. I want to repeat that. So she testified here that she was using earphones. She actually, we've got another witness who says plaintiff was standing there, flailing away with her hand, with her phone in her hand. Now, Ms. Malcolm also testified, and I know this gets a little bit repetitive, but it's important you remember this testimony and you take it into account when you deliberate. Ms. Malcolm also testified that Cardi did not hit plaintiff, that Cardi did not cut plaintiff with her fingernails, that Cardi did not use the N-word. Cardi, Ms. Malcolm testified with Cardi behind her, almost touching her back. She did not see or feel Cardi swing at plaintiff. They didn't touch each other, although counsel asked what about chest to chest, and Ms. Malcolm testified, which seems truthfully, when plaintiff had Cardi in a corner, Malcolm could not tell if their chests were touching. That's because she's behind them. She's coming out of the office door. Ms. Malcolm also testified that a few months later, plaintiff asked Ms. Malcolm to help her go after Cardi. Now, if you remember, counsel for plaintiff elicited testimony from plaintiff that she never really intended to sue Cardi. She never intended to go after Cardi. But that's not what Ms. Malcolm says. Ms. Plaintiff was trying to elicit witnesses to support a claim against Cardi. And Ms. Malcolm said, thank you, but no thank you. And she did that because she felt that plaintiff was at fault and, quote, she handled everything unprofessionally, close quote. Now, we also called Dr. Finke. He too was there the day of the incident, and he too has no axe to grind. He is not her regular doctor and never has been. He saw her that one occasion on February 24, 2018, when Cardi was here for work for the NBA All-Star Weekend and was concerned. She was pregnant, she wanted to see an obstetrician, and an appointment was made. He is a completely disinterested third-party witness with no axe to grind. Now, Dr. Finke, like Cardi and like Tiara Malcolm, testified that plaintiff, well, first of all, he testified his office was at the back of the suite. He heard yelling and he immediately ran to the front. Okay, so he gets there very quickly too. And he just has a little bit more distance to cover. And he testified, like Cardi and like Ms. Malcolm, that plaintiff had her cell phone in her hand. He saw plaintiff trying to hit Cardi. He saw poor Ms. Malcolm in the middle. And by the way, do you remember in the opening, counsel for plaintiff said, well, Ms. Malcolm threw herself into the fight. If she gets hit, she gets hit. That's what happens when you try to help. I mean, really? I mean, you know, she's a doctor's receptionist. She sees a patient coming there for a secret appointment, a pregnant patient. She tries to stop a security guard who's got the patient cornered in the hallway, and that's like, she asked for it? Is that really the answer? Dr. Finke also testified that Ms. Ellis had scratched Ms. Ellis, plaintiff had scratched Malcolm's head. If you remember, the evidence is that Tiara Malcolm did not realize she was scratched until someone else in the office, the doctor's office, pointed it out, and also that Dr. Finke, once he got plaintiff to leave, which he refused to do, that he went back into the office, so he had a chance to see her at that point. That supports his testimony that he saw the scratch on Malcolm, not on plaintiff. Dr. Finke also testified that he told plaintiff, do your job, you're a security guard. But plaintiff kept yelling and she refused to leave. Kept yelling at them, kept yelling at Cardi. Now, while Dr. Finke tried to get plaintiff to leave, he was face to face with her. He testified they were within a foot of each other. And he testified he saw no cuts or scratches to plaintiff's face. He saw no blood on her face. Despite the fact that he testified that a cut on one's face bleeds more than a cut on any part of the body. This woman claims that she was cut in that encounter, but no one has testified that she had blood in her face. In fact, she testified she doesn't know if she had blood on her face from a scratch that has supposedly ruined her life. He also testified that he saw no spit or spittle on her. He also heard, he was there when plaintiff expressly threatened harm to Cardi by saying, "I will F your S up." Now, Finke testified that Cardi did not spit on plaintiff or anyone else, did not take a swing at plaintiff, did not hit plaintiff, did not cut or scratch plaintiff, did not threaten to get plaintiff fired, did not use the N-word, and did not call plaintiff fat or poor. Dr. Finke also testified that once Cardi was safe in his office, he examined her in an examining room, and she did not have 3-inch fingernails. Now, in an interesting term, that was a surprise to me as well. He said he actually notices his patient's fingernails because it's a way of calming them down. It's a way of lightening the mood in the examination. So he's seen a lot of fingernails. And he looked at hers, and hers were not 3 inches. There were allegations, and you've heard little bits of it, that Cardi supposedly got plaintiff fired. Actually, Dr. Finke said it was him. He told his administrator, his practice administrator, that this was outrageous, and based on the conduct he saw, plaintiff had to go. Cardi did not make a complaint. Cardi is not the reason that plaintiff got fired. Plaintiff is the reason that plaintiff got fired. Our evidence also included plaintiff's February 24, 2018 incident report. Plaintiff was asked in discovery, and we read some of that to you, which are formal written requests for documents or information, sworn under oath by plaintiff in this case. We asked for documents relating to the incident, emails relating to the incident. She never produced her incident report. We had to subpoena it from Allied. That's how we got it. We didn't get it from her. She claimed it didn't exist. Once again, common sense. There's something wrong there. We had to serve a subpoena on Allied, who produced a copy of the incident report, and we relied on that incident report because of plaintiff's inconsistencies and admissions. Now, it contains a lot of her accusations, and we believe the evidence is clear that they are false, but it also includes some interesting statements by plaintiff. And this is 2 days after the February 24, 2018 incident. Plaintiff, who testified, if you remember, that incident reports are very important. And she testified, and in the incident report, she told her supervisor that that Cardi had scratched plaintiff's nose. Not cheek, nose. 2 days after the incident, when she's blaming all of this on Cardi, which I think it's safe to assume that she was improperly doing so, given all the evidence we've heard. Plaintiff told her supervisor 2 days later, Cardi's, with 3-inch nails, the evidence is against that as well, scratched plaintiff's nose. Nothing about a cheek. And again, a nose is not a cheek. They're different. This raises 2 points, really. Plaintiff's first statement that Cardi scratched her nose is directly contrary to plaintiff's sworn testimony here that Cardi scratched her cheek. Okay. So if we accept that, then the statement that she put in her report is clearly false. Because she's now saying, and she's been saying for a couple of years, no, it wasn't my nose, it was my cheek. Second, plaintiff admits that her nose was not scratched. So this is.
Ooh, I like that design. Mental note for future paperwork edits.
A very important document because it confirms that she made false statements about the incident. At a minimum, she made the false statement that Cardi had scratched her nose. This statement, this incident report that she said is very important, also apologized to Allied and the building owner, quote, for behaving the way I did. okay? Why would she apologize to them if she was attacked? Why is it something that she would apologize for? Again, common sense. She was apologizing because of the way she was behaving. She's apologizing to them for her professional misconduct. She's apologizing to them for attacking a medical patient who's trying to go in for a medical exam. Can I have a little bit of extra time?
Flush of the Gods, good to see you. Good to see you.
Also got extra time?
I don't know that he did, but please try to wrap it up.
Okay. I'm going to do this a little bit faster, and I apologize. We also called Nicole McKenzie. Nicole McKenzie is an interesting person because she's a psychologist, a workers' comp psychologist, and plaintiff called her too. It's baffling why he did, because all of her testimony only helped Cardi. First of all, no one called Dr. McKenzie as a psych witness. There were no psych witness questions. We called her because what plaintiff told Dr. McKenzie in April of 2018, just 2 months later, is directly contrary to what she's been saying. Ms. McKenna testified that let me rephrase this because I'm trying to cut some of this out. Ms. McKenzie, who you may remember, testified in this case that everything that she was saying was what plaintiff had told her. And she testified that when Dr. McKenzie did the evaluation, plaintiff made no.
Real quick, what up to everybody?
Flush of the Gods, good to see you. Good
From the
to
Cat Not
see
Williams
you.
raid. Appreciate y'all joining, family. Y'all hit the like button, hit the subscribe, tap in on your way in, share with a friend on your way out. Appreciate y'all. Let's keep it rolling. Shout out to Cat Not Williams. Much love. Stream sponsor.
No mention of being scratched, cut, or even touched by Cardi. She actually said Cardi, quote, almost, close quote, touched her. Almost is not touching. Plaintiff has offered no explanation as to why she told Dr. McKenzie Cardi almost touched her.
My bad. Shout out to the Raiders, Mary W, Factual Lie, and everybody else who joined. Appreciate y'all too, family.
Ms. McKenzie also testified that in doing her evaluation, she would note any physical symptoms. And she confirmed that plaintiff identified no physical symptoms 2 months after she supposedly got cut in this incident. And in response to one or more of the jurors' questions, the judge elicited the response from Dr. McKenzie that it was her standard practice that even if someone came to her just for a psychological examination, that she would also note any physical symptoms that were reported, and also that if she saw the patient and saw, if they've got a cut or a scrape or a bruise or whatever, she'd note that as well in the report. And none of that was noted because none of it existed. We also asked plaintiff about her Kaiser medical records. At this point, I'll just mention that she testified and admitted that out of 161 pages of medical records over 2 years, there was no mention of any cuts, scratches, anxiety, PTSD, or anything else. Counsel noted that we called Dr. Rosenberg, who is a lifetime board-certified medical doctor who specializes in psychiatry. He has impeccable credentials and decades of experience. He, by the way, does not work on a lien basis. He does not work, we paid him, he does not work on a lien basis, so he doesn't have the same incentive that Dr. Mulligan has to spin his story. Dr. Rosenberg wasn't asked to diagnose any psychiatric conditions that plaintiff has. So in his report, he specifically said no diagnosis. But he did come to conclusions, okay, which is different than a diagnosis. And what he did was he had a 6-hour recorded interview of her, and he had her take a gold standard test of 335 questions. And what he learned from the test was that she claimed symptoms different symptoms and so many symptoms that only 2 out of 1 billion people in the world have those symptoms. He also testified that there were inconsistencies with her story. We talked about the McKenzie analysis, in fact, that the plaintiff didn't mention any problems or physical injuries to Dr. McKenzie. We've talked about the initial incident report, which says a scratch on the nose, but not a scratch on the... So with all these different inconsistencies, that went into his analysis as well. Now, he also considered that in the Kaiser medical records, there's no indication of any of those injuries. And counsel, for some reason, focuses on vaginal discharge to say, well, if you're going for that, you're not going to mention a cut or scrape.
I was wondering that too. Like, why the hell did he keep on talking about that vaginal discharge? And he was pushing it out there like, bruh, are you serious? You know you fighting for this client, right? Why would you even put our info out there like that?
But that's not what Dr. Rosenberg testified to. He testified that in April 2022, plaintiff went into Kaiser for a complete history and physical, and plaintiff specifically in questioning denied any kind of mental health issues, including anxiety or sleep problems. In April 2023, she went in again, and for hand pain that time, and she was specifically asked, Dr. Rosenberg said that's what Kaiser does. They ask you about everything, just noted in the records. And she was asked, but again, reported no emotional problems and did not request mental health assistance. I should also mention this claim about PTSD. Dr. Rosenberg testified that you can't, quote unquote, an argument or an unpleasant interpersonal interaction isn't a trauma and can't lead to PTSD. The claim of PTSD is frankly an offense to those people who actually have it. She had a 45-second argument. She was fired. That is not what gives you post-traumatic stress syndrome, and we know that because we've heard it from a licensed psychiatrist who did all those tests and interviewed her for 6 hours. I should mention that Dr. Mulliken is a plastic surgeon. He's not a psychiatrist. So Dr. Mulliken couldn't and didn't rebut Dr. Rosenberg's conclusion that plaintiff is feigning. Counsel said, well, why didn't the defendants call a plastic surgeon expert? Because we don't see a scar. To call someone to say, can you examine this person? Do they have a scar? You can look at the photograph. Why would we call a plastic surgeon? Conversely, though, they want to prove that plaintiff had psychological injuries. Why didn't they call a psychiatrist? Let's talk a little bit about plaintiff's shifting stories. First of all, plaintiff alleges that Cardi spit on her. It's a disgusting allegation, of course, and I hate to even mention it. And everyone else says it didn't happen. But for her part, plaintiff also hasn't gotten her story straight. If you remember, last Monday she testified in her February 26, 2018 incident report. Plaintiff told her supervisor that Cardi spit on her before people came out of the doctor's office. But at her deposition, plaintiff testified that Cardi spit on her after they came out. She can't get her story straight. That's that simple. Counsel has referred to spittle. And so what he's basically backed off of is initially it was a terrible spitting at her client. Now it's, well, maybe it was an accidental spittle. Say it, don't spray it kind of thing from junior high school. There's no evidence that happened, but it's also not an assault. It's also, when you look at the jury instructions, you'll see that an assault requires intentional conduct, intentional battery. Accidentally, spraying a little bit of spittle when you're arguing, that is not an assault, and there's no evidence that it even happened. Plaintiff also is strikingly inconsistent regarding her claim that Cardi touched her. We'll go through this quickly. We talked about in the February 26, 2018 incident report, supposedly Cardi scratched plaintiff's nose. In April of 2018, plaintiff told Dr. McKenzie that Cardi almost touched her. In sworn responses in discovery in this case, plaintiff stated under oath that Cardi viciously beat plaintiff about the head, face, and body. You haven't heard that, in this trial. No one said that occurred. In her deposition, plaintiff stated under oath that Cardi struck her on her nose and cheek, and plaintiff acted out Cardi jabbing plaintiff's face with an outstretched index finger, which is directly contrary to, and you saw that videotape of that, it's directly contrary to what Dr. Mulligan testified he thought happened.
Objection, Your Honor. We're going about over an hour now.
What's your objection?
That we agreed to 1 hour.
Okay, counsel, why don't you wrap it up?
Can I have 3 minutes?
Just wrap it up.
Okay. I'm sorry, there's more to talk about, but I've got to go. Ultimately, this case comes down to what happened in a minute in a medical building hallway. And to believe plaintiff, you would have to disbelieve Cardi, you would have to disbelieve Ms. Malcolm, you would have to disbelieve Dr. Finke, and you would have to ignore all of plaintiff's contradictory statements, including whether she had a cell phone, whether she had an earpiece, all that stuff. This is not a difficult case. It is not a close case. Plaintiff has the burden of proof, and the evidence is overwhelming in Cardi's favor. Plaintiff has not met her burden of proof. And plaintiff's demand for whether it's the $24 million that was testified to at trial or the $250,000 plus that you heard today makes no sense. She suffered no injury. Cardi did not do anything wrong except try to protect her baby and get to a doctor. The court will provide you with a verdict form, and we urge you that the evidence and common sense require that you answer questions 1 to 2 as no. That will skip you over to Section B. We ask that you answer question 5 no. That will skip you over to Section C. We ask that you answer question 8 no, which will skip you to Section D. We ask that you answer question 12 no, which is then the end of the verdict, and you can have the foreperson sign it. I also want to note that for each of these questions, as the judge previously told you, 9 people do not have to agree. You can have 9 people agree on one, a different group of 9 people on another. And we ultimately, we thank you for your time, for your consideration, and you know how we wish you rolled. So, thank you.
All right, and folks, as we indicated, plaintiff gets the first and last word, so time for a rebuttal case for plaintiff.
I don't think that.
Good afternoon. Thank you all for coming back. So this is the end of the road now. I said a lot of things this morning, and I basically don't want to repeat all of it. The main point that I want to highlight, which what counsel has brought up, is
the evidence is going to show that anything that I may have said, they exacerbated it.
Incident report, Ms. Emani Ellis tells her supervisor that the defendant put her fingernail into her face. You will see that. Into her face and scratched her nose. She caused damage to her face. It was a physical contact. As far as the spitting, I never brought up the word spittle. I don't know what that exactly means, but in either event, Emani Ellis, who was there, who was a witness to this incident, testified.
He clearly said spittle. I'm gonna have to grab that clack. He clearly said that.
That the defendant spit on her, actually spit on her, which is an assault and a battery.
The truth is that you are a liar.
Everybody gets an attorney. Everyone gets to have an attorney. Even Cardi B gets to have an attorney. All of these comments and all of these things are smoke and mirrors to hide up the truth. Bottom line is, Miss Emani Ellis, who was there, testified multiple times. She never did anything wrong in her life. She was a model citizen, good person, and she basically was doing her job as a security guard, and the defendant refused to cooperate, caused a disturbance, physically assaulted and battered her, spit on her, took a swing at her, and ultimately a couple of witnesses came after the fact, and they were not witnesses to the entire incident. The entire incident really took place between Emani Ellis and Cardi B, and it really is going to come down to who do you believe? Who do you believe? Are you going to believe Emani Ellis, who was a security guard, who did her job, who was there, who never had any problems of any kind? Or are you going to listen to somebody who's yelling and screaming, has anger management problems?
Objection, Your Honor.
Got angry on that day. There's no question. She admitted it. She said she was angry. She got angry. She attacked the plaintiff. She spit on her. She used the N-word, disrespectful. She took a swing at her. She did everything possible to cause her so much emotional anguish and try to get a reaction out of her. I don't know how it was that Emani Ellis was able to contain herself, maybe because she is so peaceful. You heard lots and lots of testimony about how she was peaceful. The issue with Dr. Mulliken, at some point I did ask Dr. Mulliken, could this scratch, could this cut have been done by someone who's left-handed or right-handed? At the end, he was very clear. You can ask the testimony to be read back to you. He said it could be done by either a right-handed person or a left-handed person, either one. And when we had Cardi B on the stand, she said she was disabled because she was pregnant, but at the end of the day, she wasn't disabled with her hands, and you can cut someone with either hand, both hands. Go to the bench press, both hands. Anything can happen with both hands. This is not somebody who was taking a swing with a bat, in baseball you must use the correct, no. This injury could happen with the right hand or left hand, and Dr. Melka clarified that and said it could happen with either hand. Again, the evidence that needs to be brought forth needs to be proven by a preponderance of the evidence. We don't have to prove 100%. We have to prove a featherweight more than 50%. In this case, we have given you so much different evidence from different people, which was Emani Ellis, her grandmother, her mother, and all of the medical records. We have a plastic surgeon who came here and explained everything. You now have the case before you where you can now determine what you feel Emani Ellis should receive to make her whole. And counsel brought up some points to try to maybe muddy the waters in a sense and try to change what really happened here. At the end of the day, we have overwhelming evidence that Emani Ellis was assaulted and battered, and we thank you for your service.
Have a good night. Have a good night. Have a motherfucking good ass
Presentation of evidence and argument. You're now going to be shown to the jury room. We do have a hard stop at 4:30, and by no means would I suggest that you should try and rush to be done by then. You do need to deliberate and consider all of the evidence before answering the questions on the jury form. And so if indeed it takes you longer than 4:30 today, then we will need to come back tomorrow. If you want to take a break, you can take a break, but you all need to be back together in the jury room, so please do not deliberate until all of you are back together. To the extent that we do come back tomorrow, if you want to bring snacks or anything like that, that's fine. We can discuss that a little bit later. But for now, can I have Cynthia swear in Vanessa, please? Yeah.
Please raise your right hand. Do you solemnly swear that you will take charge of the jury and keep them together, that you will not communicate with them yourself, nor allow anyone else to communicate with them upon matters connected with the case, except on order of the court, and when they have agreed upon a verdict, you will return them into the court, so help you God?
I do.
And do you solemnly swear that you will take charge of the alternate juror and keep her apart from the jury while they deliberate on the cause until otherwise instructed by the court, so help you God?
I do.
May I please have you state your first and last name for the record?
Vanessa Garcia.
Thank you.
Vanessa?
Yes, sir.
I want to talk to the alternate before she goes.
Juror number 8, Juror number 7, do you want to come up? And that alternate, if you could just stay in your seat. Thank you.
Counsel, do you see that the door's closed? There it is. Okay. All right, we're still on the record outside the presence of the jury. We do have the alternate number 1 here. Ma'am, on Wednesday, did you have any conversations with any of the witnesses? Were you sitting? Yeah, you.
Me?
Yes. Were you outside? Did you sit next to the plaintiff's grandmother on Wednesday?
Yes. The grandmother?
Correct.
I can't remember, but I did sit once, at least once.
Did you have a conversation with her?
I don't remember what I said if I did.
Okay, so she didn't say anything.
I didn't say anything about this.
Nothing about the trial.
No.
Okay, very good.
Not at all.
Vanessa,
what y'all doing talking?
Can I excuse you to the jury room? All right. Thank you, ma'am.
I'll take your notebook.
Thank you.
And then I'll take your.
Thank you.
I don't remember what I said if I did. Out there talking to the jury, that's automatic mistrial. But they don't need a mistrial. They probably won't even fight for no mistrial because she already won anyway.
And just for the party's information, they were seen, they had some kind of conversation, may have been innocent, I just wanted to rule out an improper contact. If you could please either stay close or give a cell phone number to Cynthia, just please stay within a couple minutes in case we get any questions from the jury or if we get a verdict.
Your Honor?
Yes.
So I do want to put something on the record, but not about counsel.
Okay.
I think it's important. I think this court has a duty to handle the situation, which is what happened. During the lunch hour, Cardi B went outside and threw something at one of the news reporters. I have it on video. She's been staring at my clients, all 3 of them, trying to intimidate them. I think it's unfair, and it's they feel scared. They feel scared about what she may do to them because of what she did to that court reporter, which I have on video.
To the court reporter?
I'm sorry, to one of the news reporters. She threw an item at the news reporter, physically, in front of this courthouse, on court property, outside this courtroom. So I would ask that she be admonished and be told not to handle herself in this way and not to look at my clients anymore.
All right, so the court can't.
He wants to admonish her? What is this dude doing? Man, get him up out of here. Talk about what they did to the news. What do that got to do with this case?
Making orders for conduct that the court didn't witness.
I can show the court the video.
Well, I still haven't witnessed it. To the extent, I think it appropriate that the parties be courteous to each other. I don't think it's appropriate for anyone to be either threatening anyone or even by way of staring at someone. People can take offense to that. So please continue to act courteously with each other.
May I just add one thing?
Sure.
I've been sitting here throughout the whole trial. Plaintiff has never looked this way, so I don't know what she's talking about.
Okay.
Second, plaintiff is halfway between Cardi and the jury box and the witness. I have never seen Cardi do anything else other than watch. Sometimes she, in response to a witness, may wonder what. But I have not seen anything that plaintiff's counsel has claimed.
Okay. All right. And we do have extra security here just in case there's any kind of issue. All right. All right. Stay close.
Yes, sir. Thank you.
Hold on, family. I got the clip. Let me pull it up one time for the one time. I was about to switch it, but since they ended right there, well, let me keep playing in case they not done, but I'll pull it up. But I'll keep it playing just in case they come back again. Oh, yeah, there they go.
Cardi, insiders are claiming that Offset is publicly bragging about getting you pregnant for the 4th time.
Over and over and
Do you
over
foresee
again.
any paternity issues with Stephon Diggs?
Stop disrespecting. Don't disrespect me.
Diggs.
Stop.
That's what he's scared of? Was she throw a lighter at him? Was that a nail?
Do you foresee any paternity issues with Stephon Diggs?
Stop disrespecting me. Don't disrespect me.
Oh, it was a pen.
What's the verdict?
She grabbed the pen and threw it at him.
Thank you.
Cardi, insiders are claiming that Offset is publicly bragging about getting you pregnant for the 4th time. Do you foresee any paternity issues with Stephon Diggs?
Stop disrespecting me. Don't disrespect me.
I got another marker, Cardi.
Cardi, your courtroom is amazing.
You're amazing, Cardi. I still love you.
She said, I don't care. I get another assault charge. You see me beating them back to back? I don't take no losses. You want to come in here and try your luck?
No, you just threw some stuff at me.
I don't care.
I'll scratch your face, nigga.
Disrespectful. Don't do that. Do you see women asking those type of questions to me? Do you see women asking those questions to me?
It's legit.
Why do you feel as a man you get to ask me those type of questions? Act like you have some manners. And your mama taught you respect women.
All right,
With that whole situation of them asking that question when Cardi B came out and
She threw a pen at him. That's crazy, family. He said, I'm scared for my clients. The way she been looking at him, she out there throwing pins. That was dumb, no, but she don't give a... They can't do nothing for that unless he try to sue her, but that's going to be a whole nother case. That ain't got nothing to do with this one. Heck no.
Welcome to Flesh of the God.
Well, isn't this a nice surprise?
The absence of evidence is not the evidence of absence.
What?
Hey yo, peace fam. Welcome back to Flesh of the Gods. Today, we're watching the final act of this staged courtroom. The civil trial against Cardi B is reaching its dramatic conclusion. Today, we're not just watching testimony, we're watching closing arguments and possibly even a verdict. Emani claims she deserves a bag because Cardi B assaulted her, used racial slurs, spit on her, and scratched her face with her long 3-inch fingernails. And she talking about 24 M's. Well, at least according to Cardi B's testimony, it's a $24 million lawsuit. Cardi B's testimony was a direct counterpoint to the claims of former security guard Emani Ellis. We also heard from the receptionist who testified that Ellis was the one who was aggressive and was never actually touched by Cardi B. Today, it all comes down to this. The plaintiff's legal team will give their final pitch, trying to convince the jury that the assault was real and the damages are deserved. Then, Cardi B's lawyer will have their final say, trying to slam the door shut on a lawsuit they've called a desperate attempt for a cash grab. After that, the jury will be in deliberation, and the verdict could come down at any moment. Will the truth win in the end, or will the system be used to reward a performance? I guess we shall see. Stay vigilant, stay fresh, and stay blessed, family. Now let's get to it. Shout out to Cat Knott Williams with the 5 gifted membership, bringing Jack up to ask for some more subs and dance for some more subs. Shout out to you. Y'all show some love to Cat Knott Williams. Drop them KSPNs, drop them coins in the chat. Morris said, can I change my vote? I think you can change your vote, actually. What was your vote? I don't know. I think you can. I'm not sure, though. So, while they doing... Oh, wait a minute. My mouth not moving. What's going on here? So, anyway, I don't know what's going on with that. While they deliberating, I'm going to go ahead and play some of the full testimonies. I'm going to play the full opening testimony from Emani, whatever her name is, from Emani. We're going to start with her and play her full testimony. And then, well, not the full. Anyway, let's just get into it. We're just going to hang out until the verdict come around. I'll play some random stuff to keep us entertained. You know what I'm saying? But shout out to the stream sponsors, Allie, TSC, Cat Knott Williams, Chant My Black is Golden. I definitely appreciate y'all. Appreciate all the support. Much love to y'all for that. And now let's get to it.
22 through July 2nd of 23.
Same objections.
Overruled.
Correct, yes.
And for that psychological treatment, did Dr. Avila's office agree to treat you on a leave basis?
They did, yes.
For Nicole McKenzie,
Hey, and y'all let me know if they return y'all gifted memberships, because I accidentally played a little too many clips, and I don't know, I think one of them might have got a little flag. So if they take those memberships back from y'all, let me know so I can see what's going on. But I should be able to remove it before they do, but I don't know if they take them back or not. So please, if they take them back from those who donated, let me know.
did you, were the medical bills totaling $5,087 per office for medical treatment that you received related to this incident?
Objection. Leaning, Black's Foundation.
Sustained.
Is it your understanding that your total medical bills related to this incident are $36,000?
You need to start with the foundation. You need to establish what she knows and how she knows.
And you're right. Did you receive medical bills at your home from these different medical providers?
I'm not sure.
Did some of the medical providers send you bills to your home?
I'm sure, yes.
Did some of the medical providers that I mentioned advise you of the amounts that they were charging you for their medical treatment?
Yes.
Was the medical treatment that you received from these medical providers beneficial to you?
It was.
Do you still suffer from psychological issues related to this incident?
Objection.
Sustained.
I do, yes.
The objection was sustained. Sustained, you don't answer.
The judge says sustained, then you don't answer.
I apologize.
How often, since this incident, February 24th of 2018, how often do you see your grandmother, Diane Schmidt?
Objection, relevance.
Once a month
And where does she live?
in Las Vegas.
And she's here today to testify on your behalf?
She is.
Do you know how old your grandmother is?
79.
Do you have respect for authority?
Yes.
Sustained.
Where does your grandmother live?
Las Vegas.
Do you ever visit your grandmother in Las Vegas?
Yes.
And for what reason did you visit Las Vegas to visit your grandmother?
To check on her. She's a senior.
Do you take any medication or drugs?
No.
Do you drink alcohol regularly?
No.
Can you tell us a little bit about what your expectations are when you worked security at that building on February 24th of 2018?
Are you asking me what were my duties today?
What were your expectations? What was your expectation from visitors or guests who were coming to that building on that day?
Sustained.
When you worked security on February 24th of 2018, did the owner hire you to do security for them?
Yes.
And why did they hire you?
Objection, causes speculation, Black's Foundation.
And after this incident, you decided to discontinue working as a security guard. We're not blaming it on the incident, but we're saying that, I want to be clear that after this incident, you have decided that you're no longer going to work as a security guard, correct?
Yes.
And before the incident happened, did you have that intention, or did that intention come about after the incident occurred?
Objection, compound.
It came after the incident. I had plans of promoting, moving up, definitely staying at that job.
Did you, well, I'll strike that. Did you ever want to become a police officer?
I did.
Do you still want to become a police officer?
No.
And why is that?
I was deeply traumatized about what happened.
Can you tell me a little bit more about your trauma that you suffered from this incident?
Yes. I deal with anxiety, deal with depression. I have post-traumatic stress. I have a scar on my face. I deal with insomnia, things like that.
Do you believe that the incident, well, strike that. Are you single at this time?
I am.
Were you single at the time of the incident?
I'm not sure.
Do you believe that this incident has an effect on your future ability to have a partner?
Hold on. She not sure. She don't remember if she was single or not. Do you remember going home telling a man or a woman, whatever you may have been with at that time, about your bruised up face? Do you remember telling them at all? Like, I need to go get plastic surgery because these scratch scars on my face then tore me up? I don't know.
Objection, lacks foundation, calls for expert testimony.
Assisting.
Do you expect Cardi B to pay for your medical bills?
Objection, irrelevant.
Assisting.
The evidence is going to show that anything that I may have said, they exacerbated.
Aside from calling you the N-word, spitting at you, taking a swing at you, cutting your face with her fingernails, is there anything else that she did on February 24, 2018?
Lady Justice is blind. Everybody forget.
I mean, the whole incident was super traumatizing for me. She did a lot that day.
The truth
Did
is
she ever
you are a
apologize for
liar.
what she did?
Never.
Would you want her to apologize?
Of course.
Thank you. Thank you, Your Honor.
All right. Cross again.
And if it's okay, I'll use the podium. With a slight adjustment. Good afternoon, Miss Ellis. Your
Daniel
lawyer showed
Berry
you
Sports
photos
Highlights. What's good, family? Shout out to Daniel Berry. Appreciate you joining.
of the building that you were working on at as a security guard in February 2018. Do you know the name of the building?
I don't know the name.
Was it Beverly Hills Medical Center?
It could have been, yes.
Yeah, it was a medical facility, right?
Yes.
And the incident that you claim happened that day happened at approximately 1:30 p.m.?
Approximately, yes.
And you knew at the time, when you saw Cardi B, that she was going to a medical appointment, correct?
I didn't know where she was going, but she was at the building.
And you understood that she was going to a medical appointment, right?
She was going to an appointment, yes.
And it was a medical building, right?
Yes.
And your deposition was taken, and you said that you testified under oath in your deposition. Let me ask, do you remember your deposition was taken in this action? Yes. Do you remember taking an oath at the deposition to tell the truth?
Yes.
And that under the same penalties of perjury that apply in this courtroom, for example, correct?
Yes.
And you testified that you understood when you saw Cardi B that she was going to a medical appointment, right?
Yes.
Now, after this incident, you talked to your supervisor at Allied, right?
Yes.
And she told you to submit a incident report, correct?
Yes.
And you emailed an incident report to your supervisor 2 days later, right?
I don't know about 2 days, but I sent it to her, yes.
Yes. And it was by email?
I'm not sure how she received it.
Your Honor, if we may, I'd like to show the witness the incident report that she did not produce in discovery.
To refresh.
Mora say, wait, she worked there for 4 years and she don't know the name of the building. But you want to try to sue somebody. Insane.
I would object to that based on authenticity. It's not her document.
I think admitted you refresh my recollection. It's over.
This is a document that we got from Allied pursuant to a trial subpoena. And it's not in the book. So let me provide a copy. Should I hand it to the clerk?
You can push.
I'm sorry? Oh, thank you, Ron. Let's make sure. Here we go. Does that refresh your memory that you sent an email to your supervisor on February 26, 2018?
Okay.
Do you recall that now?
I don't, but I'm looking at what you gave me.
And that's your email address, right?
Yes.
And it's addressed to your supervisor, Jasmine?
Yes.
And it's dated February 24, 2018? Oh, I apologize. It's dated February 26, 2018, and the subject is 224-18 incident report. You see that?
Okay. I see it, yes.
Yes. Okay. Now, before we talk more about that incident report, do you remember receiving in this case discovery requests that you had to verify under oath, where people asked you questions and about documents?
I'm not sure.
Well, let's see if we can refresh your recollection. With client's response.
Which one is it?
If I may, Your Honor, to explain to counsel that it's plaintiff's response and objection to defendant Cardi B's demand for production of documents, set 2. And may I approach?
Sure.
Thank you. If you look through the last 2 pages, is that a verification by you, signed by you, under oath, that the statements in the response, are true and correct?
I'm sorry, were you asking me?
Is that your signature on the last page here?
Yes.
And you verified that, you signed stating that under penalty of perjury, the statements in the document are true, correct?
Yes.
Okay.
Man, I forgot about them blackouts on the first day.
I'm not sure.
Well, please look at it. If you could please look at pages 5 and 6. The plaintiff has no emails related to this lawsuit.
Are you asking me about this email on the paper?
I'm asking you about the response. You made a discovery in this case stating that under oath you have no emails that relate to this incident. Is
Well,
that
that's
correct?
correct. I don't have access to this email anymore.
Okay. So you're, well, okay. Let's talk,
Truth
let's go back.
is, you are a liar.
Actually, we have one other response, another sworn response. Your Honor, I would like to show the witness plaintiff's responses to defendant Cardi B's special interrogatories, which rather than asking for documents, ask for information. May I approach?
Go ahead. What is the date of the document?
It was served on January 3rd, 2024, and the verification is dated January 30, 2024. Ma'am? Well. And you, that's your signature at the last page, verifying under oath that the statements in the document are true and correct?
It's my signature, yes.
Okay, and you understood that you were verifying under oath that the statements in that document were correct?
Yes.
Okay. And in that document as well, you said you had no emails related to this incident, this lawsuit, right?
I'm not sure if I said that in this document, but
Could you please look at pages 4 to 5? In fact, you say it 5 times. If memory serves, it's in bold.
okay.
And you never produced the email that you sent to your supervisor on February 26th in 2018 in this lawsuit, did you?
I don't have access to that email, sir.
My question to you is, did you ever produce that email?
I'm not sure I know what you're asking.
Did you ask, you had discovery obligations in this, did you ask Allied for a copy of the email that you are now testifying you couldn't access?
I wasn't in communication with Allied.
Okay, so let's talk about what you said on the email to your supervisor 2 days after the incident. If you look at page 1, it states that you were the daytime guard on duty at 8920 Wilshire Boulevard. You were on patrol, and I had, quote unquote, I had 2 cell phones, the work phone and also my personal phone. I had my cell phone to my ear. Do you see that language?
Okay.
Do you see the language?
I see it, yes.
And you wrote that 2 days after the incident?
I don't remember writing this, but if this is what you have, then...
Your Honor, I would ask that you read the whole sentence for completeness.
I don't have it in front of me, so I don't know that, but to the extent.
Well, that's the portion I intend to read. I mean, he's welcome to read whatever he wants to read.
Well, he's just reading half a sentence. It would be unfair for him.
Why don't you provide a copy?
Yes, Your Honor. Well, let me actually include the declaration that came with it of Allied.
Sorry.
Too much stuff.
What is y'all on a different time zone or something? Cause my court TV still say verdict, or it still say coming or whatever. It don't say that they here back. Y'all saying y'all already watching or what?
We're talking about the first paragraph.
It does appear to be a narrative, so if you want to read everything in context, that would be great.
Should I read it, or are you asking her to read it?
No, go ahead.
Okay. And just that sentence, Your Honor?
Just read it. Whatever it is, make sure it's just in context.
Okay, thank you. Again, the context is that you state in this that you are a daytime guard on duty at 8920 Wilshire Boulevard. Per usual, I was conducting a routine patrol of the building premises, and as part of that patrol, I checked the rooftop, all tenant levels, and parking garages. At approximately 13:30 hours, and just to clarify, that is 1:30, correct?
Yes.
I was finishing a patrol on the 5th floor of the building. In my hand, I had 2 cell phones, the AUS work phone, and I also had my personal cell phone. I held my cell phone to my ear, checking my voicemail because my mother is recovering from cancer and is in chemotherapy, so sometimes I don't get the calls and have to check the voicemails. Do you remember that?
I'm reading it with you, yes.
And are you telling me you have no recollection of this 2-page email detailing the event that you've sued over?
I remember writing an incident report and sending it over.
Well, do you recall also that you produced in this case your T-Mobile cell phone records, correct?
Yes.
And if I could, I believe that's something we can display because it is an exhibit.
Can you share, Your Honor, may I ask if we can share the exhibit number, please?
So why don't we, just to move things along, why don't we take our afternoon break now? Ladies and gentlemen, we're going to take an afternoon break. Since we have a couple things to discuss and I need to give the court reporter some time off, why don't we resume back at 3:15? In the meantime, please do not discuss the case with anyone, including other jurors. Don't form any opinions or do any research about the case. We will see you at 3:15.
The incident report, we saw that you wrote that you had your phone to your ear, correct?
Okay.
Is that correct, ma'am?
That's what it says on the paper, yes.
Yes. And if you look at that incident report at the very top, it says from Emani Ellis, Emani Ellis at gmail.com. That's your personal email account, right?
Yes.
Okay. And is doing incident reports a normal practice in the security guard business?
When something happens, yes.
In fact, you do daily activity reports as a security guard?
Yes.
So the reports are very important, right?
Yes.
And in the incident report, when you were reporting back to your supervisor, you said that you were checking your voicemail, right?
That's what the email says.
The email that bears your name, right? Reporting on the incident that you have sued over?
Okay.
Is that correct?
Yes.
Okay. If we could turn in the blue book to File Exhibit 200. You see it?
Yes.
And that's a letter from your lawyer to me.
Okay.
Is that correct, Ann?
Yes.
And if you go to the page that has a lot of blacked out entries, is it correct that that is a portion of your T-Mobile invoice, including for February 24, 2018?
Yes.
And you see that at 1:30, you received a call, and that lasted, what, 22 minutes?
Objection, Your Honor. The document does not say 1:30.
Well, maybe my glasses aren't, I need to get a new prescription. Do you see the entry? It's 1:10 p.m. for 22 minutes?
Yes.
Okay, that was a phone call that you received and talked on the phone for 22 minutes?
Yes.
Okay. And at 1:40, you made an 8-minute phone call?
Yes.
Okay. And whose phone number is that?
Which time are you referring to?
310-403-3656.
I'm sorry, can you say that again?
Yes, absolutely. I apologize. 310.
So apparently the verdict is in. We must know what that must gonna be, but I don't know. We still gotta wait to see. But it's still a 30-minute delay from the court time because they air it 30 minutes after. I didn't find that out till Cat Not Williams told me, but good to know. That way I could tell y'all that yeah, it's a 30-minute delay. So that's why it seems behind.
403-3656.
I don't know who the number belongs to, but it's probably a family member of mine.
Is that Nicholas Jackson's phone number?
Probably yes.
If you could go back. And you testified that you said when you saw Cardi B, you said something to the effect of, wow, that was Cardi B?
Something to the effect of that.
And at that point, as a security guard, you knew it would have been improper for you as a security guard to tell people that Cardi was a patient at a medical facility, correct?
I didn't tell anyone that I saw her.
Could you please answer the question, though? I can repeat it if you like.
Okay.
Isn't it true that as a security guard who had been trained, as you said, and worked for 4 years, you knew it would have been improper for you to tell people that Cardi B was a patient at a medical facility?
Objection, asked and answered.
It would be improper, but I did not tell anyone I saw her.
Move to strike everything after improper.
So ma'am, I just want you to answer the question, okay? Don't, if you can answer the question with a yes or no question, please answer yes or no.
Yes, Your Honor.
And you understood when you saw Cardi B that she thought that you were using your phone to tell people that she was at a medical facility, correct?
Yes.
And as I understand it, you denied that you used your cell phone to photograph or film Cardi B on that day. Is that correct?
That's not true. I didn't record her or film her.
The question was, is it correct that you deny using your personal cell phone to photograph or videotape Cardi B on February 24, 2018?
Yes.
Objection, vague and ambiguous.
Overruled.
And isn't it correct that you don't have that phone, right? You no longer have that phone. You disposed of it. You can't show us that phone and show that you don't have any photographs or videos of Cardi B. Isn't that correct?
Yes.
And rather than simply leaving, you stepped out of the elevator and told Cardi B to repeat what she said. Say it again. Isn't that what you did?
No.
Well, if you look at the incident report, quote, you see in the second paragraph, I stepped out of the elevator and asked her to repeat what she said to me, and so she did, angrily putting her finger in my face and yelling at me. Do you see that?
I stepped out of the elevator to clarify.
And you told her to say that again, right?
I don't remember saying say that again.
She stepped out of the elevator and said, clarify what you just said? Say that. I want you to clarify what you saying to me. I'm going to follow you all the way down. Fuck out of here. Fat girls need love too, Craig.
And your testimony was that you and Cardi B yelled at each other for 30 seconds?
She yelled at me. My voice was firm because I was upset.
Are you denying that you testified at your deposition and stated to Dr. McKenzie that you were yelling and cursing at Cardi B?
I'm not denying it. I just wanted to clarify.
And as you were yelling at Cardi B and people stepped out of her doctor's office, one of them stepped in between you to separate you two. Isn't that correct?
Yes, because she was in my face.
And the people came out of the woman's care doctor's office?
Joni Ford, thanks for joining, family. Look at her prepping up her lie.
Employees came out from the 5th floor. I would assume they were from women's care.
And the woman who stepped in between you came out of that office?
I believe it was her, yes.
just a hot
And
mess. Flush
you
of the Godz,
testified
good
in your
to see you.
deposition
Good
that
to
Cardi
see
B
you.
spit at you after the other people came out of the doctor's office. Isn't that correct?
She did.
Move to strike as non-responsive. And if
Why don't you clarify the question?
you testified at your deposition under oath, you said at that point that Cardi B spit at you after the other people came to intervene in the argument. Isn't that correct?
Yes.
And yet in the report, you state
The truth is, you are a liar.
I advised Cardi B that she needed to get her finger out of my face because I had not did anything to her. She then responded by spit at me. That's how it's spelled. And as a result, I became angry and yelled out to her to leave me alone and go on about her business. A few moments later, I remember a few people coming out and trying to separate us. That's what you said in your email, correct? 2 days after.
Correct.
And you stated in your incident report that Cardi B's nails were 3 inches long that day.
They were.
Your Honor, if we could ask for an admonition for the witness to answer the questions I'm asking.
Yeah, so please just focus on the question and answer the question that's asked.
Yes, Your Honor.
And the question is, you claimed in the incident report that Cardi's nails were 3 inches long that day. Isn't that true?
Yes.
And you testified at your deposition that Cardi pointed her fingernail at your face, right?
Yes.
And you state in your February 26, 2018 incident report, bear with me for a second. I'm sorry, I have a marked copy of this one and I didn't bring it with me. You state in your incident report that she scratched you on your nose, right?
Objection misstates the testimony of the witness.
Well, it's contrary to the, sorry, Your Honor.
What up, Joni Ford? Says she gonna come watch the verdict with the fam. Hey, appreciate that, family. Y'all hit that like, hit that subscribe, tap in, share with a friend, you dig?
You testified in this trial, that Cardi B cut your cheek. Yet you stated in your email to your supervisor on February 26, 2018, that Cardi B cut you on the nose. Isn't that true?
Objection misstates the testimony.
She put her finger in my face.
Okay, first of all, you have testified here today under oath that Cardi B, 7 years later, that Cardi B cut your cheek, your left cheek. Isn't that true?
Yes.
And you state in your report 2 days after the incident that she scratched your nose. Quote unquote, third paragraph. At this time, she continued to yell at me and point her 3-inch acrylic fingernails into my face, scratching my nose. You see that?
Yes, but into my face.
Move to strike out everything after yes.
Over. Motion's denied.
And you were clear at your deposition that you had changed the story to Cardi supposedly cutting your cheek, not her nose, right?
No.
You specifically testified to that, didn't you?
I'm not sure I know what you're asking.
At your deposition, you specifically testified that you were not scratched on your nose that day, you were scratched on your cheek.
She touched my nose, but she scratched my cheek.
Okay, but in the incident report, you state scratching my nose, right? You have to answer audibly.
Yes, I'm sorry.
And in fact, you demonstrated at the deposition how Cardi B supposedly was nose to nose with you, but jabbed your cheek. Is that true?
Yes.
And if we could show that. This is a video of the deposition where she plaintiff demonstrates how to supposedly scratch onto his cheek. That's the deposition video. We may have to come back to that.
Just you have to identify by page and line.
Well, we'll have to come back to that because I don't have that. I have the deposition video. Actually, well, I don't want to hold things up. We'll do that a little bit later. And you admitted at your deposition that there is no scar on your nose, right?
I'm not sure.
Well, we can play that back for you if you like. But did you testify at your deposition that there is no scar on your nose?
I'm not sure.
We're working on that. And in your response, your verified response to the written discovery that was served on you in this case, and specifically the special interrogatory, interrogatories number 1, 3, 5, 7, 9, 11, 14, 25, 26, 27, and 28, that Cardi beat you about the head, face, and body. Isn't that what you did?
I'm objecting because I don't have the number of special rog he's talking about, the set and the date.
I haven't used it yet.
What he's asking her about, I want to know what he's talking about.
Why don't you break it down?
I'm sorry, Your Honor?
Why don't you break it down to the specifics?
Sure.
Interrogatory.
Well, in light of counsel's objection, I can show the witness.
It might be faster if you just read the interrogatory and the response.
Bear with me for a second. And for counsel, it's plaintiff's responses to defendant Cardi B's special interrogatory, set number 1.
Is that dated 2022?
Yes, sir.
August 9, 22?
May I answer? Some judges don't like counsel talking to each other. Okay, yes. Counsel, it is. The verification under oath is dated August 9, 2022.
Thank you.
And if I can direct you to interrogatory number 1 at page 4. And
okay, I see some action. I got the sound on, so we'll hear it as soon as they start moving, but they not moving yet. But it look like we got action, family.
Bruh.
sorry, it's a long one. I'm trying to.
The jury. Question for counsel, just in the interest of saving the time to read the verdict. Can the clerk only read the call to the question? For example, for number 1, did plaintiff Emani Ellis prove all the following elements of battery in yes or no, rather than reading the entirety?
That's fine with us, Your Honor.
I would like the entirety, I'm sorry.
Any particular reason? It's not going to change the answer.
Well, I feel like she verdict form was not
Okay.
the right type of form.
Okay. No, rather, of saving the time to read the verdict. Can the clerk only read the call to the question? For example, for number 1, did plaintiff Emani Ellis prove all the following elements of battery in yes or no, rather than reading the entirety?
That's fine with us, Your Honor.
I would like the entirety, I'm sorry.
Any particular reason? It's not going to change the answer.
Well, I feel like the verdict form was not
Okay.
very
Okay. Do we have a foreperson, number 3? And have you reached a verdict?
Yes.
Can you hand the verdict to the clerk, please?
Last minute's to vote, family. Last minute's to vote. Hit the vote before they read the verdict. What you saying? Guilty, not guilty, or I don't know. About to end the poll as soon as they read it, so this your last opportunity. We got 5% say guilty, 82% say not guilty, and 14% say I don't know.
All right, can the clerk please read the verdict?
Superior Court of the State of California for the County of Los Angeles, Emani Ellis, plaintiff, versus Godz, Marlenes Almanzar, Cardi B, dose 1 through 50, inclusive defendant. Case number 20 STCV 07031. Verdict. We, the jury, in the above entitled case, answer the questions submitted to us as follows. Section A, assault and battery. Question 1. Did plaintiff Emani Ellis prove all of the following elements of battery? 1. Defendant Godz Marlenes Almanzar, Ms. Almanzar, touched Ms. Ellis in the intent to harm or offend Ms. Ellis. Number 2. Ms. Ellis did not consent to being touched. Number 3. Ms. Ellis was harmed or offended by Ms. Almanzar's conduct. And 4. A reasonable person in Ms. Ellis' situation would have been offended by the touching. Answer, no. Question 2. Did Ms. Ellis prove all of the following elements of assault? Number 1, Ms. Almanzar acted with the intent to cause harmful or offensive contact with Ms. Ellis. Number 2, Ms. Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner. Number 3, Ms. Ellis did not consent to Ms. Almanzar's conduct. Number 4, Ms. Ellis was harmed. And number 5, Ms. Almanzar's conduct was a substantial factor in causing Ms. Ellis's harm. Answer, no. Section B, intentional infliction of emotional distress. Question 5. Did Ms. Ellis prove all of the following elements of intentional infliction of emotional distress? 1. Ms. Almanzar engaged in extreme and outrageous conduct beyond mere insults, threats, indignities, annoyances, hurt feelings, or other trivialities that a reasonable person is expected to endure. 2. Ms. Almanzar intended to cause Ms. Ellis emotional distress.
Drop them W's in the chat for Cardi.
Number 3, Ms. Ellis suffered severe emotional distress. And number 4, Ms. Almanzar's extreme and outrageous conduct was a substantial factor in causing Ms. Ellis to suffer severe emotional distress. Answer, no. Section C, negligence and contributory negligence. Number 8, did Ms. Ellis prove all of the following elements of negligence? Number 1, Ms. Almanzar was negligent. Number 2, Ms. Almanzar's negligence caused Ms. Ellis to suffer physical harm rather than only emotional distress. And 3, Ms. Almanzar's negligence was a substantial factor in causing Ms. Ellis's harm. Answer, no. Section D, punitive damages. Question 12, did you answer question 4 and 7? Answer, no. Signed this date, September 2nd, 2025, by foreperson George Uloa, number 3.
All right, does anyone wish to pull the jury?
No, Your Honor.
Yes, Your Honor.
All right, let me ask the foreman, was it unanimous as to all the questions?
Yes.
All right, so the question that the clerk is going to be asking is, was it unanimous as to all questions?
Question 1.
Or just all questions?
As to all questions?
Was it unanimous?
Was it unanimous?
Yes.
And then go through each of the jurors. Was it unanimous?
Was it unanimous, juror number 1? Yes. Number 2?
Yes.
Number 3?
Yes.
Number 4?
Yes.
Number 5?
Yes.
Number 6?
Yes.
Number 7?
Yes.
Number 8?
Yes.
Number 9?
Yes.
Number 10?
Yes.
11?
Yes.
And 12.
Yes.
All right, sounds like it was a unanimous verdict as to all questions. Can the clerk please record the verdict?
The verdict has been recorded, Your Honor.
All right, thank you. Ladies and gentlemen, thank you for your time and dedication to this case. I know that you've paid a great deal of attention throughout the matter, which was especially evidenced by the questions that you did submit. I want to thank you for that time and attention on behalf of myself, the parties, the court system, as well as the people of California. As I indicated before, this system does not work unless people like you are able and willing to serve, and so I want to thank you once again. Throughout the trial, I have admonished you that you could not discuss the case with anyone, including other jurors, and at this point in time, I am relieving you from the admonition. You can speak with anyone about the case from this time forward. I suspect that there's going to be not only the parties that will want to speak with you, but I suspect also the members of the press are going to want to speak with you. And so I'm going to tell you this, I'm telling the members of the media this, and I'm telling the parties and their assistants that it's up to you whether or not you want to speak with anyone. If you don't want to speak with anyone, then you can just head right out the double doors, out the elevators. If there's press outside that want to speak with you, you can just walk past them. Don't let them stop you. If you do want to speak with them, then go ahead and you can wait outside the double doors. We're not going to be speaking with anyone in the courtroom. And if you do speak with someone, please be respectful of the views of any of your other jurors in terms of the deliberations. You can speak with respect to your point of view and how you saw the case. And the other admonition or the other issue with respect to speaking with people is that it's got to be at a reasonable time and place. And so if people start bothering you, or if people reach out to you that's inconvenient for you and they continue to do so, let me know and I'll take care of it, okay? All right. All right, with that, once again, I want to thank you. You are now dismissed.
The absence of evidence is not the evidence of absence.
What?
Well, family. Cardi B is free. I mean, not that it was jail time, but she free from that 24 million or so they was trying to hit with. I don't know what happened to my mouth, man. It's tripping. Oh wait, hold on. Did I get it? Oh no, never mind. I don't know what's happening. But anyway, appreciate y'all, family. Shout out to today's stream sponsors, and let me add Ressa up there. Is that Ressa or Risa? $1.99 for the Love Your Channel. Appreciate you, family. Appreciate the support. Let me add you on up here to the stream sponsor list. As I'm saying my outro, appreciate y'all. Much love. Pause. Thank you for the support, Rissa. I love it here too. Yeah, shout out to Cat Knot Williams, Joni Ford, Tia C, Ali, Chan My Black is Golden. Let me see. Ressa, I might have to add you to the next stream, man. I don't know. I'm closing out. No, I'm just playing. I think I got you. Hold on, let me see. All right, it's a different font, but I got you. Ressa. Boom. Okay. So boom. Oh, it's behind me. Okay. So what the heck, Bobby? There we go. So boom. Shout out to Ressa. Appreciate you for the 2. Shout out to Ali, Cat Knot Williams, Tia C, Joni Ford. Appreciate all y'all. Shout out to everybody in the chat holding it down. Shout out to all the new subscribers. Much love. We almost at that 3,500, which means we almost at that 4K. So keep on hitting that subscribe. Keep on sharing. Keep on helping us rise up in this algorithm. it's a constant battle with me, man. You know, they don't really like the content I post, and plus I kind of ride real close to that edge, and sometimes I cross it a little bit, and it definitely damages my channel when I do it, so I gotta be more careful with that. But other than that, man, Cardi B is free. That's the verdict. I gotta get up out of here. I gotta go to the cookie shop. The cookie shop is calling me. I'm short, I'm dry. I did this whole stream sober. I didn't smoke one blunt this whole stream. I think that's a first. Y'all clap it up for me. Outside of that, man, y'all stay fresh and stay blessed, man. Have a great night. Tell everybody I said what up. Tell everybody Cardi B free. She didn't have to pay the money. And other than that, y'all stay fresh and stay blessed. Much love, family. Y'all love the channel. We love y'all too. Factual Lie, what up though? Oh yeah, hold on. I didn't say my good nights yet. Shout out to Trakisha. Appreciate you, Trakisha. Hanging out with us. Mary W. Appreciate you. Joni Ford. Miss D56. Mara O'Shea. Cat Knot Williams in the building. Shout out to the Cat Knot Williams raid. Appreciate y'all who came through. Shout out to Shay. Appreciate you. Ressa, new one. Appreciate you. Love your channel. Appreciate the support. Trakisha, Aaron Adventuring. Hey, shout out to Aaron Adventuring. Always holding it down. Much love, much love. Tammy Lewis. Much love, much love. Appreciate you joining. Lady L. Chan My Black is Golden. Cha Diggy. Appreciate y'all joining. Late Night Baking with Mookie Mookie. Appreciate you, family. Brown Sugar Babe. Brown Sugar Babe. I get high off the love. Don't know how to behave. Kissing Pink in the building. Shout out to Kissing Pink. Appreciate you, family. Cat Knot Williams, let's see, a couple new faces. Miss W, Daniel Berry Sports Highlights. All right, man, I gotta go to this cookie shop, man. I think that's all I see right now. I'm seeing doubles now. Appreciate all the sponsorship. Appreciate all the love. Like I said, if they return that whatever y'all donated, please let me know, cause I need to figure that out. But other than that, y'all make sure y'all stay fresh and stay blessed, family. And have a good motherfucking night.
Have a good night. Have a good night. Have a motherfucking good ass night.
Oops. Oh, wait a minute. I can check for anybody live. Let me see. Hold on. We ain't out of here yet. Let me check the check if anybody live, so we could pass this on through. I was going to this one, but I don't need that anymore. Nah, don't look like I see nothing. All right, we out, family. That was it. Appreciate you. Much love. Stay fresh. Stay blessed. Peace easy.